Good morning, everybody. Welcome back. Getting ready for day 3. Almost done with the first week already in Commonwealth versus Karen Reed. So, I was a little critical of the defense yesterday, and of course, you all know I don't have bad intentions. I'm not trying to aggrandize myself or anything. I just have concerns because we watched this trial the first time. We saw how it unfolded. And I don't want to see them just run back the same thing they did the first time that wasn't successful. But I will also point this out. We are in the Commonwealth's case. And so the Commonwealth should already have moved the ball forward. I mean, this is your opportunity to be presenting your theory. And I don't see that the Commonwealth has really delivered on its commitments that it made in the opening statements. Because what we heard was that the Commonwealth has facts, science, and data on their side. Those are going to prove beyond any reasonable doubt that Karen Reed killed John O'Keefe. And we haven't heard a single bit of that yet. We heard that the backup was that's going to be corroborated by Karen Reed's statements, right? I hit him. But we've had one witness who says she says that, and that witness was pretty big problem. Pretty big problems with credibility with poor old Mr. Nuttall. He really is, in my mind, he's a true believer. He's a true believer. I don't think he's badly intentioned, but boy, do I think he has confabulated like a champ. And so that's what makes him valuable as a mouthpiece for the Commonwealth theory. He really, truly believes in it. So I just want to give you some assurance that for all that I haven't been like bending over to pat the defense on the back. Certainly they've done some things well. Thought they had a great opening. They showed the problems with Mr. Nuttall's testimony. My criticisms have largely been cautionary. It's not because they aren't doing what needs to be done necessarily at this point in time. I'm just concerned about how that could unfold as this trial continues, if they continue on this path that they're on. But the bottom line is the Commonwealth should be ahead by now. They should be ahead. You normally start your case with something that's going to catch the jury's attention. It's the whole principle, primacy and recency. Every attorney learns it pretty early on if you're doing trial work. The things that people tend to remember, the first thing they hear and the last thing they hear. So the whole stuff in the middle, it just kind of runs together. It's one of the arguments in favor of doing a very short and very targeted cross-examination. Makes it more memorable. But we haven't seen that. We haven't seen that from the Commonwealth, have we, Timothy Nuttall? I mean, if the doctrine of primacy and recency is at play here, then the first thing that the jurors are going to remember is that witness the Commonwealth put on completely fell apart. Just can't be relied on at all. Didn't learn from the first time that your vivid memory of John being in a puffer coat that you had a hard time taking off of his cold, stiff fingers didn't happen. You didn't learn that the first time. So you had to have a second vivid memory of exactly how and when Karen said, I hit him. That didn't happen either. So that's what the jury's remembered at this point. And through the witnesses that we've had so far, Timothy Nuttall, Kerry Roberts, Peggy O'Keefe, Nicholas Guarino, and Derek Whitley. 5 witnesses. Nobody's brought facts, science, and data to show that Karen Reed has killed John O'Keefe with her car. So they're not moving the ball forward on their case. And that's frankly a win for the defense. If they're keeping the score even, if it's still competitive at this point, they're not starting to get pushed into defensive ground. That's a win for the defense because the Commonwealth has had 2 days to move the ball forward with their best stuff. And this is what we've gotten. So I made a comment yesterday because we were talking about this kind of evolution with the challenge to the ARCCA witnesses and how Judge Cannoni is handling it, and this, bringing up of the ABA guidelines for document retention, which is just so bizarre, so bizarre. And I said, this is a tell, guys. This is a tell that she's looking for a reason to exclude ARCCA. She's just looking for a justification to do it. And so then lo and behold, yesterday, what comes out? We get the order that she signed that is directing ARCCA to produce certain records. I'm going to go ahead and take a look at this because I kind of tend to think this is substantiating that perspective. Here's what she's ordered them to produce. All records within ARCCA or its owners, partners, employees, or representatives' possession. Okay, ARCCA's representatives are ARCCA's lawyers. In all of their possession, custody, or control in whatever format kept that reflect or in any way relate to work performed or contemplated and related in any way to billing, payment, compensation, and or reimbursement of any kind in connection with Commonwealth versus Karen Reed 2282 CR 00117. Such records must be produced to the Norfolk Superior Court by April 25th, 2025 at 9 a.m. That's tomorrow. Tomorrow at 9 a.m. Right? Because that's when they were going to have that's when they were going to originally have the voir dire. Maybe we'll hear more about this this morning as far as logistics and what's going to happen. But yesterday we had Elizabeth Little tell us can't happen tomorrow. They've got a conflict. They've got a scheduling conflict. Can it be Monday? Judge Cannoni says it can be Monday, but if it's going to be Monday, they have to have all their testing done. So why they have to have all their testing done if they're going to be questioned on Monday, but they could be questioned on Friday and not have all of their testing done is not entirely clear to me. She hadn't previously established a Monday deadline for them to have any kind of testing done. So it seems to just be a little bit retaliatory. You know, if I'm going to give you something, I'm going to take something away too. Just continues to be a little bit alarming. But then she spells out and clarifies exactly what this order covers, and it includes by way of example but not limitation. This is extremely broad language. All correspondence via regular mail, email, text messages, and or encoded messages between the above entities and individuals and any third parties. This order includes all reports and or draft reports, as well as all test results, photographs, video or audio recordings, charts, graphs, and calculations, and reported observations of all tests or experiments undertaken, whether the results were included in a report or not, and all internal memoranda and phone records related to communication about work performed on the case. The order also includes all records related to time spent on the case, including timesheets and draft and final bills. To the extent that any record responsive to this order is kept in an electronic format, the ARCCA witnesses shall bring with them the appropriate hardware equipped with the appropriate software to allow the court to access all such records at the voir dire hearing. Here's the problem, guys. We've been hearing over and over and over again that a substantial amount of what the crash daddies have done in this case, they can't disclose it. It's federal work product. They aren't at liberty to disclose it. It's up to the federal government to disclose it. They have TUI regulations that they go through. So the federal government has disclosed what they're going to disclose when it comes to ARCCA. So if this order encompasses work that they did for the feds, how are they supposed to comply? How are they supposed to comply? So the only limitation that is going to give them some leeway here is this one right here: reimbursement of any kind in connection with Commonwealth versus Karen Reed. If this order in the production that she's requiring is limited in scope to what they did for Alan Jackson and David Yenetti and Elizabeth Little and Robert Alessi, just for this case, then they can comply. But if this relates to work they did that they used in their testimony in this case, that's federal stuff. That's federal protected stuff. And I don't know that they can comply with that. So I already know what's going to happen here. What's going to happen is ARCCA is going to produce what they have with respect to when we were subpoenaed for trial, like after, as soon as we started having any kind of communications with the defense team about testifying in Commonwealth versus Karen Reed, and subsequent to them being them testifying and being retained by the defense, they're going to produce all that, and they're going to say the work we did in preparation for that. I mean, it wasn't in preparation for that. It was work they did on a different retainer for a different purpose, for an FBI investigation, not for Commonwealth versus Karen Reed. Commonwealth versus Karen Reed doesn't come into the equation until they find out they're going to be called as witnesses in that case. That's going to be how the defense is going to have to toe this line, because that's all ARCCA is going to be able to produce. You can't produce federal stuff. And then we're going to have to wait and see. Who was giving us a really obnoxious loud beep on the live stream? That would have been Court TV. I think we're going to ignore Court TV today. Go back to NBC 10. So it's going to be up to Bev once again to decide, is that what she actually meant when she wrote this order, or did she contemplate something more broad? Does she want it? Does she want it all? I don't know what's going to happen. I think there is just enough wiggle room in this order for the defense to be able to say this is crafted to accommodate ARCCA's limitations with respect to the FBI investigation, because when they were working for the feds, they weren't working on Commonwealth versus Karen Reed. They were working on their own independent investigation of who we don't know, for what we don't know that either. That's the prerogative of the federal investigators to keep that to themselves. But we know when they started doing stuff in connection with Commonwealth versus Karen Reed, and that's the moment they got contacted, they find out we're going to potentially be witnesses in this case. That's going to be how the defense is going to thread the needle. I think they got a good argument here, despite the very, very broad language that is a little bit alarming on its face. That limitation right there in connection with Commonwealth versus Karen Reed, that's going to give them what they need to narrow the scope and say the stuff that they're not allowed to produce under the terms of their federal retainer, that is not covered by this order. So not producing it will not be a violation of this order, and not producing it will therefore not justify a sanction against ARCCA for not excluding it. So I think it's pretty clear at this point that the pressure is really on. They got to finish their testing, or it's going to be excluded. And she pretty much said that. She didn't say the quiet part. She didn't say the or else part. But she said, if we're doing this voir dire on Monday, they better have their testing done. There's an implied or else there. Or else, defense, you may not get to use your ARCCA witnesses. I'm going to go ahead and pull up the NBC 10 over here, although so far we are just looking at the fan, but I'll take it off. Take it off the fan. And she did promise us that we're going to get started on time this morning, didn't she? We'll see if that holds up. We're already a couple minutes late, but can't be too picky. Can't be too picky. So when we left off yesterday, we were kind of in the middle of Daniel Whitley's cross-examination, and it's not clear if the defense is going to be coming back to him or not. They had gotten, it looks like we're getting started now. So let's get it unmuted.
Please proceed in court.
Screen.
22117 Commonwealth versus Karen Reed.
All right, so I was told counsel wanted to see me.
Of course they do.
Good morning, Your Honor. Yes,
Good morning.
I just have one brief issue I want to raise for the court.
Okay.
I wanted to confirm whether experts in this case are permitted to watch testimony in order to prepare for rebuttal. We've asked for that.
For rebuttal, like post,
Responding,
for responding, okay,
in our case in chief, for both sides.
okay. What's your position? Ms. Little, you want to?
Yes, we could.
All right. Mr. Brennan, is there any reason not to?
I need to give it some thought. I'm not
You need
willing
to give
agree.
thought
I'll
to
abide by whatever the
sequestration?
court thinks is fair.
So why don't you think about it? We'll address it later today. Okay, there's no expert testimony today, right?
It's not.
Okay,
Thank you, Your Honor.
all right, sure. Is that it? Ready to bring the jury in?
That's all.
You need to
wanted a
think about
ruling
it.
on the clip from yesterday?
I did.
All right, you can play it.
Thank you.
All right,
I think she
so
let him.
we'll take a quick break.
That was our early start. Not so much for the jury, but for the parties. What do you need to think about? You knew they brought this up weeks ago that experts are normally exempt from the sequestration order. They get to watch each other's testimony so that they can respond to it. It's just part of being helpful for the jury. They get to stay kind of on pace with everybody else. And since they're not fact witnesses, they're not there to talk about what happened or didn't happen. They're there to offer opinions based on other information. They don't have the same risk of the fact witnesses of, the truth is going to get distorted because people are going to start changing their stories once they hear what the other witnesses have testified to. Experts don't have that same problem. They brought this up weeks ago. And remember, Judge Cannoni, the defense had said, we just, sort of assume this is routine. This is normal, which it is. And Judge Cannoni says something to the effect of, you shouldn't make any assumptions. You shouldn't assume. You shouldn't assume. Yeah, that's right. In this court, you should assume nothing. You should assume nothing. You should CYA and you should make your record every single time in this court. Assume nothing. But this has been out there for weeks, and now he needs to think about it. Ridiculous. So they'll decide later. No expert testimony today, and that's really the only hint we have. Okay, we're getting more fact witnesses today. We don't know if there's more that the defense needs to do with Mr. Whitley. They were in the middle of cross-examination. They went to sidebar. My notes are a little bit out of hand here. So they were talking about whether they were like in the middle of kind of reciting the conversation. She was on the phone with Mr. O'Keefe, and Mr. Whitley overheard it. They're in the back of the ambulance, and the defense is trying to elicit that conversation. There's an objection. They go to sidebar, and that's kind of where things ended. So seemed like it's a hearsay type of objection. Seemed like the defense is going to be arguing it's not for the truth. It's for her state of mind, but we don't have a ruling. And the defense hasn't done the thing that I keep saying. This is like non-negotiable for me. Every single first responder at the scene needs to be asked, did Kerry Roberts give you the phone? Because we need to know which one of you.
Hear ye. All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court, now holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
22-117, the Commonwealth versus Karen Reed.
All right, good morning again, counsel. Good morning, Ms. Reed. Good morning, jurors.
Good morning, jurors.
I have to ask you those same three questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we were here yesterday? Yes. Everyone said yes and nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? No. Everyone said no or should be. Thank you very much. Can we bring Mr. Whitley back in, please?
So we are going to continue with
Christina,
Mr.
you can step
Whitley.
up to the podium.
Thank you very much, Your Honor.
Did Ms. Roberts give you the phone, Mr. Whitley? Every single one of them. Every single one of them needs to be asked.
Sir, I'll remind you, you're still under oath. Thank you.
Can I proceed?
Yes.
Mr. Whitley, yesterday you testified that when Karen Reed was brought to the hospital, she didn't want to get into a hospital Johnny and she didn't want to give a urine sample. Do you recall that testimony?
I do.
It was clear to you that her reluctance to cooperate at that time was because she very much wanted to check on John's progress and status at the hospital, correct?
No, I don't believe that to be the case.
Well, you testified before the grand jury regarding this matter 3 years ago, didn't you?
I don't believe I said that she was
I
reluctant.
didn't ask you that question. You testified before the grand jury 3 years ago, didn't you?
I testified before the grand jury 3 years ago.
You were under oath then, as you're under oath today, correct?
Correct.
You swore to tell the truth.
I am telling the truth.
You swore to tell the truth in 2022 before the grand jury, did you not?
I did.
Getting
That was
shifty
less
and
than
nervous.
3 months after you brought Karen Reed to the hospital, didn't you?
Yeah.
And your memory of what happened at the hospital was very good in April of 2022, right?
As good as today.
Your memory in April of 2022 was very good, wasn't it?
It was very good as it is today.
Okay, so you want to add the as it is today, despite the fact that you weren't asked that question. Is that right?
Objection.
Sustained.
All right. When questioned by Mr. Lally at the grand jury, you were asked the following question. So what, if any, interaction did you have with her, meaning Ms. Reed, at the hospital once you were there? You remember that question, right?
I do.
And your answer was, so we, after that, I helped escort her down to, they call it the psych hallway, where they have rooms set up for psychiatric patients for their evaluation. And then she was unhappy that she wasn't able to see him, meaning John. And she kept trying to. She didn't want to get into a hospital Johnny. She didn't want to, I believe, give a urine sample. She was not, the nurses were asking her to do certain things that every patient has to do, and she was not cooperating with them. Do you remember that answer?
I do.
So 3 years ago, when you testified about this issue,
Leave it there. Don't argue with them about it.
you testified under oath that you believed that she didn't want to give a urine sample, correct?
Correct.
Yesterday, 3 years later, you testified with certainty that she didn't want to give them, right?
Yeah, she was giving them a hard time about having to give a urine sample.
Right. No, I'm asking you about your testimony yesterday in contrast to the grand jury, sir. To the extent that I ask yes or no questions, I'd like yes or no answers.
So no instructions to the witness, Mr.
You
Yenetti.
want
Ask
the
a
witness be
question.
instructed to answer the question yes or no if it calls for a yes or no question. Answer.
Answer the question that's asked of you, okay?
Okay.
So go ahead, ask a question.
You testified yesterday that she didn't want to give a urine sample without saying it was your belief that she didn't want to give one, correct?
Correct.
In any case, were you aware that when she was asked to give a urine sample, that Ms. Reed had gotten her period and did not have a tampon?
I was aware she was on her period, yes.
You're also aware that when somebody is brought to the hospital for a Section 12, they have no privacy. Isn't that right?
They have medical privacy. Either the tech or the nurse would be with the patient at all times.
Okay. With them at all times, observing them at all times, correct?
So they wouldn't be, she wasn't in like a hallway open to the public.
Understood, sir. But she also, when I said privacy, what I was asking is she was not allowed to go to the bathroom alone to give a urine sample, correct?
She was a psychiatric patient.
Right. So she would have to use the bathroom in front of hospital personnel or some medical personnel with people watching her while she was on her period with no tampon, correct?
I would understand that to be true.
All right. And you're aware that she did cooperate and eventually give a blood sample as well, correct?
I'm not aware of a blood sample, but urine sample, yes.
She did give the urine sample.
Correct.
Now, in your testimony yesterday, you discussed the topic of your memory of what Karen Reed may have asked you about John surviving in the snow with light clothing. You remember those questions?
I remember asking about not having a jacket, correct?
Now, starting at the end of the day, when I cross-examined you yesterday, I asked you about that topic and I said to you, you mentioned something about hypothermia, that you assumed you may have been dealing with a hypothermia situation. And your answer was, well, she said that he had been out in the snow without a jacket for many hours, correct?
Correct.
But before I cross-examined you at the end of the day yesterday, you previously testified 3 times about this topic, correct?
I believe it would be the grand jury and the previous trial.
Right.
Thanks for saying that.
Direct examination when Mr. Brennan was asking you questions before I stood up, correct?
Okay, yes.
Let's start with the first time you testified about this topic back in 2022. That was, again, less than 3 months after you had a conversation with Ms. Reed at the scene on January 29th, correct?
Correct.
Her statements and questions to you at the scene were fresh in your mind in April of 2022, correct?
Correct.
In April of 2022, before the grand jury, Mr. Lally asked you, quote, what, if any, questions did she ask you regarding hypothermia? Do you remember that question?
I do.
Your answer was, She was just wondering if he could have survived outside in the cold even though he didn't have a jacket on. Do you remember giving that answer?
I do.
Nowhere in that answer in 2022, less than 3 months after these events, do you attribute the words, quote, many hours, end quote, in the snow to Ms. Reed, correct?
Yes, I was not.
I'm not asking for an explanation, sir. I'm asking for an answer.
All right, so he was answering you, Mr.
My
Yenetti.
question called for a yes or no answer. Nowhere in your answer in 2022 do you attribute the words many hours in the snow to Ms. Reed, yes or no?
No, I did not say that at that point.
Nowhere in your answer in 2022 do you testify that Ms. Reed told you he had actually been in the snow for many hours, correct?
She did.
Sir, I'm asking you about your testimony.
I object.
So let him answer the question.
Let me ask it again. Nowhere in your answer in 2022 did you testify that Ms. Reed told you he had actually been in the snow for many hours, correct?
In 2022, I testified that I was just told to be brief and give generalizations. She quantified many hours in the snow when we were back at the end.
Let me try this again, sir.
So, Mr. Yenetti, you're just saying 2022. Get to a date and a place.
Yes, April of 2022, okay, before the grand jury. My question again, and I'm still seeking a yes or no answer from you, okay? Nowhere in your answer in April of 2022, before the grand jury, did you testify under oath that Ms. Reed told you that John had actually been in the snow for many hours, correct?
Objection.
Not in
That's the answer.
2022 of April, no.
Okay.
You did already
The
say
next
that.
time you testified under oath was last year in 2024, correct?
Correct.
During that testimony, Mr. Lally asked you, oh, by the way, so 2022 is no mention of many hours, right?
I did not, and I was told to be brief on the grand jury stand.
But again, no mention of
Right.
many hours in 2022. Okay. Now, 2024, last year, Mr. Lally asked you, so firefighter Whitley, at some point, specific to your conversations with the defendant, Ms. Reed, can you describe sort of her demeanor or any observations you made in relation to that as you were speaking with her? And your answer was yes. She was very upset. She kept asking if there was any chance. She kept asking us if we knew if the person ambulance 1 had transported was alive or dead, and we could not speak to that. She asked if somebody could be alive in the snow without a jacket for many hours, correct?
Correct.
So 2022, there was no mention of many hours. 2024, over time, now that's the first time that you mention the words many hours in your testimony regarding this case, correct?
Correct.
Right? And when you testified last year, you testified still that she was asking you a question about surviving in the snow, correct?
Correct.
So then we come to yesterday on direct examination. Do you recall that Mr. Brennan yesterday asked you, before you left, were you having any conversations with the defendant? And you answered yes. Recall that yesterday?
Is that at the hospital?
I'm asking you yesterday, do you recall Mr. Brennan asking you before you left essentially the scene, were you having any conversations with the defendant? And your answer was yes.
You're talking about Lee, I'm just trying to make sure we're talking about the same instance. Are we talking about when we left the hospital or when we left Fairview Road?
When you were at Fairview Road, leaving Fairview Road, we're talking about the same subject of what Ms. Reed supposedly told you or asked you. Okay, Mr. Brennan went into that with you.
So on the way to, you're talking on the way to the hospital in terms of left, when we left.
Well, before you left, he meant before you left the scene.
Okay, no, I'm just trying to clarify.
Again, the same conversation, Mr. Whitley. I'm not
So,
trying to trick you.
Mr. Yenetti, he just asked for a point of reference. It's clear. Now go.
Understood. And Mr. Brennan said, can you share with the jury what those conversations were about? And your answer was, so we were talking, she was upset. She kept asking if there was any chance her husband could be alive, even sitting outside in the snow without any coat for many hours. Do you recall that answer that you gave yesterday on direct examination?
Yes.
And that was the first time that you mentioned that she said, supposedly, or asked supposedly, about him sitting outside in the snow, correct?
I was just using phrases generally speaking.
Not my question.
I wasn't at that point I was paraphrasing. I was not speaking verbatim to what she said.
Let's try that again. That was the first time that you mentioned that she claimed or asked that he was sitting outside, correct?
It could have been sitting, laying, being.
Let's try it a third time.
So
Was that-
just ask the question, not let's try it,
Sure.
let's try it.
Was that the first time that you testified under oath that Ms. Reed said or asked about him sitting outside?
Are you asking me to clarify whether she used the
I'm not
word
asking you
sitting?
to clarify anything. I'm asking you whether that was the first time yesterday during direct examination that you mentioned that you asked about him sitting outside.
I'm sorry. I am very confused because I'm trying to figure out if he was being outside, sitting outside.
I'm asking about Ms. Reed's statements, sir. That's all I've been asking you about. Her
Okay.
statements to you and your testimony about her statements to you. Was yesterday on direct examination the first time that you testified under oath that Ms. Reed mentions the words sitting outside?
I don't know.
All right.
I'm just using, she might have said laying outside, being outside, outside.
Okay, so when you testified yesterday before this jury
Yes.
that she mentioned the words sitting outside, you're now saying that that might not have been accurate, correct?
It could have been a different word.
Okay, but you didn't say it could have been a different word yesterday. You just left it as sitting outside, correct?
Yeah, that's
Okay.
what I said, sitting.
All right, so now we get from, the grand jury with many hours mentioned to questions about many hours to sitting outside to let's talk about what you said on cross-examination.
I object.
Okay, the objection sustained.
Sure. On cross-examination, your words were, she said he had been out in the snow without a jacket on for many hours, correct?
She had asked if he had been outside, if there was any chance he could be alive, even though he was outside without a jacket for many hours.
So it always was a question, correct?
It was a question.
She never said what you said on cross-examination yesterday, which was she said that he had been out in the snow without a jacket on for many hours. That was not a declarative statement by Ms. Reed, correct?
Objection.
I'll allow that. Was that a declarative statement by Ms. Reed?
She asked if he could be alive without a jacket in the snow for many hours.
So again, it was a question, sir.
She asked me, and we were just trying to give her hope in terms of telling stories of hypothermic patients that could survive outside in the snow.
Okay, is there any redirect?
The phone,
Okay,
the phone, the phone, the phone. The phone.
When you were called to the grand jury, was the testimony as in-depth and as long as it is in front of this jury?
No, not even close.
When you're recounting your memories of what happened, do you memorize word for word what you've said in the past?
Objection.
as to that form, it's sustained.
When you're recounting the past, do you record your statements personally?
Objection.
I'm going to let that one. Do you record your statements?
No.
Next question.
When you testified in the grand jury, page 90, line 15, and you said the defendant told you, I'm upset if he dies, I want to die. And then you later testify last year, and you said, if my husband dies, I want to die. Do you notice the little differences between those phrases?
I do.
Is that you making up words?
No.
Is that you trying to help a case?
Objection.
As to form, that's sustained.
Are you inventing facts?
No.
Sir, when you were recounting what happened that day, are you using your best memory?
Objection.
Sustained.
When you were asked by the defendant about how long, or someone out in the snow without a jacket for many hours, do you remember that conversation with her?
I do.
Where were you during that conversation?
We were in the back of the ambulance.
Do you remember it distinctly?
I remember it distinctly. She was
Vividly?
looking at me.
When you tried to give her hope and comfort, and you told her stories about other situations where people, maybe children, have fallen through the ice and had hypothermia, did you have that conversation with her in trying to comfort her?
I did.
Do you remember that conversation?
I do.
Did you necessarily share those conversations with the grand jury?
I don't recall if I did or I didn't.
Did you ever write that in your report?
No.
Is it something you typically put everything in your report?
No, we do not write. Generally, we only write patient complaint, what happened, what they did, not their opinions or anything like that to what's going on.
Do you have any interest in the outcome of this case?
I do not.
How long have you been a firefighter for?
Since March of 2006, and an EMT since November of 2002.
Over 20 years.
Correct.
You said that you live near Kerry Roberts?
I do.
You've been to a block party for the kids where you've brought the fire engine down?
I do.
Objection.
I'm going to allow it.
When you're at that block party, do you ever step out and have secret meetings with Kerry Roberts trying to corroborate some conspiracy on their behalf?
No.
I'm going to allow that.
No.
Put your career on the line?
Objection.
Sustained.
No further questions.
Any follow-up, Mr. Yenetti?
No, Your Honor.
All right, Firefighter Whitley, you are all set, sir.
You are all set, sir. Did not love that, guys. Didn't love it. Didn't love it. We'll talk more about it.
Like to play clip 5, Your Honor?
And his mother leans over the kitchen island and says to me, I think it looks like he got hit by a car. It looks like he got hit by a car.
All right, who's your next witness, Mr. Brennan?
Next witness is Jean DeMoulis.
Jane DeMoulis is not a name I recognize from trial number 1.
Your Honor, can you please go through the case?
Okay.
This is not a name I recognize from trial number 1, so I'm not sure who this is going to be. Since they're at sidebar, guys, let's chat. Let's chat. I don't like that. I don't like that. I don't like how the defense is making everybody an enemy. It's the jury already sees things in these kind of oppositional terms, you guys versus those guys, and it's part of your job to kind of overcome that. You can't buy into, they're all bad and we're all good, because that's just not reality. It's putting you in a bad position where, you got to convince the jury everybody else here is the problem. This guy is really not a problem. Okay. Do these evolutions really matter so much? They don't, if the whole point here is that Karen didn't hit John with a car we can prove that scientifically, and therefore whatever she was saying in her frantic state that morning doesn't matter. He could have believed she hit John, and it wouldn't matter because the evidence shows she didn't. Then you don't have to get in the weeds about, combat every single witness about did she say these things or not. It doesn't matter if she said them. It doesn't matter.
You solemnly swear the evidence given to the court and jury in the case now hearing the truth, the whole truth, and nothing but the truth, so help you God. Yes, you take a seat. You just scooch in close to the microphone. Thanks.
May I proceed?
Yes.
Good morning.
Good morning.
Could you please introduce yourself to the jury?
My name is Jean Demulis. I am the general manager at CF McCarthy's in Canton.
I'm going to ask you to keep your voice up if you would, please.
Sure.
Thank you.
You said you're the general manager at CF McCarthy's?
In Canton, yes.
Okay. How long have you been the general manager at CF McCarthy's in Canton for?
For 6 years.
Can you briefly describe for the jury what CF McCarthy's is?
It is a restaurant and bar.
At CF McCarthy's, is there a video surveillance system inside?
Yes.
Who owns that video surveillance system?
CF McCarthy's.
Are you familiar with the video system?
Yes.
Have you ever looked at it before?
Yes.
Do you employ people to help the establishment with the video system?
No.
You maintain it on your own?
Yes.
At some point, were you visited by somebody from the Massachusetts State Police?
Yes.
Were you asked whether or not they could view some of your video surveillance?
Yes.
Do you remember the date? Not the date they came to visit you, the date that they were looking for.
I believe it was January 28th, 27th, 28th of 2022.
Around that time?
Yes.
Did you allow access to the video system?
Yes.
Did you oversee that access to the video system?
Yes.
Was it a state police officer?
It was two state police detectives.
Do you remember their names?
I remember one of the detectives' names. I do not remember the other detective.
The one you remember, could you share the name?
It was Detective Buchnick, Yuri.
Detective Yuri Buchnick.
Yes.
At some point, was he allowed to download information from the surveillance system?
Yes.
Did you watch him do that?
Yes, I did.
At some point, have you been able to briefly look at some of that download?
Yes.
And does it appear to be a fair and accurate depiction of the surveillance or the area of your bar?
Yes.
Move to introduce.
Okay, there's no objection, Mr. Yenetti.
There is no objection, Your Honor.
Exhibit 18, so marked.
Thank you.
Your Honor, may I play just a small portion?
Sure.
Thank you. Ma'am, I'm going to show you just some random shots from this video, but I want to know if you recognize it. Is this the inside of CF McCarthy's?
Yes.
I'm not asking if you have any particular knowledge or information about that night. I just want to know is this a fair and accurate depiction of what CF McCarthy's looks like?
Yes.
So has there been any substantive, significant changes to the inside of that establishment
No.
since this video was taken?
No.
Okay. Thank you, Ms. Gilman. Your Honor, I have no further questions.
Okay.
I have no questions.
All right, Mr. Lewis, you all set.
Thank you very much. Thank you.
Stepping down.
So foundational witness.
Your next witness, Mr. Brennan.
Thank you. Bridget Meehan.
Good morning. Good morning.
You solemnly swear the evidence given to the court and jury in the case now hearing the truth, the whole truth, and nothing but the truth, so help you God.
I do. Good morning. Good morning.
May I proceed?
Yes.
Good morning.
Good morning.
Could you introduce yourself to the jury, please?
My name is Bridget Meehan.
Where do you work?
I work at the Waterfall Bar and Grill in Canton.
The name maybe tells us a little bit about it, but could you just share a couple lines of what the Waterfall Bar and Grill is?
It's a small family-owned business in Canton. It's in a mixed condo complex.
Oh, I love her
Are
accent.
you involved in the ownership of it?
The old country.
Yes.
How long have you been involved with the Waterfall Bar and Grill?
We've been there approximately 10 years.
Do you help run the establishment?
Yes, I do.
And you were running the establishment back on January 28, 2022? At some point, were you asked or visited to see if your establishment had video surveillance of the inside?
I was.
Does your establishment have video surveillance of the inside?
It does.
Do you have a camera and a server?
Do I have? Yes, I do.
Okay. Did you provide video surveillance to the Massachusetts State Police from that night, January 28, 2022?
Yes.
May I approach, Your Honor?
Yes.
I'd like to move this in as an exhibit, please.
Okay. Mr. Yenetti?
No objection.
Thank you.
Exhibit 22.
With the court's permission?
Yes.
Thank you. Ma'am, I'm going to show you just a brief clip. Okay, stop, please. Do you see that video?
I do.
Does that depict the inside of McCarthy's?
No.
I'm sorry, the Waterfall?
Yes.
I'm trying to switch establishments on you. Back on January 28, 2022, does that look the way it looked then?
Yes.
Has there been any significant changes inside since then?
No.
Thank you. I have no further questions.
Okay.
No questions.
All right, Ms. Meehan,
Thank you.
Both of these witnesses are just authenticating the video exhibits. It's foundational testimony. They're going to play them later, probably with Buchanan, because
All
that's
right,
what
your
they did
next
last
witness,
time.
Mr. Brennan.
Commonwealth calls Mike Camerano.
Mike Camerano. Mr. Lally last time watched some of the CF McCarthy's video with Mike Camerano. If I remember correctly, he was out with John and Kerry Roberts that night. So we'll see if Hank is just running it back like trial one as well.
So step forward. Raise your right hand.
You solemnly swear the evidence given to the court is there in the case now returns from the truth, the whole truth, and nothing but the truth, so help me God. Take the stand.
Good morning.
May I?
Please.
Good morning, sir.
Good morning.
Could you please introduce yourself to the jury?
Hi, good morning. My name is Michael Camerano.
Mr. Camerano, can I ask how old you are? I'm sorry.
Spell your last name.
Camerano.
And so if you could either move the microphone down a little bit or speak up, or maybe a combination of both, please.
Okay.
Thank you.
Thank you. Could I ask you how old you are?
48,
Where do you live?
Canton, Mass.
How long have you lived in Canton for?
Me and my wife have lived there for 20 years. Me and my wife have lived there for 20 years. We have 2 children.
How old are your children, sir?
My daughter is 17. My son is 14.
Did you know John O'Keefe?
Yes.
How did you know him?
I met John for the first time at his sister's, they had a benefit for his sister in 2013. I met John there for the first time. And then years later, our kids got involved with sports together and they became very close. As they became close, I became very close with John and his family.
Was your daughter close with John's niece?
Yes.
Was your son close with?
Yes.
Did you spend a lot of time together through sports and socially?
Yes, we did.
I want to take you forward to January 28th of 2022.
Okay.
Do you remember that day?
Yes.
Had you, without any discussion of what might have been said, did you have any discussions with John that day?
Yes.
Did you have a plan?
Yes, we were communicating.
At some point, did you decide that you were going to spend some time or go meet John?
Yes. That Friday, my daughter and his daughter, they got acceptance letters to school. So we wanted to get them together so they could enjoy the time together. And, just, go over like how it would be so much fun, something new, different. Yeah, so we were going to meet up after I got out of work.
Was your daughter planning to go to a new school?
Yes.
Where?
Bishop Fan.
And how about his niece?
Same.
They both got accepted to
They
the
both
same
got
school?
accepted to the same school.
Was it a celebratory mood?
Yes.
Did you have a plan to bring the children together so they could celebrate?
Yes, we did.
And then separately, you were going to meet John and celebrate?
Correct.
Where did you drop your daughter off?
I dropped my daughter off at John. I went into John's. I was at the house with John and the girls, and we had a little celebration. Talked about how nice it's going to be, fun, change, different, meet new people.
And you celebrated at John's house before you went out?
Correct.
After the celebration with your children, did you and John leave?
Yes.
During that celebration, was there anybody there other than you, John, and your two daughters?
No. No. Karen was not there.
Was there anybody else there?
No, just the two girls, myself and John.
What was the weather like that night?
It was cold. It was not snowing yet.
Was there an expectation?
Yes, there was an expectation. Yes.
And what was that?
That there was going to be a big snowstorm coming in.
A storm was coming.
Yes.
When you left, did you leave in a separate car than John, or did you leave together?
No, we left together. John got in my car and we were leaving. We're going to leave.
Where were the girls?
The girls are in the house, stayed in the house.
They were staying at John's house?
Yes, correct.
Where did you go?
We went to CF McCarthy's.
When you got there, did you know anybody who was there other than you and John?
At that time, no.
Did you spend time at CF McCarthy's?
Yes.
Were you drinking?
Yes.
Was John drinking?
Yes.
Alcohol?
Yes.
How long were you there for?
A couple hours.
While you were there, did anybody come and meet you that you knew?
Yes.
Who?
A friend. And then Karen came in.
Okay. The friend?
Yes.
What was the friend's name?
Kurt.
And then how long after you first got there was it that the defendant arrived?
I would like to say within an hour, so not 100% sure.
You said back home it was a celebratory mood. Was it still a celebratory mood at McCarthy's?
Yes.
When the defendant arrived, did she spend time with you and John?
I've talked briefly to her, and her and John were mostly talking.
Okay. You didn't see any issues?
No.
Okay. It was a normal night?
Seemed to be, yes.
As far as you could see?
Yes.
And you saw John drinking?
Yes.
Did you see the defendant drinking?
I saw her with a glass, yes.
Okay. Did you leave at the same time that John left?
No, I did not.
When you left, was John still at the establishment?
Yes.
When you left, was the defendant still with him?
Yes.
Why did you leave?
I left because I got a phone call. My son was playing hockey in the backyard, and he got hit with a stick and lost his tooth.
Oh. Where did you go?
I went to my son's friend's house.
Do you know about what time that was when you went to see your son?
I would like to say 9:30, between 9:30 and 10.
You didn't go back to McCarthy's that night, did you?
No, I did not.
After you helped your son, where did you go next?
I went to pick up my daughter, Madeline.
Did you go
at John's house?
Did you go in John's house?
No, I did not.
When you got to John's house, did your daughter come out?
No. We went to the side door and rang the doorbell.
And then what happened?
And then my daughter came to the door.
Where'd you go?
From there, we left and went home.
When you went home, had the weather changed at all?
It was cool. It might have been flurrying at that time.
No accumulation?
No.
You got home?
Yes.
Did you do anything significant when you got home?
Put the kids to bed, my son, and no, I went to bed.
What's the next thing you remember happening?
Waking up to, I missed some phone calls.
Who were the missed phone calls from?
From my wife and Karen.
What did you do?
I called my wife.
After speaking to your wife, what did you do?
I got in my car and drove to John's house.
About what time was this?
In between maybe 5 and 6 a.m.
What was your mood at that point?
I was panicked.
Why did you go to John's house?
Because I went to get Kaylee.
Did you know if she was alone?
Yes.
How long did it take you to get to John's house?
Maybe 5-7 minutes.
When you get to John's house, what do you see?
I pull in the driveway. I see that the garage door is open. I go in through the garage door. I don't know if Kaylee was standing there, if the door, she came out the door, and I asked her, if she needed anything, she could get in my car and stay warm.
When you first saw Kaylee, what did she look like?
She looked distraught.
Did you try to help her?
Well, I think I just said everything will be okay.
Did she come with you?
Yes.
Where are you going?
To my house.
So what happens?
So we go to my house, and my daughter's up, and the two girls they were hanging downstairs, just hanging out, just being kids. And then, I don't know, a couple hours later, maybe, Paul called me and asked me to bring Kaylee home.
Did you know anything at that point?
I did, yes.
You did or didn't?
At that point, I did when Paul had told me.
So what do you do?
Ask Madeline and Kaylee if I'd say, Madeline, will you come for the ride? I don't say anything to Kaylee, and why we get in the car, and I start heading back to John's house.
And you didn't say anything to Kaylee?
No, I didn't. I just said everything will be all right. She had a feeling.
Why do you say that?
She didn't want to go home.
So what happens next?
So I pull in the driveway, and I remember Paul and Papa standing. I think they were standing at the side door, and we just embraced.
Did you stay?
No, not long. No.
Did you go back?
I was to the house. I went back to my house.
Did you go back to John's house?
I did the next day. Yes, I was there.
When you went back, were there people there?
Yes.
Many?
There was people coming and going.
Thank you. I have no further questions.
Thank you. Bless you.
Good morning, Mr. Camerano.
Good morning.
This is quite painful for you to remember the events of January 28th, is it not?
Yes.
You were very close with your friend John O'Keefe, correct?
I was close with him, yes.
and you actually met Karen Reed through John, correct?
Correct.
After meeting Karen, you spent a good amount of time with both Karen and John, correct?
Correct.
As of January 28th of 2022, you had known Karen for maybe about a year or so?
Sounds correct.
And you'd see them especially on Fridays, correct?
Correct.
That would be sort of the day that you get together with both of them often?
Yes.
And of course, your children spent a lot of time with John and Karen, right?
Correct.
You entrusted both Karen and John with your kids.
Yes.
Sometimes your kids would even go on vacation with Karen and John, right?
They did go to the Cape, yes.
Sometimes you'd see Karen without John at your house or on a ball field.
Correct.
And your daughter in particular would sometimes spend time with just Karen without John, correct?
Correct.
Your daughter would sometimes go over to Karen's house in Mansfield when she lived there, correct?
Correct.
And obviously when your daughter would go to Karen's house in Mansfield, Karen would be the one in charge of caring for her, correct?
Correct.
And you were fine with that because you liked and you trusted Karen, right?
Correct.
And in your view, Karen was very good with kids, right?
Correct.
But you also had the opportunity to see Karen and John together, right?
Yes.
You saw how they interacted with each other over that year period that you knew Karen?
Yes.
You saw how they got along?
Yes.
And you never observed any arguments or bickering, correct?
I mean, they argued and bickered.
You had previously testified that you wouldn't even call it arguing, you just call it banter, right?
Yes. I mean, he would, I mean, no, he would get upset or like over if she bought expensive things for the kids.
Right.
Yes.
Yes. We will get to that. That would be the one thing that John would complain about, Karen buying like very nice things for his niece and nephew, right?
Correct.
Or he'd complain if, Karen was taking his niece and other girls to get their nails done, like extravagances like that.
Correct.
And one specific memory you have is when Karen bought his niece a very expensive sweater, right?
Correct.
And you recall John telling you that he wished that she hadn't done that because he considered that to be spoiling the girl, correct?
Yes.
But it was very clear to you from your observations that Karen really, really liked John. I'm sorry, John really, really liked Karen, right?
Sustained.
He certainly never told you or even suggested he was thinking about or planning to break up with Karen, right?
No.
Okay, so with regard to that Friday night, January 28th, sir, the plan was for you and John to go to McCarthy's to have some drinks because there was a storm coming in, correct? And because of the celebration of the girls getting into Bishop Fen?
Well, yeah, we were going out. It wasn't a continuation of the celebration of the girls. We were going out to have a few beers as guys.
Okay. And when you were leaving the house, John asked you to move your car, right?
Correct.
Where was your car when John asked you to move it that night?
Actually, I backed up my car. We were leaving the driveway, and John asked me to stop so he could move his car.
I see. And he wanted you to move your car because of the storm coming in, and you wanted Karen to be able to pull her car into the garage, right?
Correct.
And that was really thoughtful of him, wasn't it?
Yes, extremely.
And it showed you that he was being chivalrous toward Karen that night, right?
Yes.
He didn't want Karen to be out in the heavy snow later when she returned to his house during the expected blizzard, right?
Sustained.
You took from that there was an expectation that Karen would be coming back to his house, correct?
Objection.
Sustained.
You had no inkling that day that anything was wrong between Karen and John, correct?
No.
Everything seemed fine between the two of them, right?
Yes, he did mention though that night that he didn't understand why Karen had a plumber go to the house.
because he had somebody that could have done that work instead of paying for the plumber, right?
Well, yes, yes.
Okay.
And
But in any case, the plan was for Karen to meet up with the two of you, right?
yes,
And she did show up to McCarthy's at about 8:30 PM or so?
yes, I guess
And-
if that's the time.
And you saw an affection.
I'm sorry, what was the answer that you
If
said?
that was the time, I'm not sure about the timeline.
Okay. It was sometime after you
Yes.
got in there. Right.
Correct.
But you do remember when Karen arrived, there was an affectionate greeting between John and Karen, right?
Yes,
You saw them kiss, right?
yes,
You saw John put his arm around Karen,
correct,
and you saw that Karen sort of nestled into his embrace.
correct.
And when she did that, that's when he kissed her, correct?
Yes,
And they seemed happy to see each other, did they not?
they did.
That night they were affectionate,
Yes,
laughing,
yes,
happy,
yes,
like a normal couple.
yes.
No arguments.
No,
You witnessed no bickering, no tension, correct?
no,
And during the month before John's passing, that January of 2022, you observed their relationship in your presence to be normal, caring, and affectionate, right?
yes.
Thank you very much, sir.
That was very well done. Still a little longer than I might prefer. But
You
I'm
were
being
asked a
very
number of
nitpicky.
questions about the relationship between John and Karen that night. Do you know what was going on behind closed doors other than what you saw?
Objection.
I'll allow it.
No,
Do you know whether or not they texted each other that day?
no, that day, no.
Do you know whether or not there was any arguments that day?
Objection.
I'll allow it.
Not to my, no, I don't know if they were, I don't know if they were arguing over the plumber situation. I
Do you
don't
know
know.
if there's any vulgarities that day?
No,
Do you know if there's any vulgarities that night?
no, not to my knowledge.
Do you know whether or not John was trying to end the relationship with Miss Reed?
Objection.
Do you know that, sir?
No,
Next question.
Do you know if there was any jealousy in that relationship?
Objection.
I'll allow it.
I mean, Karen wouldn't they did everything together, a lot of things together. And I thought at times, yeah, you could see, she didn't want other women around John. I don't know, not at that, but
Thank you.
Any follow-up?
Nothing further.
All right, Mr. Camerano, you're all set, sir.
thank you.
So I'll just step them down, please.
Glad they didn't follow up on that.
I'll see counsel at sidebar for just a minute, please.
Now a sidebar. Well, I like that much better. He, you don't have to make everybody an enemy. Michael Camerano, obviously, he's not a cop. He is not one of the people that is there to have bad things to say about Karen. So I do sort of understand, but it is a good contrast. I'm glad to see with how he handled Mr. Whitley, because I didn't like that. I really didn't like that at all. The arguing with him because he wants to explain his answers. He gets to explain his answers, dude. He gets to. This is a situation where Judge Cannoni is not necessarily wrong when she's saying he gets to answer the question kind of the way he wants to. It's not unresponsive just because he doesn't stop at yes or no, or just because he, set some context to get there. That is allowed. So the arguing, back and forth and going to this extreme effort to pin him down to exactly the point that you want him to make, I don't find that helpful. I don't. It's a style thing, maybe. Maybe this is fine in Massachusetts and they like that kind of engagement. Obviously, I don't know that. But I personally don't like it. There are many occasions where he got what he needed as far as like the concession about the prior testimony. You got it, but then you went further and you tried to get him to characterize it the way you wanted him to. And that's argument. And then when he didn't do it, you end up going around and around this rabbit hole again to try to get him locked in to what you want to say that it means. And he's not going to agree with you that that's what it means. So I find a lot of that. I find a lot of that very frustrating. But he did volunteer the previous trial, didn't he? The team isn't going to be able to point that out, that this case has been tried before. That's off limits as far as them being able to mention it. Their question did not specifically elicit this. He didn't ask them what were the circumstances in which you testified on previous occasions. He just said you had 4 previous occasions where you testified. It turns out it was or 3 previous occasions when you testified. And he said, well, there was the grand jury in the previous trial. This is what happens when you don't answer the question yes or no. The question did just call for yes or no. He chose to explain it. That wasn't elicited by the defense. But it came out and now the jury's heard it. The jury's heard there was a previous trial and now they also understand from the context, if they were paying attention, that was last year. When they talk about testifying last year, that was in the previous trial. So Mr. Camerano, God, he was nervous. He was having so much difficulty breathing. I've definitely started to notice a real distinct difference in the attitude of the witnesses between last time and this time. And I just wonder what they're being told in prep. Are they being told?
May I?
Please.
I'm going to recall Nick Garino.
Okay.
Are they being told that like the defense is going to mess you up? The defense is going to do this and that? Is this why the witnesses are so cautious and resistant with the defense? Like they're thinking about everything, they're qualifying everything. They've been positioned as like enemies of the defense. Have they been told their lives are in danger? They're going to get threatened. People are going to show up at their houses. I would really like to know if there's something going on in those prep sessions that is encouraging this attitude on the part of the witnesses.
Okay.
Parliament, please.
Sure, you can have a seat. I'll remind you you're still in your room.
Or stand, however you're most comfortable today. Just do whatever you need to do, okay?
Thank you, Your Honor. Good morning, everyone.
Sir, yesterday we talked about downloading phones and making what you called extractions.
Yes.
And from that data, you could create different types of reports.
So have Detective Garino say his name again, please.
I'm sorry. Again, for the record, could you introduce yourself to the jury and spell your last name for the record?
Yeah. Good morning. My name is Nicholas Garino, Guarino.
Thank you.
Sir, you mentioned yesterday that you downloaded a number of phones, or you were involved in the process of downloading a number of phones.
That's correct.
You explained to us that after you have the data analyzed, you can pinpoint certain items that you may want to put in a document.
Yeah, so the extractions into a program of our choosing, Cellbrite is the most commonly used, and then we can take call logs or text messages, any information that the investigator is looking for.
When you downloaded Mr. O'Keefe's phone, and you downloaded the defendant's phone, did you try to create, or did you create a report through Cellbrite, the software, that would show you all of Mr. O'Keefe's call logs?
Yes, I did.
And when I use the term call logs, what does that mean?
The call logs are the calls that the phone receives.
How do you create a report from Cellbrite? Can you just walk us through that process briefly?
Yep. So in the program, you can go in and select the calls from it and export it into different formats, PDF, XML, HTML, or you can create a portable case and extract them all as a portable case that we would see on my computer.
May I approach, Your Honor?
Yes.
Very wrinkled forehead on Mr.
Showing you
Garino.
a document of Mr. O'Keefe's call logs. Do you recognize that?
Tight in his eyebrows. You can see,
Yes.
you know,
And what is it?
clenching.
It is the call logs. Just want to make sure it's between John O'Keefe and the defendant from, just want to see the dates, the 28th, January 20th, 2022 to January 29th, 2022.
Would this contain all the phone calls from his phone data for the calls between those two parties that night?
Yes, that's what I created.
Thank you. I'd like to move this as an exhibit, please.
Okay. So
If I could, Your Honor, just
This is
wanted
him.
to make sure we got the same.
Okay.
Thank you, Mr. Brennan.
this is him. Remember that in the last trial? He did. He sat there and he said, just kill me under his breath. We were all like, oh, what on earth did he just say? He did. He said it. Hot mic
Thank you, Mr.
moment.
Brennan.
Okay.
Thank you, Your Honor. Consent.
Okay.
No objection.
You captured all of the phone calls between two parties on that last document. Can you also do that with chats?
Yes, that is true.
And did you do that in this case?
Yes, I did.
Did you create a document of chats between the phones of the defendant and Mr. O'Keefe for after midnight for the evening hours of January 29, 2002?
Yes, I did.
May I approach?
Yes.
I'm good.
We do know this. He's the one that is making the objections and stuff. They don't get to double team witnesses, so it will be a lessee.
Yes, I do.
And can you tell us what that is?
These are the texts from the defendant to John O'Keefe. Yes.
For January 29, 2022?
Yes, that's correct. I'm sorry.
Okay. I'd move this as an exhibit, Your Honor.
No objection, Your Honor.
Thank you.
So just on the 29th after midnight, not all the precursor stuff where he's unhappy, she's not waiting for him to come fix her toilet whenever, or her hot water heater, whatever it was. It was a hot water heater.
Did you identify or specify chat messages between John O'Keefe and a person named Jen McCabe?
Yes, I did.
Did you create a Cellbrite report?
Yes, I did.
May I approach?
Yes.
Can we have just a brief moment, please?
It's sidebar?
No.
Just the two of them?
Compare that what we have.
Yes, go ahead.
Thank you, Your Honor.
Okay.
Thank you, Mr. Brennan. You're welcome.
Sir, I'm handing you a document. Do you recognize it?
Yes, this is the text messages between John O'Keefe and Jen McCabe on January 29th, 2022.
And this is to a search and celebrate you match their data, pull up all of their conversations.
Yes, that's correct. Yes.
Okay. I move to introduce this, please, Your Honor.
No objection, Your Honor.
25.
So all this is just after midnight, except for the call logs between John and Karen carried over
Similarly
from
to the chats, did
the
you
day
do the
before.
same with calls between Mr. O'Keefe and Ms. McCabe?
Yes, I did.
May I approach, Your Honor?
Yes.
Showing you a document, sir. Do you recognize that document?
Yes, this is the call log between John O'Keefe and Jen McCabe for, just want to make sure I get all the dates correct, just for January 29th, 2022.
All
Do you
after
have this, Your Honor?
Okay.
No objection, Your Honor.
Exhibit 26.
Oh, look at that. Look at that
Did you
forehead.
do a file extraction and a report on all chats between the phones of John O'Keefe and the defendant for a period of time?
Yes, I did.
May I approach, Your Honor?
Yes.
Getting you a document. Do you recognize that document?
Yes, this is the text messages between John O'Keefe and the defendant from January 28th to January 29th, 2022.
Thank you. Your Honor, move this into evidence.
Okay. Mr. Lessie?
No objection, Your
All
Honor.
right. Thank you.
Exhibit 27.
Back to worried already. Got his drink and a brief moment of relaxation, and then instantly he's back in worried mode.
Did you have an opportunity to make a report from some of the data from the defendant's phone from January 29, 2022?
What are you referring? I did make some reports from the defendant's phone.
What's a call log report?
Again, the call log report is the calls that the party makes to another phone. So it's going to show everyone they've called or attempted to call.
May I approach, Your Honor?
Yes.
Is this how he's trying to make his case look super science-y by turning this into a big stack of exhibits instead of, you know, one or
I'm gonna
two?
ask you to take a look at this document. Do you recognize it?
Yes.
And could you tell the jury what it is?
It's the call log from the defendant's phone for January 29th, 2022. It looks like everyone she called.
Introduce this as an exhibit, please.
No objection, Your Honor.
Thank you.
Exhibit 28.
What we just introduced into evidence is the entire call log of calls to anybody and everybody to and from for that period of time.
Yes.
That's fair to say?
Yes, that's correct.
And then can you further isolate calls between just two parties?
Yes, you can. You can search by phone number or name.
And did you do that with the defendant's records for some parties?
Yes, I did.
Did you isolate phone calls between the defendant and Ms. McCabe for the evening of January 29, 2022?
Yes, I did.
May I approach?
Yes.
Let's take a look at this document. Do you recognize it?
Yes, I do.
What is it?
It's the phone calls from the defendant and Jennifer McCabe, January 29, 2022.
Thank you. Your Honor, I'd like to move this into evidence, please.
No objection, Your Honor.
All right, thank you.
29.
We're up to 7 exhibits that are just little bits and pieces of Celebrate reports. Who's going to be able to hand the jury look how
Did
many
you
there
isolate
are.
calls between the defendant and Ms. Roberts for the night of January 29, 22?
Yes, I did.
Can I see the last exhibit, please? Thank you, sir. Thank you. I asked you to take a look at that document. Do you recognize it?
Yes, I do.
Could you share with the jury what it is?
Yep. It's the call logs between the defendant and Kerry Roberts for January 29th, 2022. Yes.
That's a report you created.
Yes, it is.
Your Honor, listen to evidence, please.
No objection, Your Honor.
Okay, thank you.
Exhibit 30.
Ew, his back
Did
of
you
his
have an
suit
opportunity
is rolling
to
up. Bad fit,
isolate
dude.
and produce a
Swimming in the
report for
suit.
all chats between the defendant and Ms. Roberts for the night of January 29, 2022?
Yes, I did.
May I approach, Your Honor?
Yes.
It rolls up like that. He's got too much fabric at the back. Get the menswear guy on that. Help him sort
Sir,
that
hand me the
out.
document. Do you recognize that?
Yes.
And could you share with the jury what that is?
This is text messages between the defendant and Kerry Roberts on January 29th, 2022.
Thank you. I would move this to evidence, please.
No objection, Your Honor.
Okay. Jurors, this is the way we have to put evidence in cases in Massachusetts, okay?
Exhibit 31.
So do you have an opportunity to identify a text message or chat between the defendant and a person by the name of Ingrid on the morning of January 29th, 2022?
Yes, I did.
May I approach?
Yes.
Take a look at this document. Do you recognize it?
Yes.
Could you tell the jury what that is?
Yes, this is a text conversation between the defendant and looks like a group chat between Ingrid Curtis and Bill Curtis.
Did you make that report?
Yes, this is on January 29, 2022.
Thank you. And move this into evidence, please.
No objection, Your Honor.
Thank you.
Don't think we heard about Ingrid and Bill Curtis last time. This will be new. Somebody else she was talking to
If
sometime
this is a
after
good time,
midnight.
if the honor would permit.
Okay.
Jurors, what we're going to do is we will take our morning recess now, and we'll take 20 minutes to a half an hour. We'll see you then.
20 minutes to half an hour, taking an extended morning recess. Normally it's like a 15-minute bathroom break kind of deal. So let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 separate exhibits of things that he's broken out from the extractions. Is this to just make it look like, look at this volume. Look at this volume of information that we have. I don't know. we'll see, I guess. We'll see how he uses it. Do you guys remember there was an issue last year with Trooper Guarino and the extraction and a PDF that was provided? And he was distancing himself from it. He didn't know who provided that. That wasn't him. Kind of sounds like that was one of these reports, one of these broken out reports or something that people can make with the Celebrate data. Wonder if that's going to come up in this trial too. Remind him last time there was an issue with it. Because it definitely seemed like he did not want to be associated with that particular item. That little comment from Bev. Oh, guys, don't hold this against the Commonwealth. This is just how we have to do it in Massachusetts. I also noticed that when Mr. Brennan cuts people off, he cut Mr. Camerano off at several points during his answers. She doesn't tell him, don't interrupt, let the witness answer. Just a little thing I noticed. Well, kind of a slow, boring start this morning, if we're being honest. But I really do wonder what's going through these witnesses' head this time, because they do seem to be quite different in their demeanor than they were last time. Michael Camerano, last time, my recollection of him was that he was still emotional. He's John's friend, and he remembered these events, and they're definitely, painful for him. But I don't remember him being so just careful to make sure, when you ask a question, he kind of talks around it. Well, I mean, it's just, maybe they were arguing about the plumber. I couldn't say for sure. He's sort of cautious about testifying in a way that he wasn't last time. Last time, my recollection of him, he was just pretty forthright, there to say what he knows. And didn't seem so nervous about what he's there to do. These are subjective things, of course. You can't really I guess you could measure it somehow. You could have some metric like how many times does he stutter? Count them in this trial versus the last trial. You could come up with some kind of objective measure for reluctance or caution or whatever, and go back and do it. But I haven't done that. This is just pure vibe test. Vibe test. He just seemed so much more nervous this time. And that, combined with how Kerry Roberts was much more closed off, haughty than she was the first time. She seemed very soft and very grieving, and it was very sympathetic. So they didn't cross her. Just a vibe I'm getting, and I'm curious about it. I don't know if it's their own independent. We've seen how things have gone in the aftermath of the first trial. We've seen all this stuff's on TV. We see this case is blowing up. This case got national attention. We're going to get blamed. I don't know. I really don't. And so my suspicion is it comes from the prep. They've been told something that encourages them to be fearful about what's going on here. I don't know. I'd like to know. Well, since we have a chance, we'll go through some of your questions and comments this morning before we get too far ahead, and then we can't keep track of who's talking about what. So we've got Kevin Honky Brennan's spell checker is a new member. Welcome, Kevin. Nick, welcome, Nick. Don't underestimate the clips of Karen reinforcing what the witnesses says. Changing the mind of a juror is hard. Nobody wants to believe the state is this bad. Yeah, I mean, that's part of the back foot that you're always on as the defense attorney. People want to believe in order and security and safety because they want to know if I get in trouble, I can call the police. The police will be there to help me. They will come and keep me safe. They will help me get justice. If something terrible was to happen, they'll be on my side. So those are the desires that people have. And so when you want something like that, you're going to intend to interpret reality in a way that will reinforce that. That's your confirmation bias. You want that to be right. So you're going to tend to look at the cops as the good guys. You're going to tend to look at the prosecutors as the good guys. You're going to tend to look at the defense as that bad person who did something wrong. That's why they're here, because these good guys who do justice have brought this person in there to answer. So even though, this stuff may not be that explicit, it may not be that obvious, conscious, these are just fairly normal biases that people walk into a courtroom with. So it's very difficult to overcome that. And that's part of the reason why I don't like feeding into it. I don't like a position where you have to make an enemy of everybody that's involved in law enforcement and first response, because I don't think that's a distinction that you win. You need to find common ground, find ways that you're on the same side, find ways that it doesn't matter. So what if the guy is slippery and changing his story? If he's slippery and changing his story about something that doesn't matter, then it doesn't matter. Let the jury think whatever they want of him. It doesn't matter. You don't have to make everybody an enemy. But the clips, I mean, I'm not sure yet what to make of the clips. I'm really not. I haven't heard anything that seems very damaging. The defense was concerned about her demeanor on this last one that got shown, because she's doing this caricature of Peggy O'Keefe, of the mean Peggy O'Keefe. He looks like he was hit by a car. He looks like he was hit by a car. I mean, the jury's already heard that Peggy O'Keefe was like, what is she doing here? What is she doing here? Like, the jury's already heard Peggy's got this disdain and contempt for Karen, and they heard that from the Commonwealth's own witness. They didn't hear that from some defense witness, who might be characterizing it negatively to help her out. It came from a Commonwealth witness. So, I mean, I'm not sure yet what to make of it. My perspective on this is that that's part of why the defense is on such strong footing when their theory of the case that they're pursuing, their primary theory here is there was no collision. John wasn't hit by a car. And part of the reason why that's so powerful is because if you can establish that, then you can also necessarily establish whatever Karen said. If she said anything that sounds like she hit him with the car, it doesn't matter. She was mistaken. Being mistaken, somewhat normal, somewhat expected, predictable. You put 10 people in a room and have them witness something, you're going to get 10 different versions of what happened. You can follow that theory. Karen can be just as wrong as everybody else. And so that's kind of how I see the way to attack this case. And that's, again, just to kind of emphasize that it doesn't matter what people said she said. Now, I can definitely see the point in going after the I hit him. That is probably the most damaging one. It's the one that sounds the most like a confession, the one that people are probably most likely to put weight on, as far as, that's an admission. And the fact that it's got such a clear path of confabulation, right? Didn't show up at the meantime, didn't show up at the time, didn't show up till, later. People didn't act at the time as though that had been said, and their accounts of when and how it was said don't add up with the objective evidence. So it's kind of low-hanging fruit in terms of being able to establish this point. A lot of times what people say and think and remember is wrong. And yeah, that can include Karen too. You can turn that to kind of part of your theory. That applies to Karen too. So it's not, I guess, so much the clips themselves that bother me, because I really haven't seen anything that from my perspective is like, ooh, that's super damaging. And again, I mean, remember, the Commonwealth assured me they're going to rely on fact, science, and data. And so far, we don't have any of that. We just have Karen Reed says stuff. We have a lot of Karen Reed says in this initial part of the Commonwealth's case, that they told us that was their backup. And I told you it was a head fake. It's their actual case. It's their actual case. The fact, science, and data is just in case they can get ARCCA out, they can get ARCCA limited, and then they can have some sort of claim to have presented a scientific basis for their theory. But it's really just I hit him, part 2. They're running it back. And so my concern is not so much with the clips themselves. It's, has the defense theory been constructed in a way that minimizes that emphasizes it doesn't matter. It doesn't matter what she said. If she didn't hit him with the car, and we can prove that through John's injuries, through the damage to the car, through the location data, through everything, if we can prove that, then it doesn't matter what she said. She could have thought she hit him, and she would have been wrong. So it doesn't matter. Kathy, your realtor and jury, do you think the defense is so invested in proving her innocence that they are overlooking reasonable doubt? Well, in their opening statement, they did a fantastic job of addressing reasonable doubt. And I think, maybe this is just a difference of perspective between attorneys. I look at things a certain way. I am not the authority. Lots of attorneys are going to look at the same case and have different perspectives on how to handle it. And so we just may have a little bit of a difference of perspective. Some people might think creating reasonable doubt means undermining Commonwealth's witnesses whenever you have the opportunity, so that you can point out to the jury, this is unreliable and you can't rely on it. And that's reasonable doubt. If you can't rely on any of the Commonwealth's witnesses, then that gives you reasonable doubt. I mean, it's possible, but now you're running up against that bias that Nick just brought up. The jury wants to believe these are the good guys. They're going to want to believe that. And so if they have the ability to choose, do I believe he's a good guy? Do I believe he's a bad guy? They're probably going to choose he's a good guy. Unless they got a really good reason not to. And so that's where, if you got something substantive, something important that shows he's unreliable, that's going to be really important. But just going in and kind of trying to nitpick over, you didn't say in your report that, she was crying off and on. You just said in your report she was crying. This is not the kind of inconsistency that I think lands. I don't think it's necessarily working. But I mean, this is an intriguing idea. Yeah, I do think they want to prove her innocence. It's just that the way you prove her innocence is by proving John wasn't hit by a car. And so if we were focused on that, our eyes are on the prize, we're going to establish John wasn't hit by a car. So whatever she said doesn't matter. I feel like we'd be seeing a little bit of a different approach. My concern here is twofold. I think a couple of things are happening. I'm seeing a little bit too much playing it back from trial number one. I mentioned this yesterday. I'm starting to see it again today. I don't like that. You were supposed to adjust your strategy. You told us in opening kind of how it's different. It's not a Karen Reed is framed case this time. You acted the way you did in the first trial because you're proving Karen Reed was framed. That didn't work. So now we're shifting and we're pointing out Karen Reed didn't hit John with a car because John was never hit by a car. And this investigation was trash. If they had done a real investigation, they would have found leads that are more consistent with the circumstances that were actually present in terms of John's body, location, et cetera, et cetera. It's supposed to be a different case, so it should look a lot different than it is. We shouldn't be getting the same emphasis, the same approach from all the different witnesses. You need different things from them to prove or establish different theories. And so I'm still seeing that Karen Reed was framed run back, and I don't like that. It concerns me. I'm just going to say this, guys, and I know this may not be popular, but I'm just going to say it. You get what you pay for with lawyers. You get what you pay for. I know there's been a lot of praise of the defense team that they're proceeding pro bono at this point. Nobody's getting paid. That's not what this is about. They just really believe in justice for Karen. And that is, you can't say that's not laudable. Of course, that's laudable. But there's a problem with it. Which is that if you are not getting paid for your time, you are not incentivized to put in a lot of time. You got to focus more on your work that is paying you, because y'all got bills to pay. David Yenetti has a firm to run. Alan Jackson has a firm to run. Robert Alessi is in a massive multinational firm, that is going to have expectations of him. Right? He's a partner. He's got probably a little bit more leeway. But you can't just pretend like money doesn't matter, that time isn't money when it comes to a legal case. So it's a little bit of a concern of mine that they haven't really put in the time to prep a new theory in a new case, that they're relying a lot on the time they already put in prepping for trial one, but that was a different trial and that was a different theory. And the same approach isn't necessarily going to work the same time. This reminds me of a quote, because jury trials, from my perspective, they are won or lost in prep. You win or lose your jury trial in prep. And I say this not because it's a script that you make and then, produce and everything goes the way that you're expecting because you've planned it out so carefully. No, anybody who's ever been to trial knows whatever is going to happen happens. Things can be very unpredictable. Stuff can come up. It can get really wild. And so you have to be flexible and able to adjust. You have to be able to figure things out on the fly. Like it's a lot of both of these things. But it reminds me of a quote, and now I'm going to have to defer to Jeff in the chat to say who said it, because I don't remember who said it. But it's one that he's told me often, and it's some military person that plans are useless, but planning is essential. And that's really what I'm getting at here. You can't have a script. You can't have a script and expect it to just, go exactly the way that you've planned it out. It just doesn't happen. That's fantasy land. The witnesses are not necessarily going to answer the way that you want. There's going to be problems with people not showing up, or people randomly coming up with new things, or volunteering new things, or evidence, getting excluded at the last minute. Like, you're always going to have to adjust. So your actual plan, you're not going to be able to rely on that. It's like building a house. You have a plan for a house, but no house is ever actually built exactly to plan. It just doesn't happen. That's not how it works in reality. But it's the process of planning that lets you know where you're going, what your objectives are, and how you're going to get there. That's what gives you the structure that you need, so that when chaos happens, you are able to adjust on the fly and be like, oh, this isn't going how I anticipated, but here's where I need to get with it. So here's how I can modify my approach. This road is blocked. I didn't expect that, but here's this pathway. I'll go that way, because this is where you need to end up. So that's where the planning is essential. And that's what concerns me. I'm not seeing what I would expect if there had been like a rigorous plan, revision, prep for this trial that's different from trial number 1. I'm just seeing a little playing it back. And so I'm concerned about that. I'm concerned about that, and I'm concerned about the incentives for why that may have happened. Not saying it's a bad thing for lawyers to do pro bono work by any stretch of the imagination, but this is a big project to not be getting paid for. And if you're not getting paid for it, your incentive is to minimize the time you put into it. I hope that's not going on, but that's just kind of natural. So I don't know, Kathy, I think it's complicated, and I think there's a lot of stuff going on here. I think they definitely do want to prove her innocence. But that's not necessarily what I'm seeing driving things so far. I guess we'll see. The rural juror, could there be a splitting of hairs with the testing? Like, what if they finished it but haven't made a report or evaluated the results? That's going to be up to Judge Bev, isn't it? As far as the ARCCA order, she says they have to have their testing completed by Monday. She didn't say they have to have their testing completed and a report and, written and distributed and so forth. She didn't say that. It sounds like if it's complete to the point where they're able to talk about it on Monday, then that, if I'm the defense attorney, I'm arguing that satisfies the condition that you laid. They finished their experiment. They finished their testing. Haven't necessarily had the time to document everything, haven't maybe necessarily had the time to finalize everything, but enough to be able to give you an idea of what we're doing and what we're looking at. Is the Commonwealth like really entitled to that? Not necessarily. They're getting a draft report, basically. Getting a draft report. And then there's the risk, that can be used against them. They come up with some kind of preliminary interpretation, preliminary analysis of their experiment. But as they go back and, in the process of finalizing it, they have to tweak it. Well, then it's going to be slightly different. And now that's going to open the door for Mr. Brennan to come in. Oh, you guys testified before that it was this. It's just, setting up a very advantageous playing field for the Commonwealth when it comes to the reconstructions. and the facts, science, and data evidence. Getting a little boost with it. So yeah, who knows how Bev is going to interpret this? We don't know. We don't know. James Cassatelli, we're watching prosecutorial and judicial misconduct in real time. How is there no way to stop this? Well, because the premise in the law is that your remedy is an appeal. Premise in the law is your remedy is an appeal. If it gets to that point, if the judicial and prosecutorial misconduct is so bad, let the jury see it, show it to them. Kind of harder to do that with the judge, they have to figure that out themselves. With the prosecutor is, suborning perjury or things like that. Show the jury that, so they can take it into account. Maybe you don't have to end up in an appeal in the first place. But that's all I have for you is just an answer that's because that's what the law is. Not very satisfying, is it? It's not very satisfying, but we got to know what the law is, because if that needs to change, we have the power to change the laws. You got legislatures that can do it. We got political pressure, voices, all that. Laws can be changed, but we got to know what they are first. Right now, the law is, well, she'll get to appeal. Sorry for the unsatisfying answer. Freddie York, Andrea, I hear what you're saying, but they can't just not question these people. Given that they aren't sympathetic to the defense, they have to do their best to impeach them at the minimum. Well, I understand this perspective. I just don't agree with it. I don't agree with it. They absolutely can not question people. You absolutely cannot question people. And I promise you, it's not bad. It's fine. If the people don't matter, we already understand the Commonwealth's witnesses are against the defense, by and large. By and large, their witnesses are friendly. Sometimes they might call a hostile witness, but by and large, their witnesses are friendly. So we already know that. It's not telling us anything we don't already know to show they're behaving in a way that shows that they're, against Karen. We already kind of know and expect that. So it's not particularly helpful or valuable. It really isn't. And I know I'm advocating for restraint. I'm advocating for restraint. I'm advocating for discipline and focus. And sometimes that means you don't need to question the witness. If there is nothing of value to get from that witness, you really don't have to question them. Who cares if they're against Karen? If they're against Karen, does that prove that John O'Keefe was hit by a car? No, it doesn't. That's just my view of it. I mean, I understand people have different perspectives on that. Some people do. They want to see a fight with every witness. I guess my question would be, let's say, okay, we've got a pretty, I see opinions all over the place in the chat, and we have a difference of opinion right here. We don't know what the jurors think, right? It's possible that all 18 of them think exactly like I do. It's possible that all 18 of them think exactly like you do. It's more likely that they're mixed. There's a mix. People will have different reactions to what they're seeing and different preferences about how they'd like to see it handled. And so if that's the case, which approach is likely to be more damaging to the defense or less damaging to the defense? Is it going to be more potentially damaging to be making everybody an enemy because you got to cross-examine everybody, even if it doesn't really matter and you look antagonistic? Or if you have a witness who is against Karen, presents testimony that makes it clear they're against her, they don't like her, she said stuff that they think is problematic, and you don't question that witness because you're just going to argue to the jury at the end of the case, it doesn't matter. And hopefully you would have told them that in opening as well. Doesn't matter what she said. He wasn't hit by a car. We can have different opinions about that too. My perspective is with the right groundwork, it's far less damaging to let the witness go because you've already let the jury know it doesn't matter. You've told the jury what matters. You made it clear what doesn't matter. And so as the case unfolds, it already fits in that framework. If you've laid the groundwork, you cannot question the witness because it doesn't matter. But I think you run a risk of putting people off. Run a risk of putting people off. Like, why are you going after this guy on this nitpicky stuff? He's just a firefighter showing up trying to do his job. If you could prove to me that he's influenced by the Alberts or he's influenced by Kerry Roberts, okay, that was kind of part of your theme and opening, right? The powerful Albert family. They're controlling all of this. They're the ones that are being appeased by everybody's actions. That might be one thing, but him living in the neighborhood with Kerry doesn't get you there. It doesn't get you there. So I think my perspective, it's more risk of harm than upside to that approach. But I totally buy that we can all have different opinions about it. Oh, Jeff is reminding me in the chat that the plans are useless, but planning is essential is Eisenhower. So I knew it was a general. I knew it was a military guy. I just couldn't remember, like, is this an American, like, recent one? Is this Van Clausewitz? I couldn't remember. So thank you, Jeff. Really appreciate you. Kathy, your realtor in Jersey. Kind of fun to see him wiggle as he is questioned, similarly to how they treat people. Yeah, I mean, I can see that. Here's, I think, maybe a little bit of the difference. I feel like people who are especially empathetic, they're going to tend to put themselves in the shoes of the witness, and they're going to tend to, try to feel for them. Other people like to watch the action. They like to play.
All right.
And
Could I see counsel for a minute regarding scheduling, please?
Regarding scheduling. So, I mean, I especially get this with the firefighters or with the law enforcement. I do, because it's very direct that way. We like seeing the tables be turned, but mostly when they deserve it. If you got a real nice cop up there, a real nice guy, and yeah, they're out there. There are nice guy cops out there, and you try to get him wiggle, like, people are going to feel bad for that guy. He's just a nice guy. He's not one of the bad ones. He doesn't deserve that kind of treatment. But most of them, cops, their authority and their control and all that. Yeah, it does feel fun to kind of turn the tables a little bit. I can't deny that. I can't lie about that. Just not sure that the firefighter paramedic people are the right ones, because they're like, they're affiliated with the cops, but they're definitely not the cops. If there's a hero archetype, it's a firefighter. In the modern world, going into danger, saving the children and pets at peril of their own life and limb, with really nothing to gain. They don't have, career status to gain by, fingering somebody for a crime that person didn't commit. Kind of purely there to help, so. Of course, then you got the firefighter arsonists. Those guys that are out there. It's always kind of wild to me. But I'm kind of talking about archetypes and biases that people have. They're your sort of generalizations that you go through life with. And so I think when you see a firefighter, you don't have that same negative reaction to them that you might have to a cop. Oh, this guy is used to bossing people around and, throwing them on the ground when they don't comply and doing read technique to them and stuff like that. They're not. They're a firefighter. They go into burning buildings to rescue babies. Not necessarily the best target for seeing wriggle. I'll take this up. We might get back to it if they come back, but Michigan Farm Boy, 20 minutes behind, but how would they comply? And
Jury, please.
Okay, thank you.
All right, so the court, please, your attention.
Gotta have our fan moment here.
Goes back to session and may be seated.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good afternoon. Just a few more items I'd like you to recognize. Your Honor, may I approach?
Yes.
Oh, more exhibits still. 10 wasn't enough. We need a whole big stack of them.
Showing you an envelope. Do you know what's in that envelope?
Yes, the raw data extraction of John O'Keefe's cell phone.
All right, ask it to be marked simply for identification, please.
Okay,
Exhibit A, identification.
thank you.
Second folder.
Yes, the raw data extraction of Jen McCabe's cell phone that I created.
Thank you, sir. Your Honor, ask it to be marked for identification as well.
All right,
Exhibit B for identification.
thank you.
Trooper, you shared with us that you downloaded the extraction of the phones that you identified and you made reports based on specific identified features. For example, a conversation between two people.
Yes, so I didn't do the extraction of Jen's phone, but I made those reports with the PDFs from the data extraction.
Relative to Mr. O'Keefe and the defendant's phones, you created a document that provided us the phone calls between them on January 29th.
Yes, that's correct.
And separately, you also provided a document that included all of the chats or text messages between John O'Keefe and the defendant on January
We already
29th,
established
2022.
Yes, it also included the 28th.
Thank you.
Yes.
And in that compilation, did you put together or do you create or review a PowerPoint of those?
Yes, I did.
And what was the point of that?
Just to show the texts and calls in a chronological order, because that way you're not looking at two different documents, trying to compare and contrast the calls to text messages when each is coming in.
And did you begin that PowerPoint presentation with a call at 2:16:10 on January 28, 2022?
Yes, that's correct.
And are there additional chats or text messages earlier that morning?
Yes, there's a handful starting around 9:45 a.m.
May I
Yes.
approach you, Your Honor?
Yes.
Handing you a folder, sir. Could you take a look at it? Let us know if you recognize what's in it.
Yes. So this is the bulk of this is the PowerPoint calls and text messages. And at the beginning, there's the messages from before 2:16 in the morning.
I'd like to introduce this as an exhibit, Your Honor.
Okay.
No objection, Your Honor.
All right, thank you.
Exhibit 33.
For permission, I'd ask the witness to read the text messages from the morning hours, and then we begin the PowerPoint presentation.
Okay.
Thank you, Your Honor.
Do you have a hard copy of those for me?
It was provided. I'll see if you have another copy if you don't have it.
All right, I have, it's in here, the pre-morning hours. The ones that we discussed at Sidebar. If you don't have them,
The defense has a copy for you, Your Honor.
thank you.
Madam? I'm sorry.
Thank you, Ms. Little.
Okay, thank you.
May we begin, Your Honor?
Please.
Could you first read the text messages from that morning to the jury?
Yes. Apologize if I misspell things or state things. Start time, all right. It's a little different than the format I had before. All right, this is from Karen Reed to John O'Keefe. You have really hurt me this time. This was sent at 9:49:20 a.m. on the 28th. From John O'Keefe to the defendant. I'm sorry, this has been an issue with me for 8 years. It physically hurts me to see everyone else in their life do things for them, and I'm forced to always be the bad guy. This is sent at 10:02:56 a.m. on the 28th. From the defendant to John O'Keefe, I'm not the same as everyone else. Most of the time I try to do what is healthy/smart for them. More importantly, I try to support you in what you need. You just lashed out at me and said terrible things. I don't know how you've gotten to this point with me when I'm just trying my hardest. You made your point and continue to beat me down. I have a lot going on too. Physically, I am falling apart and trying to get answers and help. 10:09:49 a.m. on the 28th. From the defendant to John O'Keefe. I am just your girlfriend. I am not a perfect parent. I'm trying very hard and sometimes treat them - nothing like I used to. 10:46 a.m. on the 28th. From John O'Keefe to the defendant. I know, I'm sorry for lashing out. I'm just hurting and struggle daily with them. Always feel like I'm failing at this parenting thing. I wasn't built for this. 10:14:12 a.m. on the 28th. The defendant to John O'Keefe. Kaylee isn't perfect, but everything wonderful about her is because of you. 12:21:36 p.m. on the 28th. From John O'Keefe to the defendant, an emoji is sent at 12:21:59 on the 28th. From the defendant to John O'Keefe, it's true, I know she's her mother's daughter, but she wouldn't be so bright and successful if she lived with anyone else. 12:22:51 p.m. on the 28th. From the defendant to John O'Keefe, wow, Kristen just sent 2 back-to-back messages to not lose your faith in the kids. 12:31:28 p.m. on the 28th. From the defendant to John O'Keefe, or in yourself, at 12:31:41 p.m. on the 28th. From John O'Keefe to the defendant, there's 2 emojis sent at 12:32:06 p.m. on the 28th. From the defendant to John O'Keefe, no, and there's 2 emojis. Life can pick you up sometimes. Please be happy with them and put away your frustrations for the rest of the day. And be so proud of yourself, JJ. That's 12:33:35 p.m. on the 28th. From John O'Keefe to the defendant, that's what bothers me more than anything. Should have sent Peg's or Sarah's W-2s. We're all equal guardians. 1:18:21 p.m. on the 28th. From the defendant to John O'Keefe, maybe you can call someone. 1:21:55 p.m. on the 28th. From John O'Keefe to the defendant, like who? 1:46:42 p.m. on the 28th. From John O'Keefe to the defendant, what time are you coming here? 1:47:38 p.m. on the 28th. From John O'Keefe to the defendant, it's another emoji sent, 2:05:30 p.m. on the 28th. From the defendant to John O'Keefe, I don't know what time, feel kind of out of it, just trying to clear my head, 2:06:07 p.m. on the 28th. From John O'Keefe to the defendant, he writes, okay, 2:06:25 p.m. on the 28th. From the defendant to John O'Keefe, text me when you guys settle in later, 2:06:44 p.m. on the 28th. From John O'Keefe to the defendant, sure, 2:06:58 p.m. on the 28th. From the defendant to, oh, and it's cut off here, sir.
Yeah. May I approach, Your Honor?
Yes.
That must be where the, so,
Would it be helpful if I take it out of the binder?
I believe it goes to the next one, so I'll start.
So they cut all those off and then started the PowerPoint at 2:16,
With the
even
court's
though that
permission,
seems
we'll
to be
begin the PowerPoint.
continuing
Yes.
a conversation that was going up until 2 o'clock. We're just hearing about stuff at 2:06.
At your leisure.
Okay. The phone calls, text messages, and then we'll start with the first slide. This is from the defendant to John O'Keefe. I feel pretty shitty about how this morning went down. I know you said sorry, but it really stung, especially when I've been trying pretty hard lately. I feel like a loser turning around, just coming back over after everything you said. 2:10 p.m. on the 28th. From John O'Keefe to the defendant, not sure what you want me to do. I said I'm sorry and I was out of line. If you prefer to stay home, I totally get it. 2:16 p.m. on the 28th. From the defendant to John O'Keefe, things in my own life have been difficult too, 2:33 p.m. on the 28th. From John O'Keefe to the defendant, I know, 2:40 p.m. on the 28th. At 2:45 p.m., the defendant calls John. The phone call is answered and they speak for 2 minutes, 22 seconds. 2:23:02 p.m., the defendant calls John. That's again answered. At 1:00, and they speak for 1 minute, 2 seconds. At 2:24:17 p.m., the defendant calls John and the call is rejected. From the defendant to John O'Keefe, tell me if you're interested in someone else. Can't think of any other reason you've been like this. 2:25:18 p.m. on the 28th. From John O'Keefe to the defendant, nope. 2:25:33 p.m. on the 28th. From John O'Keefe to the defendant, things haven't been great between us for a while. Ever consider that? 2:26:03 p.m. on the 28th. At 2:28:40 p.m., the defendant calls John. That call is rejected.
Mr. Greeno, can you explain to us the difference between not answered and rejected?
Yes, so if the call is not answered, that means the call rang out and goes to voicemail. If the call is rejected, that is someone actively hitting the send to voicemail button to disable the call to stop it from ringing. From John O'Keefe to the defendant, kids are here, not in the mood to talk. 2:29:03 p.m. on the 28th. From the defendant to John O'Keefe, so you're not into it anymore. That's fine, but I don't want to keep trying and you keep treating me like this. 2:29:12 p.m. on the 28th. From the defendant to John O'Keefe, I'm trying to hug and kiss you this morning and you whack me in the face with a pillow. 2:29:59 p.m. on the 28th. From the defendant to John O'Keefe, last night you're basically like, yeah, what about when we talk about the future? So why don't you just admit you're not into so much anymore? 2:23 p.m. on the 28th. From John O'Keefe to the defendant, not how it went down, but okay. 2:26 p.m. on the 28th. From the defendant to John O'Keefe, can you please admit your head is out of the game with us? 2:52 p.m. on the 28th. John O'Keefe to the defendant, sick of always arguing and fighting. It's been weekly for several months now. So yeah, I'm not as quick to jump back into being lovey-dovey as you apparently. 2:28 p.m. on the 28th. At 2:47 p.m., the defendant calls John. That call is rejected. John O'Keefe to the defendant, OMG, stop calling. 2:54 p.m. on the 28th. From the defendant to John O'Keefe, then why would you start with me this morning? 2:58 p.m. on the 28th. From the defendant to John O'Keefe, you're setting me up to fail. 2:05 p.m. on the 28th. From the defendant to John O'Keefe, you started a number of fights from your end. 2:26 p.m. on the 28th. And John O'Keefe to the defendant, I've explained it a few times already, not doing it again. 2:31 p.m. on the 28th. From the defendant to John O'Keefe, so you're not into this anymore. 2:41 p.m. on the 28th. From John O'Keefe to the defendant, not into fighting all the time, correct. 2:34:03 p.m. on the 28th. From the defendant to John O'Keefe, if you tell me you're interested in someone else, you will never hear from me again. You can have all the space in the world. 2:34:11 p.m. on the 28th. From John O'Keefe to the defendant, he sends an emoji. 2:34:19 p.m. on the 28th. From the defendant to John O'Keefe, then stop starting with me. 2:34:20 p.m. on the 28th. 2:34:29 p.m. The defendant calls John. He rejects the call. John O'Keefe to the defendant. I'm not answering. Stop calling. 2:34:42 p.m. on the 28th. From the defendant to John O'Keefe, can you please answer after how you treated me earlier? 2:34:43 p.m. on the 28th. 2:34:54 p.m. The defendant calls John. That's rejected.
Seen a lot of
John O'Keefe
stonewalling
to the
here.
defendant. Kaylee is right here. 2:35:02 p.m. on the 28th. The defendant to John O'Keefe. You start a rager with me out of nowhere and then tell me you're sick of fighting with me. 2:35:41 p.m. on the 28th. The defendant to John O'Keefe. I'm going to grab a drink in a bit. 2:38:14 p.m. on the 28th. 2:38:42 p.m. The defendant calls John. That call is rejected. The defendant to John O'Keefe, can you please answer? 2:38:52 p.m. on the 28th. From John O'Keefe to the defendant, no, Karen, not sure why you need to announce that you're going, not sure why you need to announce that you're grabbing a drink, but have fun. 2:39:46 p.m. on the 28th. From the defendant to John O'Keefe, seeing if you want to meet me later. 2:40:22 p.m. on the 28th. From the defendant to John O'Keefe, can you please call me? 2:40:32 p.m. on the 28th. From John O'Keefe to the defendant, have to take them to the doctor. He has practice. 2:40:55 p.m. on the 28th. From the defendant to John O'Keefe, yeah, 5 minutes. 2:41:17 p.m. on the 28th. At 2:43:01 p.m., the defendant calls John. It's not answered. At 2:43:45 p.m., the defendant calls John. The call is rejected. John O'Keefe to the defendant. My father just walked in. 2:43:58 p.m. on the 28th. The defendant to John O'Keefe. Okay, can you please call me for 2 minutes? 2:44:14 p.m. on the 28th. John O'Keefe to the defendant. Not right now. 2:44:23 p.m. on the 28th. The defendant to John O'Keefe. I'm there when anyone else needs me. 2:44:26 p.m. on the 28th. At 2:45:32 p.m., the defendant calls John. The call is rejected. The defendant calls Mr. O'Keefe. Yes, John, you gave me utter grief this morning. I'd like you to call me for a minute. 2:46:16 p.m. on the 28th. The defendant to John O'Keefe. I've been trying to get over the hump with is arguing, and now you tell me you're not into doing things, and you don't want to fight weekly, but fly off the handle at 8 a.m. with me, like you're setting me up to fail. 2:47:08 p.m. on the 28th. The defendant to John O'Keefe. I've been dealing with my own personal crisis over things I have zero control over. I'd like to lean on you too sometimes. Instead, I just hear everything I've done wrong. 2:48:34 p.m. on the 28th. At 2:56 p.m., the defendant calls John. The call is rejected. At 2:51:13 p.m., the defendant calls John. It's rejected. 2:52:37 p.m., John calls the defendant. It's not answered. At 2:53:56, the defendant calls John. Again, not answered. The defendant, John O'Keefe, you seriously cannot pick up the phone for 2 seconds. 2:54:13 p.m. 2:58:05 p.m., the defendant calls John. It's rejected. At 2:59:13, John calls the defendant. The call is answered and they speak for 4 minutes, 59 seconds. From the defendant to John O'Keefe, why don't you meet me at Hillside at 4:30/5, 3:08:55 p.m. John O'Keefe to the defendant sends an emoji at 3:10:08 p.m. on the 28th. From the defendant to John O'Keefe, or whenever you get everyone settled, 3:10:35 p.m. on the 28th. From John O'Keefe to the defendant, like I said, doctor now, and he has practice till 6. If you want to go start drinking, then go for it. 3:36:21 p.m. on the 28th. The defendant to John O'Keefe, I didn't know the times of his practice. 3:36:40 p.m. on the 28th. The defendant to John O'Keefe, I just want to give you space at the house without me there. So rather meet you out than meet at the house. 3:37:01 p.m. on the 28th. John O'Keefe to the defendant, yeah, well, now there's a 72-year-old taking up shop on my couch. 3:37:36 p.m. on the 28th. The defendant to John O'Keefe, yeah, that too. 3:37:46 p.m. on the 28th. From the defendant to John O'Keefe, is he going to Collins? 3:38:23 p.m. on the 28th. John O'Keefe to the defendant, not tonight. 3:38:32 p.m. on the 28th. From the defendant to John O'Keefe, so do you plan on going out tonight? 3:39:01 p.m. on the 28th. From John O'Keefe to the defendant, Karen, I don't know. 3:39:17 p.m. on the 28th. John O'Keefe to the defendant, you're like jonesing to drink, so go. 3:39:43 p.m. on the 28th. From the defendant to John O'Keefe, okay, well, after how this morning went down, I don't think I need to be back over there with you. Get frustrated at how I am with the kids. Has nothing to do with drinking. 3:40 p.m. on the 28th. From the defendant to John O'Keefe, I am paranoid now that everything I do with them is problematic. So rather see you for a minute without it, kids around. 3:40:24 p.m. on the 28th. From John O'Keefe to the defendant, what's your plan at 4:47:16 p.m. on the 28th? From the defendant to John O'Keefe, don't have one. 4:50:09 p.m. on the 28th. From John O'Keefe to the defendant, so still home. 4:50:26 p.m. on the 28th. The defendant to John O'Keefe, yes. 4:50:45 p.m. on the 28th. From John O'Keefe to the defendant, we just got home, waiting to see what Papa decides here, or else I have to get Patrick at 6. 4:59:45 p.m. on the 28th. The defendant John O'Keefe, okay. 5:01:55 p.m. on the 28th. John O'Keefe to the defendant, so are you staying home or coming here? 5:02:23 p.m. on the 28th. From the defendant to John O'Keefe, waiting to see what you end up doing. I don't want to hang out at the house too much, like I said. 5:03:40 p.m. on the 28th. From the defendant to John O'Keefe, I think it's clear me around the kids, I think it's clear me around with the kids around is slowly killing our relationship, and our relationship is much more important to me. 5:04:16 p.m. on the 28th. John O'Keefe to the defendant, well, there's a blizzard coming, so we'll be inside all weekend. 5:04:19 p.m. on the 28th. The defendant to John O'Keefe, it will be over by noon tomorrow. 5:04:44 p.m. on the 28th. John O'Keefe to the defendant, don't think so. 5:05:27 p.m. on the 28th. The defendant to John O'Keefe, I don't want to keep having this constant conflict of the dynamic of the four of us. The harder I try, the more it kills our relationship as a couple. It feels like utter shit to be in that position. Rather just meet you out for drinks when you figure out what your night looks like. 5:06:45 p.m. on the 28th. John O'Keefe to the defendant, well, I have no idea what's going on, so do what you want. 5:07:34 p.m. on the 28th. John O'Keefe to the defendant, need to figure out what everyone here is doing. All I know now is Madeline is coming over. No clue about Patrick yet, or if Papa is planning on hanging it for a few more hours. 5:29 p.m. on the 28th. From the defendant to John O'Keefe, okay, well, when you know the story and if you want me to come up, let me know. 5:36 p.m. on the 28th. John O'Keefe to the defendant, no, Karen, you decide what you want to do. 5:18 p.m. on the 28th. From the defendant to John O'Keefe, I know your heart isn't in this anymore. I felt it for a while and especially lately. I'm willing to try more, but not if you approaching the point of indifference. If you want me to come up and you can head out for a while, then say so when you know what your father is doing. 5:23 p.m. on the 28th. John O'Keefe to the defendant, you come up and I head out, really? Emoji. 5:48. John O'Keefe to the defendant, I've told you already, I don't bounce back as quickly as you do after we have a battle. 5:52 p.m. on the 28th. From the defendant to John O'Keefe, no, head out together with an emoji. 5:49 p.m. on the 28th. From the defendant to John O'Keefe, or meet out. 5:54 on the 28th. John O'Keefe to the defendant, gonna send Patrick to Collins tonight. They're picking him up around 7. Mike may hang out too when he brings Matt over. So why don't you just come over? 5:42 p.m. on the 28th. From the defendant to John O'Keefe, Mike doesn't want to go out for a bit. 5:20 p.m. on the 28th. From the defendant to John O'Keefe, I would like to, been a shit day from the jump. 5:33 p.m. on the 28th. From John O'Keefe to the defendant, probably 5:39 p.m. on the 28th. From John O'Keefe to the defendant, I just got sober an hour ago. 5:56 p.m. on the 28th. From the defendant to John O'Keefe, I'll text you, hang with Mike for a few. I don't need to butt in. Text me if/when you think you may head out. 5:12 p.m. on the 28th. From the defendant to John O'Keefe, can you send me Tim Zoll's contact info, please? 5:38 p.m. on the 28th. John O'Keefe to the defendant, I paid the last bill. 5:27:08 p.m. on the 28th. From the defendant to John O'Keefe, you didn't have to do that, thanks. 5:27:43 p.m. on the 28th. From the defendant to John O'Keefe, are you really not going to accept my friend request? 5:33 p.m. on the 28th. From John O'Keefe to the defendant, an emoji on what, FB? 5:33:01 p.m. on the 28th. From the defendant to John O'Keefe, yeah, we've been going out for 2 years. 5:33:20 p.m. on the 28th. John O'Keefe to the defendant, I haven't gone on. You defriended me over a year ago, I believe. 5:33:48 p.m. on the 28th. From the defendant to John O'Keefe, Kerry texted that they're headed out in a bit. 6:05:29 p.m. on the 28th. From John O'Keefe to the defendant, okay, 6:14:55 p.m. on the 28th. From the defendant to John O'Keefe, she's going to let me know where. 6:17:51 p.m. on the 28th. From John O'Keefe to the defendant, so you're going to meet them. 6:18:12 p.m. on the 28th. From the defendant to John O'Keefe, just presenting it as an option. Wouldn't mind hanging out with them for a drink. 6:19 p.m. on the 28th. Sorry. From the defendant to John O'Keefe, is Mike over? 6:27:26 p.m. on the 28th. From John O'Keefe to the defendant, yes. 6:29:45 PM on the 28th. From the defendant to John O'Keefe, sounds you're like good with getting together tonight. 6:31:32 PM on the 28th. From the defendant to John O'Keefe, was hoping after this morning you'd be interested in smoothing things over with me. 6:32:24 PM on the 28th. John O'Keefe, the defendant, told you to come over, but you insisted on meeting me out somewhere. 6:33:44 PM on the 28th. From the defendant to John O'Keefe, Mike is a little off with me for a while now. I've said that multiple times. 6:34:34 PM on the 28th. From John O'Keefe to Karen, the defendant, time to get over it, Karen. He's fine. He was fine the other night when he came by. 6:38:09 PM on the 28th. From the defendant to John O'Keefe, yeah, wouldn't mind hanging out with other people, like another female too. 6:39:09 PM on the 28th.
I thought she was
From
keeping
John
John away
O'Keefe
from
to the
women.
defendant, where are you meeting them? 6:39:28 PM on the 28th. From the defendant to John O'Keefe, I don't have plans with them. She just said they're headed out in a bit and will text when they land somewhere. 6:39:52 PM on the 28th. From the defendant to John O'Keefe, if you want to go out with Mike solo, that's fine. Just let me know. 6:40:17 PM on the 28th. From John O'Keefe to the defendant, I already told you what you should do. Not going to keep doing this. 6:41:07 PM on the 28th. From the defendant to John O'Keefe, I asked to let me know if you guys are going to head out. I haven't been out for drinks this week and had a shit week and a shit day. And I dread Kaylee or Pat is going to get chatty with me the second I walk in, and that is going to irritate you. 6:43:21 on the 28th. From John O'Keefe to the defendant, Pat is leaving, Kay is with Mad Cam. 6:44:02 PM on the 28th. John O'Keefe to the defendant, I'll text Chris then. 6:46:44 PM on the 28th. John O'Keefe to the defendant, we're headed out shortly. What's your plan, Karen? 7:06:13 PM on the 28th. From the defendant to John O'Keefe, do you want me to join or no? 7:06:37 PM on the 28th. From John O'Keefe to the defendant, yes, wasn't sure if you were meeting the Currans. 7:07:04 PM on the 28th. From the defendant to John O'Keefe, they are not out drinking yet. 7:07:40 PM on the 28th. From the defendant to John O'Keefe, where are you headed? 7:09:22 PM on the 28th. John O'Keefe to the defendant, trying to decide maybe McCarthy's. 7:14:48 PM on the 28th. From the defendant to John O'Keefe, okay then, let me know where you decide. I'm still down in Enfield. 7:21:50 PM on the 28th. From John O'Keefe to the defendant, text me when you leave. Still waiting on McKinney's. 7:22:28 PM on the 28th. From the defendant to John O'Keefe, I'm having issues with my hot water, so had to text someone to take a look. 7:24:11 PM on the 28th. John O'Keefe to the defendant, an emoji, you trying to piss me off. 7:25:35 on the 28th. John O'Keefe to the defendant, hope your plumber buddy that you texted is hot. 7:26:24 PM on the 28th.
Jealousy.
From the defendant to John O'Keefe, nope, my shower only got lukewarm and now my sink won't run hot at all. The plumber I used is right down the road. 7:26:27 PM on the 28th. From the defendant to John O'Keefe, I turned that temp thing in the basement all the way up. 7:26:52 PM on the 28th. John O'Keefe to the defendant, check the hot water heater and see if it's leaking. 7:26:52 p.m. on the 28th. The defendant to John O'Keefe, it's not. 7:26:59 p.m. on the 28th. John O'Keefe to the defendant, don't do that. 7:27:01 p.m. on the 28th. John O'Keefe to the defendant, is the pilot lit? 7:27:08 p.m. on the 28th. From the defendant to John O'Keefe, I was trying to get my shower hot. 7:27:12 p.m. on the 28th. From the defendant to John O'Keefe, yes. 7:27:14 p.m. on the 28th. From John O'Keefe to the defendant, don't turn it up. Don't turn it all the way up. 7:27:26 p.m. on the 28th. John O'Keefe to the defendant, it will burn out. 7:27:32 p.m. on the 28th. From the defendant to John O'Keefe, I had this issue twice before and it wasn't a disaster. I just can't remember what the cause was. 7:27:41 on the 28th. From John O'Keefe to the defendant, just turn it back to where it was and get over here. 7:28:08 p.m. on the 28th. From the defendant to John O'Keefe, I don't want to come home in a blizzard and then really be up shit creek. 7:28:53 p.m. on the 28th. John O'Keefe to the defendant, so you're going home tonight. 7:29:18 p.m. on the 28th. From the defendant to John O'Keefe, or tomorrow or whenever. I've had a chill all day since my shower. 7:29:45 p.m. on the 28th. From John O'Keefe to the defendant, it's going to snow all day tomorrow, no driving. 7:30:05 p.m. on the 28th. From John O'Keefe to the defendant, we're headed to McCarthy's. 7:41:29 p.m. on the 28th. From the defendant to John O'Keefe, okay, let me know if you end up leaving. 7:41:57 p.m. on the 28th. From John O'Keefe to the defendant, why? Now you're not coming. 7:42:27 p.m. on the 28th. From the defendant to John O'Keefe, I'm waiting for the plumber. I actually think he's in the driveway. 7:42:56 p.m. on the 28th. From John O'Keefe to the defendant, we're taking Mike's car, so I'm relying on you for a ride home if he leaves. 7:43:10 p.m. on the 28th. From the defendant to John O'Keefe, he's not going home after. 7:43:27 p.m. on the 28th. John O'Keefe to the defendant, 8 o'clock on a Friday, emoji. 7:43:31 p.m. on the 28th. John O'Keefe to the defendant, he may have to get Michael. 7:43:46 p.m. on the 28th. John O'Keefe to the defendant, you have a plumber coming over at 8. Knowing me and Papa could have handled it. Good luck. 7:44:36 p.m. on the 28th. From the defendant to John O'Keefe, I have always told you I will not put either of you out of your way the way everyone else in your life does. I knew it wasn't working right when you were at the doctor's with Kaylee, and I knew neither of you could get here. And this guy, Richie, fixed it last time, whatever it was. He was supposed to be here at 5, 7:48:01 p.m. on the 28th. From the defendant to John O'Keefe, if it's not a quick fix, I'll tell him to forget it. 7:48:20 p.m. on the 28th. John O'Keefe to the defendant, if you need a new water heater, don't let him do it. 7:55:04 p.m. on the 28th. The defendant text from the defendant to John O'Keefe, he's here now. If it's not quick, I'm not doing it. I just want to make sure nothing is wrong / will go wrong with when I'm not home. 7:55:44 on the 28th. From the defendant to John O'Keefe, he's not a scammer. Half the quick stuff he doesn't even charge me for. 7:56:06 p.m. on the 28th. From the defendant to John O'Keefe, he just put the toilet seats on crooked. 7:56:28 p.m. on the 28th. John O'Keefe to the defendant, status. 8:09:02 p.m. on the 28th. From the defendant to John O'Keefe, still here with an emoji, 8:09:18 p.m. on the 28th. From the defendant to John O'Keefe, said he's got to go to HD and probably be back mañana, 8:23:56 p.m. on the 28th. From John O'Keefe to the defendant, so 8:24:43 p.m. on the 28th.
So, well,
From the defendant to John O'Keefe, an emoji, 8:25:02 p.m. on the 28th. From the defendant to John O'Keefe, just trying to figure out if I need to be here, 8:25:51 p.m. on the 28th. From John O'Keefe to the defendant, what does it need, 8:26:01 p.m. on the 28th. From the defendant to John O'Keefe, I don't know. He showed me some pieces that was all rusted with an emoji. I don't understand half this stuff, 8:26:42 p.m. on the 28th. John O'Keefe to the defendant on the water heater, 8:26:59 p.m. on the 28th. From the defendant to John O'Keefe, yes, 8:27:08 p.m. on the 28th. From John O'Keefe to the defendant, tell him to leave it. I'll take care of it Sunday or Monday, 8:28:30 p.m. on the 28th. From the defendant to John O'Keefe, no, it's okay. I can either meet him here or just shut off the alarm, 8:28:52 p.m. on the 28th. From the defendant to John O'Keefe, he used to work here while I was at work, 8:29:02 p.m. on the 28th. From John O'Keefe to the defendant, does he realize it will be whiteout conditions tomorrow a.m., 8:29:32 p.m. on the 28th. From the defendant to John O'Keefe, yeah, but he lives right down the road, 8:29:47 p.m. on the 28th. From John O'Keefe to the defendant, Karen, this storm is going to be intense, can't drive, 8:30:19 p.m. on the 28th. From the defendant to John O'Keefe, okay, well, if he can't, he can't, 8:30:36 p.m. on the 28th. John O'Keefe to the defendant, I'll do it Monday, 8:30:56 p.m. on the 28th. From the defendant to John O'Keefe, I better not still have this problem on Monday, 8:31:22 p.m. on the 28th. From John O'Keefe to the defendant, you plan on being there, 8:31:43 p.m. on the 28th. From the defendant to John O'Keefe, I'd to know I can take a hot shower there here if I need to, 8:32:14 p.m. on the 28th. Figured you'd be, from John O'Keefe to the defendant, figured you'd be in Canton until Monday, 8:32:32 p.m. on the 28th. From John O'Keefe to the defendant, I'm getting off my phone. Let me know what you're doing, 8:32:54 p.m. From the defendant to John O'Keefe, I think the four of us together is toxic to this relationship. Would like to limit it, 8:33:16 p.m. on the 28th. From the defendant to John O'Keefe, you said so yourself for probably a year now, 8:33:52 p.m. on the 28th. John O'Keefe to the defendant, blizzard tomorrow, nobody is going anywhere, 8:33:56 p.m. on the 28th. From the defendant to John O'Keefe, maybe I'll come back late tonight. Bad snow is in the early a.m., 8:35:14 p.m. on the 28th. From the defendant to John O'Keefe, I'll head up there in a few min. Let me know if you leave, 8:35:26 p.m. on the 28th. John O'Keefe to the defendant, an emoji, he says sure, 8:35:34 p.m. on the 28th. And that was the last of them.
we'll have some chit-chatting at the break about these. Remember the patterns we talked about yesterday? Patterns, guys.
We're almost done, sir.
And you can feel free to stand.
Okay, thank you, Honor.
So that presentation is a compilation of text messages and phone calls between John O'Keefe and the defendant on January 28, 2022.
Yes, that was.
Aside from that compilation, are there other text messages and phone calls that you've reviewed between John O'Keefe and the defendant that evening, January 28, 2002, going into past midnight, January 29, 2022.
Yes, there's more text messages.
And those text messages and phone calls, are they a separate compilation from this?
Yes, that's correct.
All right, at this time, I'd ask us to release Trooper Gaarino and recall him at a later date.
Yes, all right. There's no objection, Mr. Alessi, correct?
No objection.
We're gonna keep doing this.
Yes. All right. Thank you very much, Trooper. We'll see you another time.
Thank you, Your Honor.
You just leave it. Okay.
Is this the time for me to see counsel at sidebar? Okay. Yes.
Your Honor, I'm going to introduce exhibits or clips 7 through 11.
Thank you.
With the court's permission, could I begin with clip 7?
Yes.
When you walked out of the bar, how many drinks had you had?
I had probably about 4, and not 4 that I completed either. I didn't drink maybe more than a few sips at the Waterfall.
And 4 drinks you felt fine to drive?
Yep.
Clip 8, please.
Okay.
And is the level of intoxication pretty high here for everybody?
It's happy.
Yeah.
It's
You had a lot to drink, right?
I wouldn't say I have like a normal amount. Let's say like a vodka tonic every 40 minutes.
Okay. And so are you feeling like buzzed? And I'm not judging, I'm just trying to get a
Yeah,
sense.
buzzed.
Yeah.
Clip 9, please.
The final count of my alcohol intakes, probably about 5 or 6 or 4. The drinks that they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest vodka tonic. It tasted just like all soda water with lime. Not that I need it to be a martini, but it might have had a splash of vodka in it. So I said, John, this drink tastes like it has no vodka in it. He said, just get a shot and mix it yourself. So each drink was being counted as a double. So I would get a vodka tonic and then I would pour a shot into it. So that would count as 2. Frankly, it just felt like a regular cocktail. It was just a really weak pour. So I asked for a shot. So for my taste, it just tasted like that's the normal strength of what a drink should be. So I had maybe 2 or 3 that are being counted as 4 and 6. And I don't know. I felt fine. I felt like I was buzzed. And then there was one drink, the last one that was given to me, which I would have counted as 3, but they're counting as my 6th cocktail. The guys that we were with brought around the shots, and they gave me one that I didn't drink, but I poured it in my drink. So that's now my 5th and 6th drinks, with the 7th, which is a shot that all the men did, and I poured it. So that one glass that I'm holding, that I go into the Waterfall with, has 3 drinks in it, a vodka tonic and 2 shots. And which is why John said to me, you're not leaving that drink here, like you haven't touched it and just poured a bunch of vodka, like just take it with you, which was something he always did. So then I go into Waterfall and I put that drink down and I socialize most of the time. So that would have been my 5th, 6th, and 7th drinks. Then John orders me a drink at the Waterfall that I don't drink, that he takes with him. And then there was a round of shots that Chris Howard bought that I did take. So that would have been the night. But I did not consume 9 vodka martinis or take 9 shots, depending on how you count it. And the last 2 drinks I didn't touch.
Clip 10, please.
as I would be if I hadn't been drinking. I mean, I had drank, so, and that led me to question, like, could I have hit him? Did I run over his foot or hit him in the knee? Did I incapacitate him? I mean, I always drive with my music blasting ever since I was 16. And I know when John got out of the car to go into Fairview, I know my car was blasting because when I got in it the next morning to go look for him, I had to immediately turn it down. And I don't know, it's stormy. I have had a few cocktails. I didn't black out, but I wasn't as lucid as I would have been if I had gone to bed at 9 and drank a tea. But so I was fuzzier than I would have been if I had had no alcohol.
Clip 11, please.
How did you feel after that many drinks? When you got in the car, did you feel like you could survive? And did you feel how
I wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15 on January 29th. I mean, it was quiet. The roads were very quiet. You can see it on the videos. And I was going, you know, when I've had a few drinks and I drive, I always drive extra slow. So I know my alerts aren't as sharp as they should be. But I shouldn't have been driving. But I don't think I was driving. I know I wasn't driving recklessly. I mean, I've got plenty of video of myself driving all over the place. I put my car in John's garage, which is incredibly narrow, and I had a very oversized SUV. You see me, there's a video of me driving through the intersection when we leave Waterfall to go to Brian Albert's, and I was always taught by my father, even when you have a green light, you always should tap the brake. You don't know who's going to run red. And I see me doing that multiple times between 12 and 1 and 5 and 6 a.m. So I know I was driving safely, not as safely or as alert as I would be if I had no alcohol. But I was not driving recklessly by any measure.
Thank you. Your may we approach?
Yes.
So that all seemed to me to be pretty consistent and, you know, not particularly bad. I think we're acknowledging the drunk driving. I mean, yeah, she probably would blow. I don't know. But, you know, we had a conference once where we tested the back then it was the Data Master. Now they use some different machine, the Draeger machine. But it's all basically the same thing with the test that you blow at the police station. And so we did a demo. We had somebody sit and take shots, wait like 10 minutes, blow, take shots, wait 10 minutes and blow. You watch it go up. Like by the second drink, you're over the limit. So she would have blown over. Doesn't mean she hit John.
Jurors,
And we do see her on
there's
video.
some confusion with counsel regarding witnesses. So those are the witnesses for today, so we're done for today. Counsel assures me that won't happen again, but more importantly, we're on track. We're on schedule, not going for the rest of the day, won't interfere with our schedule at all. It looks like it's, I can't tell with all the curtains here, but it looks like it's a beautiful day. You'll have a nice afternoon. Tomorrow we'll be going on a view. So for that, we're comfortable close. We'll be walking around a little bit. We'll be going by bus, and I'll have more instructions for you tomorrow morning. But please follow those instructions. Do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, read anything about this case, please disregard it and let us know. And we'll see you tomorrow morning. Remember, tomorrow's a holiday.
All rise for the court, please. Close your notebooks and follow me.
So what was the confusion? Why didn't the Commonwealth schedule more witnesses for today? Thursday, there's no confusion about ARCCA or anything like that. They just didn't schedule anyone else for today? We're going to have a lot of time to talk about those text messages, aren't we? I kind of thought they would come back if I didn't move away from the fan.
jury has exited the courtroom.
All right.
Seated.
Mr. Brennan, have you had an opportunity to think about whether experts should be permitted to either be present or watch the proceeding? And I also want to know, are you expecting to put on any expert testimony tomorrow?
Dr. Fowler will testify tomorrow. I think that should be considered expert testimony. He provides the procedures and protocol for the testing of blood serum.
Okay.
So I think he's technically considered an expert, although one of the briefer ones.
All right. Does the defense want an expert to be able to watch that? All right. So I know we've had a lot going on this morning. Do you want to address this tomorrow? When do you want to address whether experts should be present?
If I can address it tomorrow morning, I can consider
All right.
it.
We'll do that. And have you talked about who you all mean? Like, do you all know who you want to have exempt from the sequestration order?
We haven't got to that detail. I'm sure they have in mind who they want. I haven't gotten to that point yet.
All right.
We can have that discussion and so that we can present it tomorrow what my position is and address the court on the witnesses.
Ridiculous.
Sure, we can do that. And then I know you
Ridiculous.
said that you've got an agreement that you'll provide witnesses or a list of witnesses in advance to defense counsel, and I'm sure you'll provide witnesses in advance to Mr. Brennan. Include me on that, please. I just like to know
Very
who's
well.
coming up the next day because I have to prepare as well.
Happy to. Thank you.
Okay? All right. So we'll see you tomorrow morning.
Thank you again.
All rise.
Okay, well, so tomorrow they're going on a view, and the scheduling is confusing. So it sounds like we're having Dr. Fowler in the morning. The reason why they're doing a half day is because then they're going on the view, but they haven't really spelled that out. Oh, they cleaned the cobweb. Oh, bless them. Somebody was watching my stream, maybe. No, I doubt it. But good for them for getting that cobweb cleaned off. Just going to leave it up on the off chance that they come back for something. What's with the scheduling? What's there to be confused about with the scheduling today? Just a random sudden half day? I don't know. Are we getting Dr. Fowler and then they're going on the view and then they're done? This is very, very confusing about what to expect for those of us that are watching. I'm going to finish one thought in my notes here. Okay. Well, I guess we're going to have a long afternoon today, guys. I'm not going to complain about that at all. Got plenty of catching up to do. Before we get back to your comments and questions, let's talk about these texts, guys. So remember what I said yesterday. Think about patterns. Think about patterns in relationships because that's how they tend to perpetuate. If you grew up seeing healthy relationships, bonding, support, people feel emotionally safe, then that's what you learn. And that's how you tend to mimic in your future relationships because that's what's normal. With children in development, it's really all about normalization. You see that to the extreme when you're dealing with CPS, kids that go into foster care, things like that. Very, very dysfunctional situations. You see the counterpoint to that because humans are so amazingly adaptable. They can adapt to, just about anything. And, kids learn that some pretty appalling stuff is normal. That's kind of how this cycle gets perpetuated. What's normal to you? So when we talked about this yesterday, we pointed out, this is technically a domestic violence crime. This is somebody alleged to have murdered their intimate partner. That's domestic violence. Okay, they've killed the feed, so I'm going to go ahead and just take it completely down so it doesn't maybe go live and start yelling at me. And so I pointed to certain patterns of behavior, certain things that I saw that look, potentially problematic, things that are patterns that we might want to bear in mind as we're evaluating this pattern between John and Karen in light of how the Commonwealth is alleging that this pattern culminated. They're alleging this culminated in a murder by Karen. And so with that, let's go back to the text messages and what I see in these text messages, just my opinion. I'm not the only one with an opinion, the only one entitled to an opinion. I'm not authoritative. It's just my thoughts. So take them with however much value you think they have. I see one person basically begging for attention and concern. Care about me, please, John. I see one person trying to make an effort to reconcile, but needing to be heard and understood for that to be effective. And I see one person stonewalling, refusing. Not going to do that. We're going to do it my way. That's what I see. I don't see at any point in this message chain John reaching out, trying to empathize with Karen. Yeah, I can see where you're coming from. I don't see anything in this text message exchange where John is taking accountability for how he behaved in the morning. Oh, there's that. I'm sorry. Very, very early on. And then he excuses it, doesn't he? It's just, this has been a thing for me for a long time. It's a soft point. I'm so used to seeing everybody else do nice things for them, and I always have to be the bad guy. It's not my fault. This is somebody who can't acknowledge their own shortcomings. Can't take responsibility for, apparently going off. I'm sorry, but here's why it's not such a bad thing that I did it. And then expects that to be definitive, because when Karen is coming back and saying, I don't feel heard, I don't feel understood, I'm not sure that you get why this is a problem for me. What does she get? She gets dismissed. Well, I already told you I'm sorry. I don't know what else you want. You have one person refusing to give and one person that is desperate to get it. That is like the classic definition of a toxic relationship. Somebody is not getting their needs met. They are desperate to try to get their needs met. One person is refusing to meet the other person's needs, and they just get locked in this toxic battle of I'm trying to make this work. I'm sort of withdrawing when it's not going the way that I want it to, and you can deal with it or not. It's up to you. Refusing to give. And so there's some patterns in here that I kind of tend to see. Just the dismissiveness towards her. You don't matter. You don't count. Where did we hear that from also? Oh, we heard that from Peggy O'Keefe, didn't we? Why is she here? This is her boyfriend of 2 years who was just found by her unconscious and maybe dead in the snow. Why wouldn't she be there? But no consideration of her experience in that moment, what she's going through. Just a pattern, guys. You got to wonder. You got to wonder. When I look at these texts and I look at this relationship, I see one that's trying to appease and one that's not. And that's not definitive by any means about, who's playing what role in this relationship, but it's pretty strong correlation. Don't see Karen being the abuser here. Karen is the one trying to heal. John is the one who is inflicting emotional harm by name calling, going off on her, giving her a hard time because she's doing nice things for the kids. John is the one who is making excuses for his behavior. John is the one who is then stonewalling, refusing to take accountability. That's what I see, guys. That's the pattern that I see. Interested to see what you guys think. I guess I'll go ahead and get the batter down because we're done with Nicholas Carino. I remember that from the last trial. I remember reading these texts thinking, wow, this isn't how I would expect. She wants to call him and he keeps rejecting the call. He'll text with her. You know, he'll dry text with his eye roll emojis, but he won't pick up the phone and talk it out. Just rejected call, rejected call, rejected call. You know how that feels to somebody who's like, yeah, I'm trying to reach out to you. I'm trying to reconcile. I'm trying to heal. I need something from you. And you're just flat out refusing. Yeah, that someone is not going to feel very cared for. That someone is not going to feel very secure, very safe. That's what I see. Let's take a look at your comments now. This one we were just starting to get to, but then we paused. Michigan Farm Boy, 20 minutes behind, but how would they comply in a day to something this broad? How would they have their lawyers vet this in time with a scheduling conflict and over the weekend while finishing testing and writing a report? Crazy. This is going to that ARCCA order. All of the stuff that they have to turn over by Monday. So they have, the order was signed on April 22nd. So on Tuesday. So they had, and they're supposed to do it by tomorrow. So 3 days, really kind of less than, because they would get it late on Tuesday at best. And their production deadline is by 9 a.m. on Friday. So 2 days to go get all of this together. How are they supposed to do that? Great question. Great question. Drop everything and do this. Why? Because I'm the judge and I say so. No, it doesn't seem like a particularly reasonable, realistic, or accommodating type of timeline. It looks to me like a deadline that you know, you're making it hard to meet. Talk about setting up to fail. Looks like a deadline that's set up for them to fail. Because what? They have to rush and get it done in 2 days. Then there's going to be a risk that something's overlooked. As soon as something's overlooked, now what? You didn't comply. You didn't comply. I'm going to sanction you. This is a power move, is really what it is. She's setting it up so that she has that leverage. That's how I see it. She wants to have the power and the ability to keep ARCCA out, so she is looking for ways that she can make that happen. ABA rule was the tell. I don't know how they get it to their lawyers. The lawyers are also supposed to drop everything. Like, they know this isn't, they know this isn't realistic, but they're going to do it anyway. Nick Starrow, introducing surveillance instead of Proctor or Bukkake. Well, they're just laying the authentication for it, so that we know that it's valid. And I don't have a problem with that. I think that that's appropriate. That's the way to do it. What it actually shows that's going to be, Proctor or Bukkake like it was last time. I said Bukkake. Buchanan. It's going to be Proctor or Buchanan like it was last time. Last time it was Buchanan. Going through, watching, doing the drink count. I watched. I didn't see his count, so didn't add up to me. We'll see it again probably. But the defense is going to have the same opportunity too, right? They've already highlighted the waterfall video. There's a disturbing incident at the end with Brian Higgins. Told us about that in opening. So it benefits both of them. They get to use the video for their own purposes and show the parts that they think are significant to the jury. And they need to ask every witness if they have lost their significant other. Get the jury to start thinking why she was this way and how would others who haven't acted or not. Karen acted normal. I'm generally never a fan of the ask every witness something, strategy. I mean, I get the point. I get what you're getting at. But no, it isn't necessary. They just do need to have some way of making the point that everybody is going to react differently. In some ways, the evidence kind of already tells us that. It already shows us that. We can watch the scene at 34 Fairview and see how different the reactions are. The way that Karen is running around, she's screaming. Kerry's making phone calls. Jen is kind of standing around and talking to the cops. They have very different reactions to it. So we can kind of look and see that there's a wide range of normal. But if this jury is if they're empathetic people, by and large, just like they can watch Michael Camerano on the stand, and think, wow, I really feel for this guy. Or just like they might be able to look at somebody like Derek Whitley and think, wow, he seems like a really nice firefighter, a real hero. Wonder why they're being so mean to him. This is like so, just saying they might. They can also watch these videos and they can put themselves in Karen Reed's shoes and they can imagine the horror, the frustration, the just disbelief. So I think some of that really speaks for itself. You don't have to hammer a lot of this stuff home, because some of this just it is common sense. It's common experience. So a lot of that you can just address in your closing. Ladies and gentlemen, the Commonwealth wants you to draw a lot of assumptions from what Karen Reed said, but you saw the state that she was in, and you can understand why she would be in that state given what she'd gone through. You don't really need a witness to make that point. So, but I do understand the point that you're getting at in terms of, getting the jury to think about what she went through. But I think the videos accomplish that. I really do. Tin Cat, playing the clip this morning instead of after Peggy's testimony took out most of the sting. The point is the theatrics of it. I think this is a very good point. It did mess up the timing because the whole point was supposed to be Peggy O'Keefe is on the stand. She's upset. She's distraught. We're feeling her pain. We're empathizing with her. And then we have this counterpoint of Karen up there making her, caricature of Peggy face. He looks like he was hit by a car. And that's what the point was supposed to be, was the contrast, not so much what Karen was saying. It was how she was saying that and how that contrasted with what they just saw with Peggy O'Keefe on the stand. So I definitely agree with this. I think it would have been a very different situation had they played the clip yesterday right after Peggy testified. By doing it today, that's already faded a little bit, and it's just not as stark that contrast. The jury already has that information about Peggy that they're putting together. It isn't just what Peggy herself showed us and said on the stand, but also the things that we heard from Kerry. You know, we have a fuller picture of Peggy O'Keefe. And so that's all kind of starting to coalesce the further you get from that moment where it's just that is right there in your face, Peggy O'Keefe and how she behaves in her grief. A little bit of a win for the defense on that one. Greg, to be fair, Andrea, Mike Camerano was very emotional last trial as well. Yeah, he was definitely emotional. I don't think that that's wrong at all. I think my read, and I could be totally wrong about this. I'm just saying this is my general vibe, my vibe check. But I could be off. It's just my vibe was that he was more helpful last time. He was more interested. His vibe was more like, I'm here to help. I'll tell you what you want. And this time it's like, I'm scared to say the wrong thing. And that's a little bit of the vibe I'm getting from all the witnesses. They're all like, oh, well, I'm not going to say that. I mean, I want to put it in my own words. Everybody, resisting saying it the way that Mr. Yenetti wants them to say it. Sometimes it matters. Sometimes it doesn't, That's all I'm really saying. He was definitely emotional last trial. He was a friend of these people. Southern Mom, does anyone have the responsibility to prep witnesses to not bring up the first trial? Thanks for the great coverage and insight. So whoever is calling the witness has the responsibility of advising the witness of any limitations on their testimony. If there's things they're not supposed to say, if you're putting that witness on the stand, it's your job to make sure that they don't say it. So to the extent that Mr. Whitley should not have said there was a first trial, it was the responsibility of the Commonwealth to make sure that he knew that that was off limits because he's their witness. It's not the defense's job. The defense will have to prep their own witnesses about what the limitations are. Lauren Boborin, you're right. Yenetti made me uncomfortable with firefighter. I may or may not be right. There's going to be different perspectives on this. My concern is just if there are people on the jury that see it like I do, right or wrong, it's a risk. It's a risk. It doesn't really matter if it's right or wrong. It's just, is it possible that people are going to take it that way? Seems like it is to me. That's a risk. So it's got to be worth something. The payoff has to be worth something. And was the payoff worth it? Was the payoff worth it with Mr. Whitley? Did they get something of such important substance from him that it justifies maybe putting some of the jurors off about why are you being such a jerk to this guy who's trying to help? I don't see it because it doesn't matter. What Karen said doesn't matter under your own theory of the case. And remember, he covered for his buddy Farwell, said, I found zero connection. Yeah, Mr. Guarino has got some problems in that Birchmore case. He has got some problems in that Sandra Birchmore case. Just somehow couldn't find 30-some thousand text messages between Matt Farwell and Sandra Birchmore. Messages that made it clear that the FBI, the Department of Justice, are relying on to prove, by the way, he's been grooming her since she was a minor. Yeah, I don't know if they were buddies or not, but I'm interested to see how that unfolds in the Farwell prosecution. Just kind of as an aside, I have been keeping an eye on that from time to time. It hasn't been in the news much, and there isn't really a lot happening right now is the main reason why. They don't have a trial date set. They haven't had a lot of, motions practice or anything like that at this point in time. It's still in the early stages of the case. So I am trying to keep an eye on that because I'm very interested in the follow-up on this. This is one in federal court. Federal court stuff doesn't get televised. If this goes to trial, this is one I might go watch. But I kind of doubt it's going to go to trial. I kind of doubt it's going to go to trial, and that's part of the reason why I think it's moving slowly. because the federal government, they can pursue the death penalty, even if Massachusetts as a state does not allow it. Federal prosecution, you can do it, and that's their leverage. It's always their leverage. If you don't plead guilty, we'll pursue the death penalty, but we'll take it off the table if you plead guilty and take life. And so, early part of a case where that type of thing is on the table, they're going to be looking at how good's the case. You got to look at the trade-offs. If we're going forward, what's the likelihood it's going to blow up in my face and I'm going to get death? Should I cut my losses and plead? So that's where I suspect the case is at. And if that is the situation and we don't get a trial, we won't learn more. We won't learn more about how exactly did Trooper Guarino here manage to overlook 30,000 text messages on their cell phones. I don't know. I'd sure like to know. Like it to go to trial for that reason, if nothing else. Greg, Fox News reported yesterday that Kerry Roberts was a defense witness who admitted to lying on the stand. Oh, oops. Oops. You think that was that an accident? I don't really follow the news. There's so much going on as far as information that's available and sources of it. And of course, we're putting in our time here with the direct source material, right? We're just watching the trial ourselves. I don't need to know what other people think about the trial. So I don't often see a lot of the news coverage. But I know plenty of people out there are not watching the trial. That is where they're getting their information. And I'm interested in trends like this. Are there patterns of mistakes consistently going in one direction or another? Does Fox News have a particular take on this case that they've communicated so far? You do have to wonder sometimes, is this just an accident? Just a oopsie? Or did you just do something that will give you plausible deniability that it was an oopsie, but is consistent with the overall message, the overall narrative that you've been pushing to your viewers? Kerry Roberts is definitely not a defense witness. We're nowhere near the defense case yet. SM, can Commonwealth not call any more law enforcement EMT witnesses that are contradicting with each other? Can defendant introduce their previous statements without calling them? So as to the first part, yeah, the Commonwealth doesn't have to call any of them. He doesn't have to call any of them. And they could make that decision that we're just going to rely on Nuttall, Mr. Nuttall, the true believer in I hit him. And that's what we're going to rely on. Jen McCabe is going to say it too. So we're going to rely on those two. We're not going to bring in any other law enforcement witnesses. The trade-off of that is the defense gets to point it out in closing. All these other people were here. They could have corroborated it. The Commonwealth didn't call them. You get to wonder why. As far as can the defendant introduce their previous statements without calling them? No. Defense would have to call them because their out-of-court statements are hearsay. And so they're not subject to a hearsay exception. Not that I can think of. Defense... I guess defense isn't offering them for the truth, but what is the defense offering them for? They're not impeaching anything unless the witness is there testifying and testifies inconsistently. It's not going to meet the standards to introduce prior sworn testimony. You can do that sometimes if a witness is unavailable. They're out of state, they've died, whatever. I don't think that's the case. So generally, they're going to have to call the witnesses in to testify about what their prior statements were. If they're inconsistent then with the last trial statements can be used to impeach them or to refresh them. But generally speaking, it's going to require their own live testimony in court if the defense wants to make those points. English Kate, I love tuning into Andrea and love this chat. If I was on the prosecution list and had seen the last trial, I would feel anxious too. I do wonder what their overall experience with the trial has been. Like, these witnesses, are they blocking it out other than their part? Are they following it closely? I mean, I'm sure that there's a variety. You know, some folks probably really want to know because they were excluded, right? They didn't get to watch it in real time. They probably weren't supposed to read the news about it. Definitely can't talk to other people about what's happening. So some of them are going to be curious about that, and some of them are going to be like, I don't care. I just assume. Some people that, you know, probably don't want anything to do with it anyway, just block it out. Block it out. I got to go do my thing because I have a subpoena and I have to. But other than that, I want nothing to do with it. I got to think that there's some of those. But yeah, I also got to think that there's other people that watched it go down. And you know, what are you nervous about? You know, a guy like Michael Camerano, what's he nervous about? What's he nervous about? And that's kind of the thing. If you're just there, if you're there to tell, you're just there to tell the truth. Are you nervous that people are going to be mad at you? Are you nervous that you're going to be the reason why the case goes one way or the other? I just don't know. I don't know. It's hard for me to put myself in that perspective. Because like we talked about yesterday, I'm a pretty low neurotic kind of person. You know, it is what it is. If I'm called to testify as a witness, I mean, I'm going to show up. I'm going to do the best I can to answer the questions. But the process is out of my hands, and what people think about it is really out of my hands too. You know, my job isn't to placate people, to tell them what they want to hear. It's to answer the questions in court. But that's just me. Don't expect, you know, everybody in the world to be like that. And it doesn't mean, of course, you're not nervous in the way that everybody's nervous. You're under scrutiny. Everybody, you know, I've talked to so many jurors, and yeah, I'll still get nervous. I'll still get a little nervous. You get the little butterflies when it's just about your turn to speak, and you know, your heart rate's up a little bit. You know, everybody has those kinds of reactions. I think that that's just kind of a normal part of being in public and having people watch you. It's part of the reason why this format is a little bit better, right? There's 1,000 people watching me right now, a few thousand people watching me right now, but I'm just looking at a camera, you know? You don't have that sense of being under scrutiny. So I can definitely see just that being an ordinary part of why a witness is nervous, because anytime most people aren't used to, I'm the center of attention, everybody's staring at what I say. It's that thing you hear that when people are asked, and there's polls and stuff, what's your greatest fear? It's not like, you know, getting eaten by a tiger or falling off of a high building. It's public speaking. People's biggest fear is public speaking. And then you put them in this context where they're there to talk to a jury of 18 people in a courtroom full of people, and these lawyers who are very intelligent, and then they see there's cameras there and the whole world is watching. Yeah, that is definitely going to create a baseline of being nervous for some people. But those conditions were present in the last trial. So why more nervous this time? I tend to think, yeah, you're right. The more I know about the last trial, just the more trepidation I'm going to have about part two. The more I'm aware of the polarization, I think, is really what it is. It's not so much the fact that the first trial happened. It's that I think everybody knows how polarized it is. And so you're never going to be able to please everybody. Whatever you do, it's gonna be probably more to the benefit of one side than the other, even if ever so slightly. And so you're gonna, by necessity, piss off, you know, whoever doesn't agree with the side that your testimony happens to benefit. And that might make some people more anxious, you know, than others. Not everybody's cool with just accepting that some people aren't going to like what you do, even when you're doing your best. Some people are going to think you suck, even when you know you don't. Like that is what it is. That's life. Jennifer Hoff, listening at work. Thanks, Andrea. Well, thank you. Thank you, Jennifer, for being with us and listening. Appreciate having you here. Make sure your work doesn't mind. Lauren Boborn, one juror with mother-in-law like Peggy O and Karen's good. Well, maybe, you know, as long as that juror is a strong holdout. You know, if you got 17 jurors who are the mom that Peggy O'Keefe is, or the mother-in-law, then maybe not so much. But yeah, I think that's probably something that that people can sympathize with. That's the reality. The first thing, primacy and recency, guys, the first thing that they learned about Peggy O'Keefe was how she was treating Karen. How she was treating Karen. What's she doing here? You just left him there. Her first instinct is to blame Karen. And so, yeah, I think there's a lot of people with nightmare mother-in-laws that are going to be able to relate to that situation. You can never please them. You're never going to be good enough for their little golden child. Sentient Dreamer, question. You're in the boxing ring with a dirty opponent. Ref and crowd can't see the dirty jabs from the opponent. What do you do? How do you respond in the ring? If you're asking me personally, I'll tell you what I don't do. I don't bite someone's ear off. Some people might take that strategy. In fact, some people have taken that strategy when they're getting cheaply headbutted by old Evander Holyfield. You know, like Mike Tyson might take a big old chonk out of your ear. No, I'm not going to do that. It's frustrating fighting with cheap fighters, right? It's very frustrating because now it puts you in a conflict of, do you stand on principle and fight fair, or do you let them pull you into a dirty fight? It's a tough choice, and a lot of times it just depends. You know, it depends. How effective is their dirty fighting? If it's not doing much, I mean, I'll give you an example. If they can't see dirty shots coming in, well, then they're not getting credit for those shots, right? If somebody's like rabbit punching me, okay, punch you on the back of the head, that's illegal. That's an illegal shot. The trade-off of nobody seeing that happen, so they're not calling it as a foul, is also nobody seeing it happen, so they're not scoring it against me. If they're damaging me, okay, they're fighting unfair in a way that is inflicting damage on me. Rabbit punches that don't get called, you know, those can mess somebody up. It can mess up your equilibrium and stuff pretty badly. Punches below the belt, not so much an issue for the girls. It still hurts, but you know, nothing like the guys. You know, if it's actually like limiting my ability to respond and my ability to win the fight, then you got to consider a lot harder. My choice, my preference is always going to be, if I see you fighting cheap, to just, you know, counter it. Don't let you do it. The most common cheap fighting technique is the hugging. I don't know why. I hate it in pro boxing. This clinch, dude. Clinching is not a thing. There is no holding in boxing. This is not wrestling. You are there to hit each other with your fists. And if I'm a ref in the boxing ring, as soon as I see somebody grabbing the other guy, no, we're done. We're breaking. And you keep doing it, I'm going to warn you. That ain't the sport. You want to go hug people, go get in the octagon. Okay. We're in the squared circle over here. You're here to use your hands. And by your hands, I mean your fists. And so, you know, if it's something like that, you better have a strategy for how to not let them do it and how to not let them get away with it. Lomachenko, he was great. He was great at evading the clinch. He could certainly use a little holding when he needed to his own advantage. Very subtle, but he's so quick that, you know, it's like you can grab, move, position, and let go. And it like happens so fast that it doesn't look like, you know, a bad foul. He really didn't get called very often for holding or anything like that. But when people would come in and try to clinch with him, because he would get on the inside and then he's fast, man. He is so fast. He can get good angles. And so as soon as Lomas got inside on you, you're going to grab for your life. And he was great at being able to like make a big scene to show off that this guy is grabbing me, you know. And the ref sometimes he'd draw the warning from the ref. Oh, because he'd like, you know, drop down and, you know, push against the guy, like pull against the guy and stuff like that. Sometimes he would actually draw the warning, like, you know, don't be like that. But you force them to acknowledge, well, he's holding. He's holding. So that's why we're doing it. So this isn't a very satisfactory answer to your question because it just isn't simple. It depends. It depends. I have to decide how important is it that he's fouling. If it's not hurting me, then I probably don't care. Then I probably don't care. And if anything, it might just tell me I'm in your head. You're afraid of me. You're afraid of me, kiddo, because you have to resort to trying to foul me to keep me off. I'm gonna make you pay for that. You want something to be scared of? I can make you scared. If it is actually hurting me, somebody's fouling in a way that is actually hurting me. You know, there's some people that take the approach. If you're not cheating, you're not trying. I've heard that saying before. Heard it a few times. You know, I'm not completely above throwing a cheap shot, maybe. But it's just going to depend. It's going to have to be really worth it. I'm going to have to be pretty confident that you know, there's not going to be a big downside for it. But you do sometimes have to just let them know. Let them know, I see you. I see what you're doing. I see the game you're playing. You want to think twice about whether you want to play that game. It's just going to depend. SL, I think they need to separate the timeline for the death and investigation as far as the Commonwealth or the defense. The Commonwealth's timeline so far, it's really all over the place. One thing I will give credit to Mr. Lally for, even though it took forever because he had to call every single person that was involved for even like 2 minutes in every part of the case. It took forever, but he did a very good job of walking us through what happened chronologically. I mean, more or less. It wasn't perfect. Of course, he started with John O'Keefe, or with Paul O'Keefe. And so we already kind of started at the point where John is already dead because Paul wasn't there for any of the stuff that happened leading up to it. But it made sense because he's giving us background on John. Here's who they are. They started their relationship, etc. And then this thing happened. And then we get into the details of here's the thing and how we need to flesh that out. So that at least was coherent from Lally. The timeline was coherent, easy to understand what happened and when and so forth. Mr. Brennan is much more all over the place. We started with Timothy Nuttall, so we started at the scene. Okay, we started at the scene where John has been found dead. Then we go to Kerry Roberts. We're backing up to before, you know, John is found, when Karen starts making the phone calls, and then the process of discovering him, and then moving on until you know, a little bit after what happens with Karen being sectioned. Then we what, start getting I gotta look at my notes, remember the exact order here. Who exactly was after Kerry Roberts? Then we get Peggy O'Keefe. So then we get John at the hospital, and then later the day at the house. Then we get Trooper Guarino, and we have cell phones being extracted at different times, sort of in this time frame, sort of later. It's a mix, very confusing. Then we go back to Daniel Whitley, who sectioned Karen. So we're after John was found, but before the investigation is really underway. And now today we have some waterfall video that we know exists, but we haven't got to. We just have this preliminary introduction. We're backpedaling now to being at CF McCarthy's with Mike Camerano. And then we're backpedaling into the texts, back with Nicholas Guarino and the texts between Karen and John over the course of that day. So our timeline is just really jumping all over the place. And then we have them interspersed with these kind of random clips of Karen saying different things about different points in time. If I'm the jury and I'm brand new to this case, I mean, it's hard. It's so hard for me to put myself in that perspective. Because I'm not. I already know what the general sequence of events is and who's involved where and all of that. So it's not hard for me to make sense out of this segmented kind of approach. But if I didn't know anything about the case, I feel like I would be getting confused. Like I would be having a hard time tracking, okay, so you know, what? So when? And so is this after? Is she under suspicion at this point? You know, I'm not sure what to make of all this because of how it's being presented. It's not a very coherent, it's certainly not a chronological presentation. Not that chronology is always the best way to do it, but it's often the easiest. One that makes the most sense. If you've got a good thematic organization, that can kind of justify sometimes not following a chronology, just follow the theme instead. But I'm not seeing a thematic organization here. I'm not seeing the logic behind how the Commonwealth is choosing to present their case. SL, the way they can keep the facts of the death separate and show no collision, then show the investigation and show corruption. I see. So this is kind of more the defense approach, for the defense to have more of a distinction in how they're handling this evidence and these witnesses. On the one hand, does any of this prove John O'Keefe was hit by a car so far? No. Okay, establish that stuff. Does any of this tend to show this was potentially, tainted by Michael Proctor and or other bad actors? Or that this is something that Michael Proctor should have uncovered if he had done a thorough investigation? I mean, I can see that as being a good way to distinguish those, because that is kind of, that's what the defense laid out, really, in their opening. Those were their main points. John O'Keefe wasn't hit by a car. Michael Proctor messed up this investigation. And behind all of this, you have this powerful Albert family who happens to be whose lawn John was found on. And all of their sketchy behavior that you would expect a well-run investigation to be a little more concerned with. to follow up on. So they really did lay that out in their opening. It's kind of an issue of follow through. And so how are you approaching this case, these witnesses, in a way that's consistent with that theory? I do think that would be cleaner. It would be more targeted. It would be more focused. I agree with that. Loose and Tile, fighting every witness mutes the important fights. Yes. This is part of the important point. A lot of what the jury is going to remember is what gets emphasized, the contrast between things, what stands out. That's why Brennan was trying to get that video of Karen in right after Peggy O'Keefe is testifying. So you have the contrast between Peggy O'Keefe crying on the stand over losing her children, and then Karen, caricaturizing her. That was the whole point, was the contrast. And so, if you come out and you beat everybody up, it's not clear who really needed to be beaten up, like who was really asking for it and who wasn't. If you preserve that for the people who really need it, then the jury's going to pay attention, because they're going to notice, holy shit, this very chill and very pleasant attorney has suddenly gotten really pissed. I better pay attention. You dilute the impact of that tool that you have, that aggression, that conflict, that in your face, that anger, that dialing it up, that outrage, righteousness. If you play that with everybody, then that just becomes the norm, and there's nothing to stand out with anyone in particular. And you should absolutely have a lot more outrage when you're talking to Proctor, when you're talking to Buchanan, when you're talking to the bad actors, than when you're talking to this random firefighter. Yeah, definitely agree with this. Edward Kirkpatrick, note Guarino was quick to point out he only did PDF for McCabe's phone, but he did extractions for O'Keefe and Reed. He wants distance from McCabe. Yeah, could be. He told us Connor Keefe did Jen McCabe and Kerry Roberts' extractions. He didn't do those extractions. He just did the analysis. I don't know if him doing the analysis helps. If there's stuff in the extractions he should have seen. But that is an interesting observation. That is an interesting observation. Is he just being careful because he doesn't want to be tied up if the defense are like, well, but you just testified, but you didn't actually do, and he's like, look, I was just trying to be agreeable with the Commonwealth. They got it slightly wrong. I didn't necessarily feel it was that important to call them out and correct them. Could be. Or could it be, I know defense is going to be getting in a problem with this extraction, and I want to make it crystal clear that didn't have anything to do with me. Could be. We're going to have to wait and find out. Law and Lumber, Rob was with us this morning. I agree with Andrea's thoughts on cross. You can't turn everything into a fight, but I am looking forward to our first Alessi cross. I'm looking forward to our first Alessi cross too, and I will tell you, the Commonwealth is getting away with some stuff, I think, with this whole, we're going to call Guarino back and forth and back and forth and back and forth, and let him present his evidence in little bits and pieces. And you, the defense, are not going to get your shot at him until he's all done, and then you're only going to get it once. So the Commonwealth is getting to leave multiple impressions from Trooper Guarino with the jury throughout the course of their case. And it's going unrebutted repeatedly until he decides, I guess, that they're done. And then the defense gets one shot to go in and undermine whatever impression the jury has formed over however long and however many times he's been brought back unchallenged over and over and over again. It's a disadvantage because none of these preliminary things that he's testified to, none of these are going to be fresh in the jury's mind when it's time for cross, right? It's distant. It's already probably distant at the close of the day today. So structurally, this is a little tricky on the part of the Commonwealth. Now, defense isn't objecting so far. So far. Might it change? I don't know. It might. I guess it depends on how many more times the Commonwealth wants to do this, and whether the defense thinks they're starting to lose their ability to be effective with cross because of the passage of time and the fact that he's, just being allowed to go unchallenged. What I would prefer, if people are called out of order like this, great, then we'll direct and cross them on this particular topic at the same time. Then when you want to call them back, we'll direct and cross them about that too. So you have an even opportunity to address the points that the witness is making at a meaningful time. That's what I would prefer. If I'm the defense, that's what I'm saying. I don't mind if they want to call him out of order and call him back and forth, but I want to be able to cross him about what he's just testified to, so that I don't have to be going back weeks later reminding the jury, remember way back that first time when Trooper Garino was testifying about this particular exhibit? No, they don't. No, they don't. But I'm very much looking forward to our first Alessi cross. I mean, at this point, I kind of wonder if it's going to be our first Alessi cross, right? They could keep dragging him back and forth over and over the course of this trial. Hey, if tomorrow is going to be the doctor who's going to testify about the one who's technically an expert, Dr. Fowler, is going to testify about the blood serum testing protocol, that's going to be Alessi. I would expect it was when they were in the pretrial hearing and they were litigating whether the retrograde extrapolation should be excluded, in part because it's relying on this blood draw that wasn't performed by law enforcement, it's performed by hospital under different protocols, etc. He handled that. So probably the first Alessi cross is going to be tomorrow with Dr. Fowler. I think there's a good chance of that. I look forward to it too. I just enjoy his style of argument, and I'm very intrigued to see how his style translates into cross-examination. He's a smart guy. I'd be nervous. I would be nervous, not gonna lie. Little Mighty, the fact that John had no coat but was apparently not hypothermic means he had to have been in the house until shortly before he was found, right? If he wasn't hypothermic, he wasn't out there for 5 hours, 6 hours. If he wasn't hypothermic, he wasn't out there for 6 hours. That's the bottom line. I don't know where he was. It doesn't really matter. He wasn't there. He had to have been placed there later. And if he's placed there later, that's the defense's theory, consistent with the defense's theory. That's the bottom line. Very interested in hearing from their medical examiner. As soon as they mention them in opening statement, oh, this is new. This is new. I love it. It's one of the things I wanted in the first trial. I really wanted a defense pathologist. I wanted their take on the injuries and stuff like that. With the understanding, it's always a review in that situation, unless you're in a position where you already know you're under suspicion at the time they're doing the autopsy. You can hire your own person to attend it. I mean, even then, it's still really a review, because it's not like they can intervene and be like, no, cut here, no, test that, whatever. But you have a little bit more opportunity if there's like testing you want to be done or stuff like that. The timing can be beneficial. But most of the time, yeah, it is reviewing whatever Dr. Scorti-Bello decided to do or decided to look at. But that can give you some insight too. You know, what did she do to determine, if anything, that there weren't in fact fractures over in that boxer's fracture area that was all bruised up on John's hands, like you get with a boxer's fracture? What exactly did she do? A forensic pathologist is going to be able to look at that and know. I really wanted that the last trial. We didn't get it. We're getting it this trial. I'm very excited about that because, yeah, I didn't expect this. Honestly, I really didn't. I thought we might get more kind of detail about the injuries and stuff like that. Not hypothermic. I wasn't expecting. Because, yeah, that's extremely helpful to the defense. He was not lying out there in a storm, in a blizzard, 20 some degrees, wind chill, wet snow, in a thin hoodie and not hypothermic. Wouldn't have happened. And it also, I mean, maybe I'm interested to see how they can tie all this together. How would that correlate with his body temperature? You know, would that confirm he'd been dead for a while? If it wasn't that the air temperature was lowering his body temperature and causing the process of death, but instead was he already dead and getting cold and placed outside? Like, what would you expect his body temperature to be in those conditions under kind of a different range of assumptions? If he died instantly, if he didn't die instantly, but died some point later, like what would those look like? I think that would be so helpful. Can't wait to hear it from this defense expert. Edward Kirkpatrick, Brennan thinks the videos are his smoking gun. He wants them to be the thing the jury is left with overnight to think about. I agree. He wants these clips to get their attention. He wants them to focus on what Karen said, despite what he told us in his opening statement, that's just a backup. That's just corroboration of the facts and science and data that are going to show us that Karen hit John O'Keefe with her car. It's not. It's not. And we all know that because we watched the first trial. We already know the facts, science, and data are not on their side. Sorry. The Commonwealth chose not to call the crash daddies. The defense scooped them up and called them instead. So he does. He wants him to fixate on Karen's statements. And those are powerful. The defendant's own statements, very powerful. Shouldn't be, but are. It's just how people see the world. I would never say that if, you know, I can't imagine saying something like that. I wouldn't say I hit him if I hadn't hit him. We went through this with the Richard Allen case, guys. We went through this with Richard Allen. Richard Allen, whose interrogation videos are now out in public, who is like one of the most innocent looking people you will ever see sitting in an interrogation room, denying everything, dumbfounded that this is even being asked of him. And then once he gets put in solitary confinement over there in the Indiana State Prison and rots in there in solitary for a few months, and once he starts becoming actively psychotic and behaving in extremely disturbed and disturbing ways, then he starts making comments on the phone. Maybe I did do it. Maybe I did. Maybe I did. Yeah, that's one of the things he said. Maybe I did kill them. I think I did. What if I did? That was enough. That's enough for people to hold that against him. Be like, well, I would never say that if I didn't do it. So So people's statements are very powerful, and that's why he's using it, because he wants to get the benefit of that. Well, you know, I'm persuaded by that. I'm so suspicious of her now that even if the science raises a doubt about whether he was actually hit with the car, I'm going to resolve that doubt by looking at her words. Well, it happened because she said it did. It's a crazy kind of bizarro world, but that's the Ipsy Dixit defense. That's Ipsy Dixit. She said it, therefore she's guilty, even if it's not physically possible. Keep talking about Duped, guys. Great book. Great book by Saul Kassan. Great book about false confessions, the effect they have on people, wrongful convictions that result from them. Yeah. Jurors will convict people of things that are physically impossible because somebody said so. Just go back and look at the Satanic Panic cases. That's why he's relying on her statement so much. Michael Muddragon, I was having a good nap to the droning sounds of untraumatic text message date and time readings. Then Bev had to go and ruin it by calling a half day. What is the half day about? And why is she so cheerful about it? If the defense just happens to get confused about scheduling and doesn't call witnesses for half a day on a Thursday, do we think she's going to be chipper and cheerful about it? Or is it going to be, how do we think that's going to be? I mean, I don't know how these text messages, I don't know how the Commonwealth thinks these look bad to Karen. I really don't. I remember this from the first trial because it's when I kind of started getting sad. Because before this trial, John O'Keefe did kind of look like that hero. You know, it's easy to put a halo on him. He's a guy that died too young. He was a cop. He had taken the sister's kids. But then you start to see the full picture, the whole complexity of people in these text messages. These text messages don't make John look good. They don't make him look good. Everything that came out in the first trial, and unfortunately they're limiting some of that in this trial. We're not going into Aruba. We're not going into the randoms, the babysitter with benefits. The way we kind of had that pattern in the last trial of how John treated women. Shallow relationships, not deep bonds, discards. Uses them for a while for babysitting, discards. John isn't a nice guy. Doesn't mean he deserves to die, of course. Duh. But he wasn't a nice guy, and it's unfortunate that this trial is necessarily going to reveal that, because this trial was supposed to be about justice for John O'Keefe. That's ostensibly what everybody on the prosecution and affiliated with the prosecution and siding with the prosecution wants, justice for John O'Keefe. Is that justice? Taking his halo off? You want to get her so bad that you'll drag him into the mud to get her. That's the justice you want? I think it's sad. I think it's sad. I don't see her being the one that looks bad in these messages. James Casatelli, I fear the texts show Karen Reed had a reason to run over John O'Keefe. I don't see it. I mean, maybe if you want to see that, I'm sure you can. I guess I'd put it like that. If you want to see it that way, I'm sure you can. But I mean, why? Because he hadn't apologized to her satisfaction. So she ran him over, but she's appeasing him. She's trying to make up with him. He's the one who's being distant and I don't care. He's the one, oh my God, I can't believe the nerve of Mr. Brennan is asking Mr. Camerano about, was she a little jealous? And he goes, well, she didn't necessarily like him around other women. And then you show us freaking text messages where she's like, I'd like us to hang out with another woman sometimes. And you have John being like, you can't call the plumber. Is he hot? Darvo much? Darvo much? I see one jealous person in these texts. Hope the plumber's hot? The fuck? I mean, a reason to kill John. The thing is that you can always kind of come up with a reason why somebody might do something extreme. It's just, what have they done to show you that they actually would, that they might, that's consistent with how they behave. We're talking about such, like, given that this is the context hours before for this to escalate into running him over with a car, we are talking such a massive escalation. And not only that, we're talking about a complete switch from I'm trying to appease you and, get back into an emotionally safe place to I now have explosive rage and I'm going to run you over. It's just so incongruent. It's incongruent. I mean, a reason to kill somebody, we can point at a lot of people in this whole picture and say that that person, had a reason to kill John O'Keefe. Brian Higgins had a reason to kill John O'Keefe. He's jealous about the girl, wants the girl, doesn't like how John treats the girl. Brian Albert, reason to kill John O'Keefe. He's just an angry, violent kind of guy, and he was drunk. Jen McCabe wants to kill John O'Keefe. Well, maybe not when the night started, but once things went really downhill, and if John O'Keefe wakes up and, says what happens, we're all going to be in a load of shit, maybe then, to cover up what went wrong. You can look at a lot of reasons, but, it doesn't, people don't like people. People have conflict. Like, that happens. That's not a reason to murder. So I understand this fear. I guess I just don't share it as like a strong concern. If you don't already want to convict Karen, I don't think these texts are going to put you there. Kingdom of Capybaras. I got the impression Karen and John had already had the same conversation 100 times before. Well, it kind of sounds like that, doesn't it? It sounds like they have a pattern, and they're both kind of saying, I don't want to keep doing this. And when we look at what this is, I mean, yeah, I can understand, because it's toxic. What this is this very toxic pattern where they fight, and then Karen's trying to get her emotional needs met, and John is stonewalling her. He doesn't apologize. He doesn't take accountability for her part. So she feels unheard, unseen, unresolved, uncared about. And they just keep going around in that circle. Probably has happened 100 times before. They've probably had the same arguments 100 times before. If he's triggered by her being nice to the kids, that is a no-win situation. That is a set up to fail situation. It almost sounds like an avoidant person looking for reasons to be mad and to distance themselves. Could look like that. But if that's a point of conflict, how she interacts with the kids, and she's kind of living there part-time, yeah, then there's probably a lot of conflict about that, and it's probably not getting resolved either. If this is how they handle that type of issue, they don't resolve it. They just get to a point where they can move past it. John's like, I don't get over this stuff as fast as you do. What stuff? What did she do to you? What did she do to you that day that you need to get over? We didn't hear anything from him. We just heard he laid into her because she was too nice to the kids. And that's a trigger point for him because he always has to be the bad guy. So what did she do to him that he needs to get over? Stand up for herself? I don't know. I don't know. Yeah, I'll bet they've had the same conversation 100 times before. Talk about patterns, relationships. There's patterns in them. Communication is a big pattern. Marcelo, if ARCCA is excluded, what can the defense do? Ask for a mistrial. Bev has done this knowing that if she excluded ARCCA pre-trial, the defense would have appealed that. Now they can't. I mean, they can. They just have to post-trial. Once again, they can. They just have to wait and see if it's necessary, if they could get her acquitted anyway. But yeah, she knows very well how essential ARCCA is to the defense case. That's why she's got to be so cautious with it. She's got discretion in this area, but her discretion is not unlimited. Her discretion is a lot higher when it comes to things like, does this fit within the evidentiary rules? Is it admissible or not? Is it more prejudicial than probative? It's not that courts will never second guess that, but it's just harder to. But with a sanction, it's a little trickier because you've got discretion with imposing a sanction, but you've also got these limitations that they need to be proportionate. They need to, address the harm that you're trying to remedy. You can't be overkill because her right to a defense is so strongly implicated by her ability to call these witnesses. So if you're going to sanction them by exclusion, you better have a damn good reason. And they've made a pretty good record so far of, I don't know what else you wanted us to do, given how late the Commonwealth disclosed their own stuff, and given the context that we had where these guys weren't even available to be retained by the defense until they could get the permission from the FBI. And that process takes time too. And they started that process as soon as they found out Commonwealth is going to be calling it an accident reconstructionist. So they need to make sure that they've made their record. Otherwise, what can they do? They can poke holes through cross-examination in what the Commonwealth's witnesses bring. They can focus on those are dog bites, Dr. Russell and Garrett Wing and maybe their own pathologist. Those are dog bites. That's what I think would happen. Do their best to try to win the case under those constraints, but ultimately you got to make your record for appeal because that's really your only remedy. They're not going to get an interlocutory appeal in the middle of trial. It's not going to happen. Ask for a mistrial. I mean, maybe, but she's not going to give it to them. She's not going to give it to them. And it's not required for them to preserve it for appeal or something like that. So I don't think it's necessary that they do that, and they probably wouldn't, but it would be a very significant ruling if she excluded them. It would absolutely be appealed if we get to the conclusion of the case and Karen Reed got convicted. Just because Peggy's testimony yesterday did something that I thought wouldn't be possible since the first trial. She made me feel bad for Paul. It feels like she resents him as a surviving child. Could be. I mean, it was so notable to me, just in tears instantly over Kristen. And then John, you all, you know the story of John. You know how he's the hero that was the Boston police officer and took in his sister's kids, and everybody loved him. And he had all these friends, and his old girlfriends even still liked him. You all know about John. And then there's Paul over here. I mean, the whole shift, like even from like the tone of her voice and everything, and then there's Paul. Yeah, I mean, Paul Reed's is the scapegoat of the family to me. If we're looking at it through the lens of that kind of dynamic, Paul's a scapegoat kid. And it makes sense with the push and pull of the withholding and granting affection, getting in a cycle of needing to seek out somebody's affection, needing to withhold somebody's affection. You learn that from what's modeled to you. And so might you withhold affection as an adult if as a child you've seen that modeled to you by a parent? Yeah, I mean, I kind of feel sorry for Paul if that's the case, and it kind of looks like it is. I mean, you can, it's, again, this stuff is not zero sum. Feeling sorry for Paul doesn't also mean that you can't be like, Paul's been a major jerk through this whole process. The way he sits there and eyeballs Karen, the way he's confronted her after the trial, way he's behaved in the interviews, yada yada. You can have all those feelings about Paul and still feel bad for Paul. I felt bad for Amber Heard, guys. I did. I felt bad for Amber Heard. I said many, many times, imagine how bad it has to be going through your whole life knowing you got to be Amber Heard. It's like its own punishment. Yeah, I got that impression too. And then there's Paul, like the afterthought. Sad. Lorelai Annie, will Bev back off if defense asks for her recusal? Thanks. I doubt it. Frankly, I think she'd probably double down. She didn't, they already did it, and it definitely didn't get her to back off. I think there's an argument to be made that might be part of the trigger for why we are where we are right now. No, I don't think it's going to get her to back off. I mean, once they ask, she's got a rule on it, and they either have the basis or they don't, and it's either going to hold up or it won't. And so it almost kind of gives her more power if they do it, because then she can just say no. And now, I can rule out all of these complaints that you have. I can ignore those complaints. And now you're even more powerless, to get me to stop. No, I don't think they back off. I think there's a reason why they're not renewing that motion. It's because they can't point to anything that is going to satisfy the extremely strict standards courts have for throwing off a judge who doesn't think they need to be thrown off. It's a very difficult standard to meet. Linda M, Be in Trouble 31 channel, defense is watching his videos. I hope they are, because he's done some great videos. This is the guy that has been breaking apart the tail light. He's like deep dived into this tail light. The one that I saw, I mean, I know he's done several, and I've seen bits and pieces of several of them, but the one that made a big impact for me was the one he just went and smashed the tail light and then turned it back on. Plugged it, wired it up to the battery, and fired it up. So you can see this is what an illuminated tail light would look like when it's broken, the way it was in the Sallyport video. So that way, when we're looking at all these dark nighttime videos where you can kind of see like little bits and pieces of tail light, we can compare that to what would it look like, if it's broken in this condition. And the big takeaway was that diffuser piece. That was the piece of the tail light that's behind the outer casing. It's a clear piece and it has like little bubble looking things on it. And what that does is, because this is an LED light, there's no bulb. There's no bulb. This is LED. What that diffuser does is the light is actually generated like at the top of the tail light, and the diffuser pulls it down. So then when that diffuser is missing, it's gone. That light just sits there at the top of the tail light. It doesn't get pulled down into the rest of it. We saw that diffuser piece in the evidence. One of the 47 pieces of tail light in trial number 1 that somebody managed to collect from outside 34 Fairview at some point in time. That tells us that tail light would not be illuminated. That entire section of that tail light would not be illuminated. It doesn't have the diffuser to draw that light down. It was a very compelling video. Very well done. I found it extremely persuasive. I think the defense would be extremely well advised to be thinking along those lines and taking advantage, if they can, of that type of experimentation and research. I'd love to see the crash daddies replicating that. Is that among the experimentation that they're doing? Buzzcat, Andrea, as a retired teacher, this is driving me crazy. Why trial 2.0 the letter as opposed to 2.0 the number? Please explain. Also, thank you for your dedication and expertise. I'm not sure. I'm not sure what you're getting at. It should be 2.0 the number. If I have it wrong somewhere, it's just a mistake. I don't know. I don't know where the trial 2.0 is that you're looking at, but it should be the number. Maybe it's a font that looks like a number. It's 2.0. 2.0. 2.0 if it's a verbal, if it's just a verbal thing. 2.0 O is just shorthand for 0. It's easier to say. Runs off the tongue a little bit better. 2.0 because it's a consonant followed by a vowel instead of a diphthong. 2.0. I don't know. That's all it is. Nothing real technical. Muserlina V, if ARCCA is excluded, what's the backup plan? I hope they have one. I think the backup plan, again, it needs to be cross. It needs to be cross hard. It needs to focus on the data, the cell phone, the digital data, the health data, all that type of information. They're going to need to double down on that. They're going to need to cross hard the Commonwealth's, crash reconstructionist, Mr. Welcher. They're going to need to be able to Trooper Paul him, if at all possible. It's probably going to be harder because he's probably going to be smarter than Trooper Paul. But we'll see. It is that is the challenge of, you've made your case. John wasn't hit by a car. You still got your forensic people, your medical people that you can rely on. Dr. Scorty Bello agrees these are not consistent pedestrian, classic pedestrian injuries. Dr. Russell wasn't allowed to go there in the first trial. Maybe they've supplemented by now, but I kind of doubt it. Looks like she's still limited to the dog bite. Either way, they can point out dog bite injuries, not tail light injuries. They can point out as a matter of common sense and cross-examine, the Commonwealth's person on where's the injuries from where this car would have struck him. The bumper would have struck him. Where is it? Physics, explain to me how car hitting his arm nowhere near his center of mass is going to cause him to fly. You're going to have to prep and do it as best as you can defensively. And that's the hard part about making your case John O'Keefe wasn't hit by a car. When you're depending on ARCCA to really tie that up nice. Doesn't mean they can't still win it. Definitely doesn't mean they can't still win it. They got so many facts on their side that they can take advantage of. But it means they're going to have to tweak their approach, no question about it. Truth and transparency. What is up, Lana? I just came to say, is that right, Hank Brennan? No more witnesses today after those clips? Right. Yeah, just misunderstood. Just a misunderstanding. I just got confused that it was Thursday and not Friday as far as our half day. I just got confused. Yeah. Yeah, convenient, isn't it? We'll just watch those clips and then we'll go home. My bad. It's more important if the clips are that bad. Are the clips that bad? Karen acknowledges she was drinking. It's not ideal. Doesn't prove she killed him. She seems pretty consistent over those multiple statements about how much she drank and how she felt as a result of it. I tend to like her explanation because to me, she's not overly defensive. She's not like, no, of course, I was totally fine. I was absolutely, I mean, it didn't affect me at all, you know. That would be off-putting to me. But like, yeah, of course, if I hadn't had any drinks at all, I would have been, you know, better, but it's not like I was, you know, completely impaired or whatever. To me, that's, I can understand that. You know, that's yeah, that's reality. Okay. It is a spectrum. We have a legal rule where they say at this measurement, you know, you're presumed to be no longer capable of driving. But nobody really knows where that is. You know, people don't sit there and breath test themselves at the bar. I will teach you guys how to do the HGN test if you want some time. That's what you should be doing if you're at the bar. It's not illegal to have a drink and drive a car. It's not illegal to drink and then drive a car. Right? How long? How long ago did you have this drink? How much did you have to drink? The issue is you shouldn't be driving if it's going to make it dangerous for other people on the road, if your driving is impaired. And so how much alcohol over what period of time do you have to have for that to happen? That's really what it's supposed to be about. It's not illegal to drink a beer and drive your car home. If you're not affected by it, it's not illegal. Doesn't mean you won't have a whole bunch of shit to deal with if you get stopped. Definitely doesn't mean you won't have to deal with a bunch of shit if you get stopped. But it's not illegal. She made the choice to drive after having the drinks. She made the choice to drive. I felt buzzed. Yeah, she's probably legally over the limit. She probably is DUI. Doesn't mean she killed somebody. Definitely doesn't mean she killed somebody. Scorpion, defense gets rushed constantly, and she says nothing to Brennan about not having any more witnesses today. Oh, I know. Jury, it's fine. We're still on schedule. We're still on track. Well, if we're still on track, when you can cut out a half day worth of Commonwealth witnesses, then maybe we don't need to be telling Mr. Yenetti to move it along. Maybe we can just let him do what he thinks he needs to do. Just a thought. Just a possibility. Yeah, we know the rules aren't the same. Whatever, Clever. I think Commonwealth is baiting the defense to swing at everything. I think the defense should quell their passion and pick the battles. My worry is the jury will grow tired of what sounds like nitpicking. Yeah, I mean, some of it might be the Commonwealth baiting. Some of it might just be the defense's own, enthusiasm. Some of it might be that we're just, we're running back. Trial number one. where it was Karen Reed was framed. So we gotta, go extra hard on everybody that's affiliated with law enforcement. It could be a little bit of all of these things, some, none. But I agree. It's so much more effective when you pick your battle, because if you're just up there being argumentative, the people on the jury, let's go back to big 5 personality stuff. Okay, another big 5 personality trait, agreeableness. Agreeableness is one of the big 5. I'm not very agreeable. As my husband will be the first to tell you. I'm not very agreeable. It doesn't mean I'm mean. Doesn't mean I'm an asshole. I'm just not inclined to give people what they want just because they want it. I tend to think independently. If I agree with you, I'll agree with you. If I don't agree with you, I'll say so. Doesn't necessarily mean anything. I don't hate you because we disagree, But it's just I almost see it as kind of having to do with suggestibility and how much does wanting the approval of other people influence you. If you want other people to like you, you're far more likely to, even if you'll say yes to things you want to say no to. For example, I got really good at saying no. Yeah, no, I'm not going to be doing that. You might tend to put other people's needs, wants before your own, a lot of the time. I think a lot of that stuff tends to go hand in hand. I'm not an agreeable person, but I'm not necessarily an asshole. If there are jurors, people on the jury that tend to be agreeable, and they tend to be agreeable because they don't really like conflict, they want everybody to get along. This is making them uncomfortable. The conflict makes them uncomfortable. They don't like it. They want to see things done in a just nicer kind of way. I don't know if those people are on the jury, but there's a lot of those people out there. A lot of people out there that are uncomfortable with conflict, don't like it. And there's, even beyond that, there's probably some people that are like, okay, well, I don't necessarily mind conflict, but you can still be annoyed if it looks unfounded. You can have, friends that you love very, very deeply, but they're like constantly bickering with each other in front of you, and it gets annoying. Gets annoying. Could you guys just knock it off? And so that's the concern. Yeah, that's the risk, is you just look disagreeable and argumentative and like you're trying to stir the shit for no good reason. If you have a good reason, it's justified. If you get something good out of doing it, then we can understand why you needed to use this strategy. But if you're not getting something valuable out of it, I think you run the risk putting the jury off. They're just going to get annoyed and be like, you're fighting over everything and over petty stuff. You shouldn't do that. Nicole Kelly, could defense hone in on Guarino using Celebrite, and if he believes it's accurate? I mean, they certainly hinted at that in the opening, didn't they? And that was a little bit of a reprise from trial number 1 as well. Celebrite, the most accurate, most relied on. Celebrite, presented it as this. They can. It's just that's not what the battle of the experts is going to be about. The battle of the experts isn't going to be about, is Celebrite accurate or not. It's going to be about, there's this particular artifact. What does it mean? And so Celebrite reported it in this particular fashion. If Celebrite misreported this one particular artifact, made it look like something it's not, is it worth raising? I mean, yeah, because people do rely on Celebrite, and surely Jen McCabe is not the first person on the planet to run Google searches on pre-existing open tabs. And so you would hope that this would be something that they would have already figured that out. If that's the simple explanation, oh, when you have a tab in the background, then you bring the tab forward and then you run a search in it, it's going off of the tab, the tab being open at the time, not necessarily the search that you ran. You would think that wouldn't cause a problem because they would have already figured that out, because people do that a lot. I'm going to tell the whole internet, Jeff never closes his tabs. It's like, oh my God, I'll go into his office. And it's not so much on his phone. I'll go into his office and I'll have his desktop up and I've got like 100 tabs open. Oh my God. Like, how do you deal with that? I can't deal with that. I gotta have just a few tabs. I'm going to close those tabs out. If I need to remember my tabs, that's what history is for, right? A lot of people do that. Just flip through tabs, do different things with different tabs. So it's very hard for me to believe they wouldn't have already figured that out, and that, Celebrite would not have made this mistake. And if Celebrite had made this mistake, I'd expect that to have shown up in other casework and other situations. It should be reported the same way with similar types of problems. So I'm definitely interested in well, can we validate that in some way? Can we produce another instance where this happened, where Celebrite reported it like this? We know that Ian Whiffen is going to do his reconstruction. He kind of did that in the last trial, but they didn't use the right phone and the right operating system. So it's not an apples to apples thing. But yeah, if you could show me same model, same general, settings and everything. In fact, do it with Jen McCabe's phone. Would be best. If it's going to recreate it, surely she'd let you. Just do it with that phone. If not, get as close to that phone as you possibly can. Same phone, same operating system, same settings, et cetera, et cetera. Same browser, obviously, same apps, everything on it as much as you can reconstruct. And show me it do that. Show me it doing that. That's really what it's going to come down to. It's not, can they go to, is Celebrite accurate? Yeah, they can. It's just that's not really fair, because it is more nuanced than that. And that's what's going to come out in the testimony. It's a little bit more nuanced than just, is Celebrite accurate or not. So I think it's one of these things that runs the risk of, well, it makes the defense now look like you're trying to be too cute by half. Yeah, Celebrite is extremely accurate for a large number of things, but not this particular thing. Because we got to remember, the defense's own experts also rely on Celebrite. They also use Celebrite. Everybody uses Celebrite. It's not the only thing, but it's definitely the most common one. So, truth and transparency. I'm tipping Andrea again because I feel bad that I'm going to win out 50 Pick'em challenge fake bet. Love AB. She's a champ for the truth. Cheers to you, Jeff, and the amazing mods. I got to go back and double check what my what my Pick'ems were. I'm going to have to go back and screenshot that or something. Get that. And maybe you want to shoot it over to me, Lana, so I can track, because I'm not sure where I stand on that Pick'em challenge. Sounds like maybe I didn't predict things very well. We're not even that far into the case yet, so that was fun though. It is nice to have things like that to kind of bring some levity. I'm all about bringing some levity to the trial, making it a little bit fun. I don't buy into we all have to be somber and wear our funeral black and keep our faces long because we're talking about a murder trial. That's fake. I don't know these people. It doesn't affect me. Sure, I have empathy for them and feelings about it and stuff like that, but I'm not gonna fake a feeling I don't have. And I'm not grieving for John. I didn't know him. I'm getting to know him through this process. So yeah, it's good, I think, to have some levity, and Lana put a lot of work. She did put a lot of work into this pick'em challenge and putting them together. So appreciate that, Lana. I'll have to go back and double check. Kate Arete, how do you feel about Karen's lawyers not advising her to not do interviews until later? They had to know Spanky would use against her. I understand her passion wanting the world to know the truth. Any and probably every lawyer is going to tell you, I don't like it. I don't like it. No, I don't like it. Of course, it's a terrible idea. Not because she's gonna, give up she's gonna say the quiet part out loud. She's gonna accidentally, reveal, oh my God, I really did hit John O'Keefe. Like, no, there's not a risk like that. But the risk is exactly what you're saying, that she says some things maybe less carefully than she should. Maybe, it's kind of like in the read technique where they try to get you, they use, it's called the minimization technique, where they're like, well, maybe you didn't maybe you weren't blackout drunk, maybe you just had a little bit of a buzz, just like, we would expect that, it's normal. Lots of people drive with a little bit of a buzz. They get you to accept the possibility of something that isn't really that harmful. And then they, ignore that. They use that to turn around, treat it, oh, you were admission, you put yourself there, you involved yourself in the crime, therefore you're guilty of what we say you're guilty of. And so the interview can be a little bit like that, because it's that type of environment where you're being encouraged to provide information, and you're being encouraged to explain yourself, and to be able to, sort through all that for them. So yeah, there's a risk that you're going to give them stuff that's going to be distorted. Just give them things that they can take out of context and argue and try to paint in a particular way, even if this is no different from why defense attorneys tell you not to talk to the police. It isn't because, oh, you're going to confess and then that's bad and then they can prove you're guilty. No, it's because they will twist what you say. You can't help yourself. It will not help you to talk to the police. It will only hurt you, because they will only twist what you have to say. Now, that's where I think Karen has the trade-off. This is different. This is not talking to the police. This is the press. It can help her, potentially. Potentially. How can it help her? It can help her with the jury pool. You're not supposed to say that. It's not supposed to be your strategy, because you're not really supposed to try your case in the court of public opinion. But it can also help her just on a personal level in terms of her own reputation and trying to rehabilitate it. She's been accused of all of this stuff. She's had to sit and take it. Yeah, I can understand that at some point it's like, look, even if I get convicted, it's value of me. It's value to me to try to get my message out enough that if there are some people that aren't familiar with the case and they think maybe I did it, and they hear me and they're like, oh, she didn't, she's not that bad person or whatever, that would be worth it to her. So she's envisioning a trade-off where, it's not like talking to the police where there's nothing to gain. There is something for her to gain here. But the question is always the cost-benefit analysis. Me as the lawyer, I'm going to tell you, doesn't balance. Karen, you're in finance. These do not balance. Okay? The risk here, it's high. It's far too high. The benefit is low. The benefit is low, especially, when there's a whole trial. Now, I don't know what else is involved. I mean, I don't know. You're not supposed to be paid, but I think that's for news. If it's some other type of, some other category, entertainment, Could be that this has to do with finances. We know how much that this is, this trial and defending herself has cost her. And she's not made of money, doesn't have unlimited resources. She's going to have to do it again. It's very costly. Even if she's not having to pay her lawyers, she's having to pay her experts. She's having to pay everybody who needs to travel. She's having to put them all up, all that stuff. It's going to add up. So it could have something to do with cost too, as part of the upside. I wonder about this. I wonder if they have advised her not to. But ultimately, you're the lawyer. You just advise. The client makes the decision. I do wonder if these were against advice. It does happen sometimes. All you can do is tell people what you think, and they can do with that what they want. They don't want to go along with it. Okay. Your job as the lawyer is you get to clean up the mess after. Happens, unfortunately, frequently. You really want to say, I freaking told you. I told you. Now here we are dealing with it. Do you believe me now? You want to, but you don't. You just clean up the mess best you can. If you can. Sometimes you can't. You're a lawyer, not a miracle worker. You don't get to change. You don't get to change what's evidence, what's available to the prosecution. Once these interviews are done, they're done. You can't change that. So I do wonder if they did advise against it and she did it anyway, if they thought it was okay, that's going to be an unusual position. I think that's all I'll really say about that. It's a minority position. If you think that the benefits of this outweigh the risks, I don't think most lawyers are going to think that. Here's what I do take issue with. I've mentioned this before. There, in my opinion, was a significant risk with that motion that the Commonwealth filed about the attorney-client communications based on things she said in this interview about what she told David Yenetti and what David Yenetti told her. Very real risk that that's going to be found to be a waiver of attorney-client privilege. Because when you publicly disclose what you have the right to keep secret, what you and your attorney talked about, when you publicly disclose that, you are saying, I'm giving it up. I'm giving up my right to keep it a secret. That is the primary reason why you as a lawyer would be present at that interview. So that as soon as the words I told David Yenetti start to come out of your client's mouth, you can come at your client like a freaking linebacker, get the hand over the mouth, stop. You are not saying that. You are not talking about what you and your attorneys talked about. That is confidential. You don't want to waive that privilege. You will find another way to express what you need to say. And so if, as Mr. Brennan presented it in his motion, if the situation is that Alan Jackson was present during at least one of these interviews where Karen Reed is saying, I told David Yenetti and David Yenetti told me, and he didn't intervene and stop that, I don't know why he's there. I don't know why he's there. That's what you're there for. So I really hope that didn't happen. I really hope that didn't happen. If they advised her it's fine to do interviews, I don't agree with that. It's a risk. It's always a risk. I have the minority perspective on many things when it comes to trials and strategy and stuff like that. I'm not saying it's bad to be in a minority position. I'm in the minority position of I want the client to testify, if at all possible. I think it's a good thing. It's a minority position, but I think it's right, so I'll stand by it. I would just be interested in their thoughts. I can accept that they have a different opinion, but I really would be curious why. What were the trade-offs here? I don't think we'll ever know. Ever age, I agree. David Yanetti come off borderline cringe. I wish they listened to Ian and be sweet as butter. You can always turn it up if need be. That was kind of always my default, you know, because you can just be nice. You can be nice. You can be polite. If you just play it in the middle, then you have both ways you can go. You can be extra syrupy sweet to a witness if you need to for some reason. You can also turn it the other direction, and you can be angry, you can be outraged, you can be accusatory. But that distinction then really stands out when you have kind of different modes of interacting with people, and it signals you should treat this differently. I'm treating it differently. This is different from the last one. This stands out. There's a contrast here that matters. And so, yeah, that just kind of all depends on where you set your baseline. And if your baseline is always, we're fighting, then I'm going to notice when you're nice to people and when you're nice to the Commonwealth's witnesses, you know, it's because it's like Peggy O'Keefe. You know, you can't cross her. I mean, we were nice to Michael Camerano. We weren't mean to him. But it's because their feelings, really. It's because we're being very sensitive to their feelings. That can be risky and manipulated. What if Jen McCabe gets on the stand this time and she sees, oh, they got to be real nice to people that cry? I'm going to cry. What if that happened? Then what did they do? It's better to have a neutral baseline, I think. That's just direct, just calm, whatever. It's not personal. You're there to get facts. You're there to get evidence. You're there to make a case. You're not there to, you know, put everybody into categories of good guys and bad guys. It's not what the process is about. It's not about feelings. Feelings don't matter. It's about information. So you can keep it clinical. And then if you need to turn it up one direction, you can. If you need to turn it the other direction, you can too. Joe Flipperhead, thanks for the coverage, Andrea. Nice to have a distraction from our baseball team. Oh, Joe, what are we going to do? Talk about running it back. Talking about running it back. Thanks for being here with us. Yeah, we just dropped the series to the Mets that we haven't even finished playing yet. What are we going to do about this bullpen, Joe? What are we going to do about this bullpen? I think Ray Romano is Ray Romano. Can't remember his name now. Jordan Romano, not the actor, not the Everybody Loves Raymond guy. Jordan Romano. It was an absolute bust, big bust. He was our acquisition, our big bullpen acquisition in the offseason. Oh, what a nightmare that's been. We struggled with the bullpen for so long. I love me some Kerkering. Okay. I've been from day one, like Kerkering is a future Hall of Famer. That stuff, he's got the wickedest stuff. He's got it's great. He's got great pitches, but he's young. And so he doesn't, have a fully developed strategy and stuff yet. I'm like full in the camp of like from day one, future Hall of Fame pitcher right here. Future Hall of Fame pitcher right here. But he's struggling, man. He's young and they're expecting him to, just instantly be able to handle all these high leverage situations. And you got to develop him. You got to develop him for that. You got to give him some time, but your bullpen is so limited. You don't have other options. Who's the other right-handed high leverage pitcher? We got rid of Hoffman. So we don't really have one. Strom is great. Strom's a lefty. Alvarez is great. Alvarez is a lefty. Plus, we need him to close. He's like the only guy we have to close. We've struggled with this bullpen for so long. We've struggled with the outfield for so long. And it's like for years. Oh, why do you keep running it back? I want answers. Dave Dombrowski, I want answers. Why aren't you doing something in the off season? We better see some fixes by the trade deadline, but we've been saying that for years and we won't. Yeah, sorry for bringing us back to the pain of our baseball team, Joe. But that's just the nature of being a Phillies baseball fan. That's how it goes. They exist to break our hearts, and we keep coming back. Sonia Carballo, thank you, Andrea. You're the best. Or is it Carballo? Thank you, Andrea. You're the best. Improving my English with you since Deptford heard. Sending love to you and the chat from Switzerland. Thank you for joining us all the way from Switzerland. That is a bit of a distance, isn't it? And so you're staying up. I guess not super late if we're getting done by. Well, I mean, if you're sticking with us through the whole thing, it's like what 4:30 over here. We finished yesterday. I was like well after midnight where you are. But just not necessarily having the early mornings, but more of the afternoon session with us. East Coast time and Europe time works a lot better. Man, Chile time was so good for the live streaming. It was so good. 2 hours ahead of the East Coast, 5 hours behind, Europe, UK. I know they're not always the same, like depends on where you are in Europe and stuff, but just a few hours difference. The West Coast over here, always a little bit more of a challenge to deal with, but there's only so many of us. But I appreciate you very much, and I'm glad that we still have some of the old Deptford Herd crew sticking around, coming forward. Yeah, that was such an influential case. It mattered a lot. And one of the big things I think that I thought was so important about that case really was the emphasis on domestic violence and, the survivor community. I think so many folks found that to be very validating for Johnny Depp. For Johnny Depp, like of all people, a famous man, to stand up and talk about it and the cycle and how it worked and how he got sucked in. I think it was very powerful for a lot of people. I think a lot of people saw themselves in that and felt validated and vindicated by that. So it was a trial that meant a lot and continues to influence how we look at a lot of stuff today. Unfortunately, domestic violence very common in the criminal system. So if we're watching cases, a lot of that stuff we learned from Deptford Heard, it's going to continue to carry forward. Barney Rubble, as one of the developers that developed Apple Health algorithms, Hank Richard Cranium is wrong, but I am entertained. Yeah, I'd love to hear more stuff from the developer side. I mean, that's kind of always the issue with the cell phone forensics, right? Especially with Apple, they don't know the code. They don't know the code, so they can't go through and analyze it that way. They have to try to reverse engineer it to figure out how it's working on the Apple end. So the developers can look at it and see this is what we did and this is what we intended it for it to do. But every developer is going to know too. Code doesn't always behave in the predictable way that you expect that it should. You get bugs, you have to have fixes and things like that. It behaves unpredictably. So there's always a little bit, I think, of a mismatch between the input side and the output side, and depending on how you look at that, where you might be in alignment and where you're not. So it's expertise I find very interesting here. We're not going to get developers as witnesses in the trial. But I love the fact that we have folks with your kind of expertise in the chat. And so I love hearing that kind of stuff from you guys. It was great when we had that, we watched that motion in limine about Richard Green and does he have a methodology and what is it and so forth. All these people in the chat, like I'm from a developer, I'm from a forensic community and stuff like that. It just makes for a very vibrant conversation that I really enjoy. Edward Kirkpatrick, Dr. Russell testimony was restricted last time as a sanction for a discovery violation. There should be no restriction this time on her testimony. As long as they have, again, this time redisclosed that she's going to testify about not being consistent with the vehicle strike. I didn't remember, and I'm still not 100% clear because, frankly, Bev often isn't all that clear about what she's talking about or what her basis is. It wasn't all that clear to me if she was saying it was a discovery violation, if this is beyond the scope of what we've established as a foundation for her expertise. Wasn't entirely clear to me. I think that would be, it's a harder sell. She's a forensic pathologist. She saw thousands of vehicle accidents. If we're saying that a non-medical dog bite guy can testify about a dog bite because he's seen thousands of them, then I think we have to give the same benefit to a doctor. But if it was just because she was late to the game and they hadn't disclosed that part of her opinion, then yeah, if they disclosed it this time, you would think they would be able to. So I hope they have. I hope they have. Everage, follow-up question. Do you think the defense is coming so hot because they are afraid ARCCA might be excluded? They are left with the conspiracy. I don't know. It's possible. It's possible. It's risky, I think, if they are, because they haven't prepped the jury for that in their opening. They prepped the jury for this is a bad investigation and this is a powerful town. So, I mean, maybe they can tie those two things together into the Karen Reed was framed. But, it's not crystal clear. They definitely didn't make that crystal clear. It's a conspiracy can be a little bit different than this is a powerful family. And so without a conspiracy, we just naturally have interest in appeasing them. Not getting on their bad side, not being the one to rock the boat. It's a little bit of a different strategy than there is an outright conspiracy to frame her. So if they are making that shift, it's I think a little dangerous to do that. I mean, honestly, yeah, it's possible. I just think they're coming in hot because that's what they do. That's their style. It's how they're used to doing it. And it's what they did the first time. And the path of least resistance, the easiest thing to do, the thing that doesn't take a lot of time that you're not getting paid for, is to rely on your prep that you did last time. Run it back. But it's definitely possible that once it became clear ARCCA might get excluded, they got a little bit more. They got a little bit more punchy. But, I mean, I don't know, guys. That doesn't really explain. I mean, I don't know. Nuttall, I can kind of understand, because you gotta show the confabulation. And they did. I think they were very effective. They were very effective with that. But it's really, it's day 2 when this blew up. They didn't really know anything before then as far as the risk to ARCCA that they didn't already know before they came in and gave their opening statement and started dealing with the witnesses. So maybe, I don't think it's deliberate though. I don't think it's a strategic choice that they're making. I think it's just kind of what they do. It's their default. So that's what they're falling into. It's not something that they've thought about. Does it make sense for me to be real aggressive with these people? It's just how they've learned to do it and what their habit is. Michigan Farm Boy, do juries expect Chekhov's gun car? It was there, so it has to be involved, go off, just as a trope we are used to. Seems like the juror interviews seem to reflect guilty until proven innocent. Yeah, I think that's very much a common assumption. It was mine before I looked into some of the details of the case, before I knew hardly anything about it. All I knew, she was driving. She was she you know, they'd been out drinking. He's found right there. Easiest explanation is that those things are connected. You know, you have this kind of default, like, easy shortcut, like a cognitive shortcut where you think like, oh, well, that's a Occam's razor situation, right? The simplest explanation tends to be the one that's the most true. That's the simplest explanation. That's only the simplest explanation, though, when you're looking at it from the very general, undetailed 10,000-foot view. And once you start looking at the details, it's no longer the simplest explanation, because it doesn't explain the damage to the taillight, doesn't explain the injuries to John, doesn't explain the shady behavior by everybody at 34 Fairview, doesn't explain why Lucky Loughran didn't see him lying in the lawn at that time, doesn't explain the GPS data, doesn't explain the timing. So it's no longer the simplest explanation once you get into the detail. But I think that's a pretty normal default assumption. Yeah. Yeah. If all I know about it is this big picture, it's a reasonable assumption to make. Is that a presumption of guilty? Maybe. I think as long as you have an open mind about it, you know, if you're going to stop at, that seems like the most logical explanation, and close off your ears and like not hear the additional details that call it into question, that would be presuming her guilty for sure. But I think if you know, we're human, you walk into a situation, you think, oh, you know, this is a hypothesis. If you can treat it like a hypothesis that's going to be tested by the evidence, and you are willing to discard it, then I don't necessarily think it's a presumption of guilt. It's just a you know, it's just a interpretation of the facts. It's plausible, but it's not the only one. And so as long as you're open about it, I don't necessarily think it's a presumption of guilt. But that's just the $1 million question. Are they open about it? Because the way that the jurors described it, you know, you keep coming back to that, but that's in spite of the details. You know, if your way of handling all the details, which is kind of how it was described, there's all this conflict in the evidence, and, you know, hard to make sense of it. So then we default to, well, this is probably the simplest explanation. Yeah, I don't necessarily agree with that. Because you're not doing your job of reconciling all of the evidence as a whole. You're putting special emphasis on these 10,000-foot facts that you know, aren't. That's not the reality. It isn't just that simple. It's more complex than that. So if you can't resolve the conflict between the details and your knee jerk, if I look at it generally, that's because your knee jerk looking at it generally, you should have some doubt about that. That's what that means. That's how you should resolve it. So for me, that's kind of how I reconcile those things. I think it's fine as a knee jerk to come in with, even though, yeah, I mean, I guess it is a sort of a presumption of guilt. But it's just an interpretation of the facts. As long as you're saying, you know, the facts could disprove that, I could be open. I don't necessarily have a problem with it. It's if you don't do that, and if you know, resolve the doubts in favor of, well, I'm just going to confirm what I thought before I came in the first place, that's where I see a problem. Deborah, generally, what's needed to recuse a judge? What's needed to recuse a judge who doesn't want to self-recuse is actual bias. That's what's needed. Actual bias, you need to prove an existing actual relationship, improper relationship with somebody involved in the case. You need to prove a financial stake in some way with some person or some outcome that results from this case. That's the kind of thing you need. If the judge doesn't want to voluntarily say, you know, I can see how the standard here, it's an appearance of impropriety. And if I step back and I look at this the way outsiders might look at it, I could see how they might think I'm biased. I could see how they might think I'm not being fair. The judge doesn't want to voluntarily apply that that standard to themselves. Then you have to go to the Court of Appeals and show, remember, we got harmful error, you know, harmless error. The only way you get a reversal on this, the only way it's not just a harmless error, is if they are actually biased. So that's ultimately what you have to show. If they don't want to voluntarily step down, acknowledge their own shortcomings, their own limitations, how other people might see the situation, put yourself in their shoes. You don't want to do that, then they got to show actual bias. And that's why it's such a tough standard to meet. Very, very difficult to meet that from just a pattern of rulings. You get a lot closer with a pattern of behavior, but it usually has to be pretty extreme. It has to be like you're disparaging, you're berating, you're acting abusive towards one of the parties. That's happened. There have been cases like that. Judges will sit up there and abuse the attorneys. But it's rare. And you know, Bev's conduct has not reached that level. I'll have to find one of those cases maybe and share them. There've just been some horrifying ones. Her behavior does not reach that level. So I think they're in a situation where they haven't really documented, like made a record of disparate treatment. They're kind of starting to, and they're kind of trying to, especially Mr. Alessi has really dug into that. He's the one out of all of them who sort of pointed out we need to be applying the same yardstick when we measure everything here. He did it with the now that we no longer have a standard that only medical experts can testify to injury causation, then of course Garrett Wing comes in. He did it there. He did it just the other day when he's pointing out Michael Morrissey has a 30-day override on his own communications. We're the lawyers over here. Why is a different rule being applied to us? He's the one that's really calling that out at this point and sort of making the record like that. But I think if they were going to rely on something like that for, you know, appellate purposes, it needs to be a lot more extensive. They need to kind of be systematically laying out, okay, here's what you did on this date. Here's what you did. Like, go find it in the transcript and cite it. You know, start giving examples. You'd have to do that on appeal. So do the work now. You know, make the record now. That way you've brought it to her attention. And when she says no, you can go to the Court of Appeals about it. So they haven't done anything like that at this point. That's what leads me to think they're not going down this road. They're just going to let it go. They're just going to let it go. Because unless they come up with, I don't know, backdoor burner emails with Morrissey or something like that, that would be bad. Ex parte communications with one of the parties, that would be enough to probably establish some actual bias and get her off the case. But barring that, it's probably not going to happen. So I think they're just letting it go. Lucy Fair. Hi, Andrea. I agree. If every witness is the enemy, then no witness is the enemy. Yeah. Yeah, I mean, I think that's a pretty good way to put it. It just means that this is kind of how you treat everybody, you know, it's sort of what you're left with. If this is normal, this is your default, then kind of everyone's an enemy. And that's not where you want to be on the defense. It's not where you want to be. It's like you're in such a better position when you can appropriate their witnesses to you, you know? We're not unfriendly. There's nothing personal here. You got fact. You don't have facts, then I don't have to take issue with you because they don't matter. You know, if your information doesn't matter, even if it's bad to me, it doesn't matter. It's fine. Go ahead and go about your day. But when stuff does matter and I call it out, yeah, it stands out. It stands out. So you don't have to be my enemy unless there's a really good reason why you need to be. There's a risk. There's a risk to the other side of this. You know, the enemy of my enemy is my friend. If you're like identifying, if you're sitting on the stand, you're identifying with poor Mr. Whitley, firefighter. You're like, this seems like a really nice guy. He's getting picked on by this defense attorney. And now you've got it in your mind. He's the good guy. They're the bad guy. Defense attorney is now your enemy. And the problem is who is the enemy of your enemy? That's now your friend. That's the Commonwealth. That's the Commonwealth. You don't want to give the jury reasons to see you as the enemy. Jana Bell, could John had been involved in undercover work tied to Birchmore case, hence a motive to kill and need for federal involvement? I think this is extremely unlikely just because my understanding of what John's job was at Boston Police Department is not. He wouldn't have involvement in this type of investigation. He was the sex offender registry guy. And so what this means is that when people are convicted of a sex offense, they will have a requirement to come in and notify law enforcement of where they're living. And there will be different registration requirements, but generally it's here's where I'm living. If I'm homeless, you might have to have a different reporting standard. In Washington, you have to come in like every week and tell them here's where I've been sleeping and stuff like that. And then if you change it, you have to go in and tell them. And it's just basically so they can track where you are, make sure that where you're staying is in compliance with any restrictions you might have on staying 1,000 feet away from schools, playgrounds, stuff like that. So the job of the person who runs the registry is typically going to be to follow up on people who fail to register. They have an obligation to come in. They don't. You follow up on it. You charge them for failing to register. You get information that they got a new girlfriend. They're staying over at the girlfriend's house 29 days out of 30 of the month. They haven't come in and changed their registration with you. You follow up on that. You charge them with failure to register. That's really the only investigative kind of work that's typically what those officers are doing in that capacity. So no, the fact that Sandra Birchmore involves allegations that she was groomed and sexually abused as a minor, that's not what he would be involved in, because Matt Farwell wasn't a registered sex offender. It's not about that. It's not about that. None of them, as far as I know, none of them were registered sex offenders, at least at that point in time. So I think this is unlikely. This is not the explanation that I would jump to as a theory. If there were some proof that he was involved in deeper level investigative work, then sure. But this is just given kind of what I know, what we were told of from the last time, what his capacity was, and the whole reason why is because he wanted a more regular job with more regular hours once he took over for the kids. So he specifically moved into this capacity. And that does make sense, because if you're investigating more serious, more violent crimes, you got to kind of give what the investigation needs. Somebody not registering, not the highest priority thing. Chances are you can just follow up on it tomorrow if you ran out of time today. It's not the highest priority. So that's my suspicion based on what we know about the scope of John's work. Deborah, follow-up question: a prior conviction of contempt of court equals bias? No, it doesn't, because it's a finding. This gets a little bit into one of the points I make frequently about the difference between being biased and being informed. Right? There is a difference. She's allowed to consider the records of the people in front of her. And if somebody misbehaves, she's allowed to have them on a leash. If somebody hasn't even misbehaved in front of her, but they have a reputation of misbehaving in other courts, they can do that too. She has the right to do that. It's part of her job of managing the courtroom, making sure things are orderly. She doesn't have to treat every single person as a blank slate. She just has to be, fair. She can't assume something about them because they have a prior history. She can't make a finding that they did it just because they've done this kind of thing before and it sounds like the kind of thing they do. She's always going to have a factual basis to make a finding against them. But if she has already made a finding against them, no, it doesn't make her biased in and of itself. She gets to keep them. She gets to keep them on a leash. She gets to, try to correct the problem. Whether her prior finding of contempt is justified, that's a separate issue. Potentially, appealable. Maybe not. Isn't necessarily affecting the outcome of this case because there wasn't any type of sanction for it. But that's really a separate issue. If she has a pattern of finding them in contempt for bad reasons, unsubstantiated reasons, legally erroneous reasons, now maybe that could go to show bias. It's not that she's ruling against them, it's that she's consistently ruling wrongly against them and penalizing them, based on her misunderstanding. Maybe that would get you there. It'll get you a lot closer than just she rules against us all the time, and when she has discretion, she goes out of her way to exercise it in favor of the Commonwealth. And she shows, lenience and grace to them that she doesn't show to the defense. So no, in and of itself, prior conviction of contempt is not bias. It's just being informed. And she can keep them on a leash because of that. OCD Shaggy, we all love Andrea because she keeps things real. AF. Well, thank you. I do my best. There's no point in being here and being fake or whatever. Just trying to say what I think, share what I think, and sometimes people are going to like it, sometimes people aren't going to like it. That's just life. You really can't spend your time worrying a lot about pleasing everybody because it's never going to happen. It's never going to happen. There's always going to be people that don't like it. So really the best thing to do I found is just do your thing. Be you. If people aren't going to like it, it's just how it is. It's just how it is. We are, a little bit of a shorter day today, but about 5.5 hours in. Oh, we've got another one here from Michelle Bellinger. Bev would have grave concerns with the defense if they had a scheduling issue. She'd force them to continue with Guarino if he was their witness. Yeah, she probably would. She probably would. I think this is a good observation about the double standard. With the defense, accidentally didn't schedule a whole half day full of witnesses, she would be inclined, I would expect, to characterize that as negligent, irresponsible, inconsiderate. The Commonwealth does it. It's just a thing that happens, just a misunderstanding. Yeah. Yeah, I'm still a little bit sort of I don't this game that they're playing with Guarino, bring him in, let him go, bring him in, let him go. He doesn't get crossed at all until they're finally done with him. It might be the very end of the trial when they're finally done with him. I guess maybe the defense is cool with that. And I guess, if we're not going after the Karen Reed is framed defense this time, then shenanigans with the extractions, maybe not necessarily the most important thing. We just want to point at Proctor. Right? Everything Proctor didn't run down. And there's plenty of that in the substance of these extractions. A reasonable investigator would have looked at these phone records. They would have noticed these weird phone calls and these weird texts, and they would have followed up on that, and they would have asked about it. And none of that ever happened. So things like that, yeah, seem like pretty reasonable ones. Michelle, no, we just got it. I think it didn't show up in my queue for some reason, but Jeff had it. Jeff knew about it, so Jeff pulled it up for me. So thank you to Jeff, and thank you, Michelle. Miss Lisa, why are they making a bigger deal about Kerry lying on the stand when it was no big deal when the Alberts and Higgins lied? Well, I think it was. And I mean, we haven't got to that yet. We haven't got to that yet. I think this does speak a little bit to the previous comment about, and just my thoughts in general about how if everybody's an enemy, nobody's an enemy. If your baseline is attack, then it doesn't stand out when you do. This kind of speaks to that because, yeah, I mean, if Alberts and Higgins are our third-party suspects, these are the guys that we think got in the physical fight with John O'Keefe, one or more of them, caused him to fall back, crack his skull, and die, then these are the number one targets for you to attack. These are the ones that it's kind of fine if you make them the enemy. They are the enemy. They're the ones who really did it, not your client. They're the ones who are getting away with it because your client is being prosecuted. So it just speaks to, I think, the benefit of having just more range in your approach so that you can distinguish between, okay, we've attacked Kerry maybe a little bit because she did lie and she's running cover for Jen McCabe. And it sure would be nice. Really would be nice if we knew what Kerry did with that phone. Really would be nice. I'm So I'm disappointed. They're not going to do it. They're not. I think they're just going to let that phone go, and that's the only way. I think that you really, if you're going to make Kerry an enemy, it's because she's part of the cover up, and you haven't proven yet she's part of the cover up. She could just be a useful idiot. If she's just a useful idiot, you can point out she's a useful idiot, but it doesn't necessarily make her an enemy. You can have, pity for that person or whatever. They're just being used. That can be very persuasive with a jury too. You flip it in your direction, You're the one that has sympathy with this person because you know how hard it is. You know what they've, you know that they really believe this stuff. It's just that it's not true. And look at how the Commonwealth is using you to get this out. They know it's not true too, because here's the objective evidence. You can flip that kind of thing to your advantage. But she's not, no matter what, she's not on the same kind of level as Brian Albert and Brian Higgins. Even if, we followed up on the phone and were able to track her in the lie on the phone. If she did not give it to a first responder, if she gave it to Jen McCabe, for example, that's a lie. That's a lie she did intentionally. She did not misremember who she gave the phone to. Or maybe she'll say she did. Maybe she'll say she did. Not so much plausible deniability on that one. Not so much plausible deniability on that one as with I just misunderstood the question, which I can kind of relate to. You catch her in that lie, okay, maybe she's more of an enemy, but she's still not she's not an enemy on the level of these guys. And so you don't want to treat her the same way. You want to show range so that the jury can follow. If I get up and I'm really pissed, that means something. If I get up and I'm mostly nice, but then I have a moment where I get really irritated, they're going to notice that. They're going to notice the differences if you have a little bit more range. Maybe they'll get there. We're still very early in the trial. And in fairness, yes, we have seen some range. Just today, Mr. Yenetti, there was a very distinct range between how he handled cross-examination of Mr. Whitley and how he handled cross-examination of Michael Camerano. That's really exactly the kind of thing I'm talking about. That's range. So he has it. He has it. Now I think it just comes down to strategy in terms of where it gets focused and why. I would prefer to see it tighter. He may disagree. He may have his reasons for disagreeing. We need to be more aggressive with more people. People get to have different opinions about that kind of stuff. So just my perspective. I'm seeing that Christina Rex is telling us that as far as tomorrow goes, it is a half day. There's going to be some testimony during a half day. That's going to be okay. So there's going to be some testimony and then the jury view. So we're going to get presumably just the Dr. Fowler and then the jury is going to go out on their view, and that's going to be everything for tomorrow. So the entire day in court tomorrow is a half day. Monday is just a half day for the jury because they're going to come in the morning to take testimony, but then the afternoon is going to be the voir dire of ARCCA witnesses. So it will not be a half day for us. It will be a half day for the jury. We will continue to stick around and follow what's going on with the ARCCA witnesses. So that will be our schedule. It looks like that we'll be dealing with. Appreciate them clearing that up because it has been confusing about what exactly is going to happen and what are we expecting here. So tomorrow, probably just Dr. Fowler and then done. And then Monday, a long day of both testimony and then voir dire of ARCCA. Deborah, follow-up to the follow-up. If the same judge conviction contempt with dollar and jail time and reschedule trial, be biased at new trial. Thanks for all you do for us. Again, I don't think so. I don't think in and of itself, the finding, even if you penalize them, that's not going to necessarily establish bias. It's part of their powers to do that, to find a party in contempt, to impose a sanction that's appropriate, to try to remedy the harm from it, to try to discourage it from recurring. And then given that it has happened, if it's well-founded, and most of the time it's not going to be challenged, not going to be reversed. If it's well-founded, then for them to be aware of that and to, be alert to the possibility, hey, I sanctioned you so this wouldn't recur, but it might. I got to monitor if my sanction is effective or not. That's not necessarily bias. And so that's kind of what I'm saying, right? Because she clearly has a bad opinion of the lawyers, the defense lawyers. And so she treats them differently. She has different standards. She is allowed to rely on their misconduct, reasons why she maybe has needed to correct them in the past to justify keeping them on a shorter leash. The problem, as I see it, is that the disparity in her attitude, it precedes any of that. There wasn't any kind of problem, any kind of accusation, any kind of wrongdoing, certainly no finding of wrongdoing before she started treating people differently. She gave all this lenience to the Commonwealth before the first trial with respect to their trickling in discovery, late discovery, etc., their misrepresentations about, have you even talked to the lab? Oh yeah, you said you talked to the lab, but now we have your communications, and you hadn't talked to the lab when you said you had. No grave concern about any of that. So that was kind of the standard for what would be fair and even-handed for both parties if we're treating them equally, because nobody's been found to have done anything wrong. It happened later. And my perspective, it seems to be related to the press stuff. She doesn't like that they've talked to the press. She doesn't like that they've made these statements. Was willing to go out there and say she didn't like that Mr. Morrissey did it either, but not enough to disqualify his entire office, just him personally. Not enough to disqualify his entire office. And so the problem is that the discrepancies aren't like she was treating them fairly until they had the ARCCA motions, and the defense made statements that they hadn't paid ARCCA when in fact they had paid ARCCA, but they hadn't paid ARCCA for what the motion was about, which is the substance of their, testing and experimentation and opinions. They had paid them to show up and testify for their time. But they did maybe lean into that a little bit too hard. They did pay ARCCA, and they said they didn't pay ARCCA. If the discrepancies had just emerged after that, and if the discrepancies seem to be related to that, I'm treating you differently because it's harder for me to trust you because I've found that you violated your duty of candor, I would understand it and it would make sense, but that's not what happened. That's not the timeline of what we're dealing with. The discrepancies very, very much preceded that finding. That's part of the whole problem. So that's kind of where I see the distinction between, you're allowed to be informed about problems with the people in front of you and engage in corrective type of actions. It's part of your responsibility as a judge. But that's different from treating them differently from the outset, having different standards that you apply to them from the outset, being very eager to the point of citing guidelines that don't apply in your jurisdiction as a basis for wrongdoing of this one side, like really looking for wrongdoing on this one side, while on the other side, they're straight out telling you all of this stuff that they're doing wrong, not producing video evidence, et cetera, et cetera. Here's the 140-page PowerPoint the day I plan to introduce it, the night before. The night before I plan to introduce it. And that's fine. That's different. That's different. That's just not being fair. And it's not being fair for reasons that are separate from, you could be justified in not being fair because of this particular act, this particular finding that you made. That's just not being fair, broad swath. Michelle Bellinger, you're the best. And thank you, Jeff. Yes, thank you, Jeff. Appreciate you, Michelle. We're going to do our best to find everybody's. It is important to me, I continue to just be, very, very flattered that people care about my take, my opinion. I'm me. I'm just a person. I don't see myself as having any particularly special view, and so it continues to kind of overwhelm me that wow, there's all these people watching, and this channel has grown and stuff like that, and I'm very grateful for it. So I do appreciate your support. I do my best to acknowledge. People want to pay their money for me to see their comment, then I'm going to see your comment like that. It means a lot to me. So thank you for that. Olivia Rose, can the defense do anything if Bev tells them to speed it up? We need to move along when it's their turn to present their case. They can make their record. She's got, some ability to be able to control the timeline of the trial, the length of the trial, the efficiency of it, and so forth. But she cannot be arbitrary. She doesn't get to say, for example, defense, you're going to be done Friday. She doesn't get to just make that up out of the blue and be like, that's the amount of time that you have to present your defense. If they don't have notice of it, if there haven't been some kind of reasonable restrictions on the prosecution's case as well, she doesn't get to cut them off. That implicates their right to present a defense. They have a right to present a defense. And if it takes time to present the defense, it takes time. And she just has to deal with that. So she can put some kind of reasonable restrictions on it, but she can't put arbitrary restrictions on it. So that's kind of the limitation. This whole move it along is really an issue of, from my perspective, she doesn't like his style. And I kind of understand. I did, honestly, with Mr. Whitley this morning. I kind of agreed with her. Kind of like, yeah, it's not necessary, and it's not beneficial. It's not getting anywhere. You're just going in a circle because you want him to say it a specific way. He doesn't have to say it a specific way. That's not the rules. He gets to say it how he wants. And the fact that, more than once, he's already given you the important part. And you have to take it further now and try to characterize, and you cause a whole other fight about that, when it was perfectly fine, as soon as he said, yes, my stories were different. That's all you needed. Yes, my stories were different. Argue about what that means with the jury. You don't argue about what that means with the witness. So that's why I think she's telling him move along. She doesn't like his style. She finds his style argumentative and ultimately unproductive. And in that instance, honestly, yeah, I tended to agree with her. I kind of think it was too. It was just the fight for the sake of the fight. There wasn't anything meaningful, I thought, gained from it. I will entertain position to the contrary. Why was that meaningful? What did we get out of that was important? I would hear an opinion to the contrary. But my independent view, how I look at that from my perspective, kind of agreed with Bev on that one. Sort of justified to move it along. So with that type of thing, she doesn't think that the testimony is helpful. She thinks the testimony is becoming argumentative. She gets to cut that off. That's fair. She doesn't get to say you have a fixed limit, fixed amount of time. You have to get your case done within that time period, regardless of, reasonably how long it would take for you to present it. She doesn't get to do that. In part because a lot of that's out of the defense's control. They don't control how long cross happens. And so that's an advantage that, if they could game the trial like that, that's how you would game it. Oh, they have 5 days to put on their case, then I'm going to spend a day and a half cross-examining their first witness. Ha ha ha. In Depth v. Heard, we saw them do the time allocation, and they made it complicated to get around that possibility of gamesmanship. She kept track minute by minute of both the direct and the cross, and they both had the same amount of time, and however they wanted to allocate that between their own case and their cross was entirely up to them. That's a lot to track. Most places aren't going to do that. Most places aren't going to do that. It's far more common to just, let the trial go. The trial kind of has to go as long as it needs to go. And if it looks like it's going over long, or it's, getting to a point where it's not being useful, you might caution the lawyers. You might scold them. It's getting to the point where witnesses, Mr. Lally, are getting repetitive and unnecessary. Perhaps we could have saved a week if you hadn't called 5 separate people to talk about shoveling the apron at the Canton Fire Department. Sometimes you might do something like that. But so if she did do something like that, arbitrary, you need to finish, they would just make their record of this is what we need to do. And that's why we're not going to finish within the time that you want us to finish it. It's going to take the time that it takes, and we have the right to do that. Edward Kirkpatrick, it's also the disparity on ARCCA versus Sallyport video that is still showing up 3 years later. Commonwealth got a pass in the motion to dismiss. Yeah, they did. Yeah, they did. And, that was, we're in a different context, right? We're in a different context because the motion to dismiss was a post-trial motion. So it's already after the harm of the late produced video coming in and the defense having to adjust. And so she has that out of, well, the right remedy is just a retrial, and she's already getting that. If they had asked for a different sanction, I do wonder if they'd get it. If they hadn't gone in and asked for dismissal, because dismissal is, that is a strong remedy. Granted, egregious government misconduct will warrant it. There's an awful lot of smoke around the egregious government misconduct in this case. But I do wonder if they had come in and asked for something different. It's just, what would that be? Kick Lally off the case? Okay, he's sitting there like a lump anyway. Oh, he told us yesterday there was a moot scheduling issue. We had actual words from Adam Lally for the first time in months, as far as I can tell, other than like the couple of occasions he got to say, "Hi, jurors, I'm Adam Lally," before Mr. Brennan just introduced him for him. He's already out. That's not really a remedy. So they're in a position where, because of how things panned out, they aren't really on equal footing because they're not in the same setting, right? They could have asked for all that late Sally Port video to be excluded because it was late produced. I don't believe that they did. I think especially once they figured out, gosh, this one is inverted. They liked that. They liked that. They wanted that in. They wanted to be able to use that because it supported their Karen Reed is framed theory. If they had known or suspected, I guess, the Sally Port video is trickling in, we don't even know what's there. Maybe you could move to exclude any Sally Port video unless and until you have it all, because of it being late and you not having the ability to put it into context. I think the issue is just that by and large, the defense pretty much found the Sally Port video helpful. That was the whole point. That's why they wanted it, right? That's why they wanted it. They figured this is going to help their case. If you think you're guilty, are you going to run it down like this? If you think it's going to make you look bad, are you going to run it down like this? I don't think so. They thought from the outset, if we can get the video evidence, it's going to help with our case. So once they did get it, yeah, I think they naturally are going to think this is helpful. So they're not going to move to exclude it. They're going to use it. It's a different posture. So, I mean, yes, these are disparities. With the remedy, that's why. There's also a disparity in positioning. I just find it more, I find it most vivid in the tone. I find it most vivid in the tone. Gravely concerned about the defense and not a single concern. Not a single concern about the Commonwealth. Not even a caution. Better not do that again or there's going to be a problem. Not even that. That's what stands out to me. Anthony Wildman with a super chat. Thank you so much, sir. Appreciate you being here with us today. Joining the chat. Edward Kirkpatrick. I mean, in the first trial, an inverted video and late discovery was allowed in with not a peep from her and no sanction, no dress down. Well, yeah, I agree. I'm trying to remember back, though, if the defense ever moved for it to be excluded. And I don't think they did. I think they just brought it up as like, this is late and we need time to be able to review it. We need time to be able to evaluate it, whatever. But I don't think they asked to exclude it. I can go back and double check. If I'm wrong about that, let me know. Let me know in the chat. But I don't think they did. And so she's not going to do it if it's not a request that they made. So that would be why there's a disparity in sanctions. The one you asked for versus the one you didn't, they will get treated differently. But it doesn't explain the difference in why are we gravely concerned about the defense saying they didn't pay ARCCA when that is partial. It's directionally true, just maybe not absolutely true in an absolute sense. Just more true to the context of what's under discussion. Gravely concerned about that, but no grave concern about the million stories we've gotten about the Sally Port video and who has it and when and where did it come from and when did it start getting overwritten and how did you have all this other stuff and what storage medium was it on and will there be metadata or not? Not a single concern about any of that. Discovery sanction because you didn't keep your text messages with ARCCA? But no discovery sanction when they didn't keep the metadata for the Sally Port video? That's what I don't understand. And that's where I think it's a little bit of a problem. Edward Kirkpatrick, hidden in sidebar, kind of like the jury objection. That could be. That could be. If stuff happened in sidebar, we don't know. And that's all been impounded, and we may never know. So that is possible if they asked for it in sidebar, and we just didn't see that litigated. If that is the case, yeah, then that's yet another concerning discrepancy. That the Commonwealth can turn stuff over late and not have any consequences for it. And, with the defense, we're going to potentially cut off their ability to counter the Commonwealth's case. When the defense has a much better explanation for their lateness than the Commonwealth does. Commonwealth, by their own explanation, would have had to have had that Sally Port video all downloaded, all of it, by the end of February, very beginning of March of 2022, and never turned it over. If it's on a 30-day overwrite, and that's why it's no longer available. So they would have had it for 2 years before the case went to trial. And their explanation, Trooper Proctor had it in a file. Trooper Proctor is part of the Commonwealth team. And Mr. Lally signed a certificate of compliance indicating he'd complied with discovery, he'd made all the reasonable inquiries that were necessary. And yet it turned out that that was not true. There is this other evidence out there that is responsive. Yeah. Uncivil law. Would love to talk to Karen Reed sometime. Yeah, that would be interesting, wouldn't it? I'm not, as you know, and we talked about yesterday, I'm really not an interview channel. I've never gone down that road. It sounds like a lot. It sounds a lot more like a job, which is really what I don't want this to be. I don't want this to be a job because then I'll start to not like it. And if I start to not like it, I won't want to do it. And there'll be so many other things that I'll feel like doing instead. I want to keep this fun. And what I really like is watching trials and talking about them, talking to you guys about what we see, what we think. But I would like to see you, Kurt, talk to Karen Reed sometime. I think that would be very interesting. I'd love to know. I'd love to know her thought process behind the interviews. I'd really love to know the stuff that you can't ask, the relationship with the attorneys. That's what I'm interested in. I'd like to know. What's it like? What's it like being Alan Jackson's client? What's it like being what's it like having him as your attorney? How do those things relate to each other? I think that would be very interesting. But you can't ask that. That's privileged stuff. I would never. I would never. I'm not going to be like some journalist trying to elicit as much as I could, just for the sake of having a story. I would respect that. It's not in this person's best interest to answer that question. But I'd love to get her perspective on so much of this. What's her take on Bev? What's her take on all this? So many things I'd love to know. How does she feel about just how all of this is unfolded, being in the public eye, which she never asked for, just happened. And now she's being accused of being fame hungry and stuff like that. She's far as I can tell, never sought the limelight in her entire life until she got thrust into it, not of her own free will. I'd definitely love to know what she thinks about that and just kind of how she's coped with it. What's that been like for her? It's very hard for women, I think, be under that kind of scrutiny. I'm not saying that it isn't for men, but I just think it's different. And women get scrutinized a little differently than men do. So what that's been like for her. I think that would be a good conversation, Kurt. You should go for it. Send out the invite. Hospice Jess, since I left, came back, and you're still here. Quick questions about the brains and artists behind your thumbnail nails. I love them. Well, thank you very much. I do them. I enjoy doing the thumbnails. I set it up to have the kind of blaze, like my thumbnails. It has the blaze like in the middle to kind of give you that divide of the sides, and that's part to just sort of make it stand out a little bit. I color theme the blaze a little bit, depending on like what the case is, what the topic is. I don't remember having a specific justification for the color theme for the Karen Reed blaze, but for example, the Delphi was the purple and teal. Those were the favorite colors of Abby and Libby, so that was the purple and teal. Over in the Brian Koberger, I've got the yellow. I don't want to say what the colors are because I'll get them wrong, but it's the University of Idaho colors. The what's their mascot? The Vandals colors. So just things like that I pick out for the blaze. And then I go through and I find images, from the trial, from events of the trial, and I play with them. I like to play with, color overlays and brightness, contrast, kind of your typical image adjustment stuff, and just try to make them interesting. I've kind of now sidelined a little bit because you can also do this for Substack, where you can make an image that shows up when somebody's like looking through your feed. There'll be an image associated with the article, but it's a little different from the thumbnail, and it's different format and stuff. So what I've been playing on with that is overlaying images on top of each other. And then to, just try to get a sort of feeling out of these images coming together, and the relationship between them. And then, again, playing with the colors and contrasts and stuff like that. So I do them. Glad you like them. Appreciate that. It's nice to hear. That's just sort of what I do. It's a little bit of an artistic outlet in a very small way. Outside the box, which of Karen's attorneys is your favorite and why? Well, this is a hard one for me because I'm leaning heavily towards Mr. Alessi at this point, but I haven't seen him in action in trial yet. So how can I say that? How can I say that? I can't really say I like him best yet because I haven't seen the full measure of what he brings. But from what I've seen in the pre-trial, I just really like the way he thinks. I probably like him because I feel like he thinks like me. I feel like I relate to him in that way. He seems very logical. He seems very systematic. I'm an outliner. He seems like an outliner, So in that sense, I feel like I can probably relate to him the best. And obviously, I'm not saying I'm the best lawyer out there, therefore anybody that doesn't like me is great. No, it's just natural that, you tend to gravitate towards similarities and people like you and stuff like that. So I tend to like Mr. Alessi. I like his briefing. He can be a little bit long-winded. But here I am at 6 hours and 13 minutes. Can't really throw that stone, can I? But I need to see how he performs in trial before I really make that final decision, because it's possible he could be really bad in front of a jury. It's possible. Questioning witnesses is a very different thing than making arguments to a court. And my understanding of Mr. Alessi's background, he doesn't seem to have a criminal background. He's in civil. And it's not even clear to me he's really in civil litigation. Now, he's got argument experience. He's argued to courts. He's done litigation before. But I'm just not entirely sure that like that's really his focus of what he does. He's in the energy section at DLA Piper. And I noticed that in part because Piper is in Chile. They have a Santiago office, and energy is like energy mining are big resources in Chile. So I did have that thought cross my mind. I wonder if Robert Alessi has been to Chile. I'd love to talk to him about it. If he has, just find that out. But he's an energy attorney. Probably a lot of what he's doing is transactional. You might be doing like some regulatory compliance and things like that too, I would expect, and certainly some litigation. But I would just expect a lot of that to be transactional. So I could be wrong. But, you know, being in a criminal trial, doing criminal trial cross-examinations and stuff like that, it's a different arena. It's different. And so it's possible he could suck at it. I don't think he will. I have a lot of faith in him. I think he's going to be good, but I don't want to make that final call until I see him and I can evaluate it. If we take him out of the running, out of the picture, I like David Yenetti. I do like David Yenetti. I would tend to say he's probably my favorite. He does have good range. I don't always, like his approach. He can be a little bit overly combative for me. But he's very direct, and I think that's what I like. That's what I like about him. He's very direct. When he came up and gave that opening statement, Karen Reed was framed. He just said it, man. He just said it the way he sees it. He didn't try to soften it. He didn't try to pretty it up. He didn't try to make it, make it like the airplane for the jury to swallow. He just put it right there front and center. And I appreciate directness. I liked that. I respected that. And he's the local guy. I kind of like that too. Obviously not necessarily local to Canton, but local to Massachusetts. So he's a Massachusetts guy. He gets the culture. He's gonna understand, that type of perspective on what are the jurors going to expect in terms of demeanor and attitude and combativeness and stuff like that. He knows that for his neighborhood way better than I do. He's on his home turf, so I have to give him credit for that. But I find him very likable. I find him very likable, very easy to trust, very easy to follow. Don't always like every single thing he does. Don't always think everything that he does is effective, but by and large, yeah, I have the impression he's a very, very good attorney. So if we take Mr. Alessi out of the running, that's my answer. My answer is David Yenetti. 6 hours and 17 minutes, guys. Not too bad. Not too bad. We're just hitting the noon hour here here over on the West Coast. So looks like it's going to be time to go ahead and wrap it up. And my gosh, I'm going to get a whole afternoon. My yard is going to be so thankful. It's a little bit behind. I need to mow. The world is changing around me, guys. The world is really changing around me. I've really had some kind of revelations over the past couple weeks. It's nothing like brand new, but just things have hit me a little bit differently than they've hit me in the past. And it's just this sense of where we're at as a country and a civilization when it comes to being able to build, being able to grow, make new things, and unusual for me. So I'm a very generally a very optimistic person, but just a lot has landed lately that's like, man, it's really hard to build here. Part of that is the contrast. Because I got to spend all that time down in South America. I got to see a way, here's how they do things in Chile. Chile, you want to build a farm, you got the land, you can go out, build your shack, you can put up a cistern, run your plumbing from the cistern, and you're going to be fine. It's okay. Here in Washington, I'm trying to get my irrigation going because I'm in a very, very arid climate. And we're in an irrigation district, so there's a water supply, but it's late coming on every single year. It's not on yet. My irrigation water is not on yet. And I like to grow things. I'd like to grow more things. I could imagine a world where I would want to commercialize my garden, you know, be a small scale farmer, sell eggs, sell lettuce, sell fruit. I could see being into that. But you have to build that. You have to have the infrastructure for it, and you need water. And you need water when you need it, not just whenever the government feels like, getting around to deliver it. So I've been going through this whole big hassle of trying to set up my irrigation where I can have the city water run it. And the absolute nightmare that's involved in trying to pass the permitting and the inspection, and you can do it this way and you can't do it that way. Like, God, they make it so hard. Like, you could just put backflow prevention on it. I'm not going to be drinking the irrigation water. Even if I did, is it going to kill me? Probably not. If it's going to kill me if I drink it, it probably shouldn't be out here in the pipes going through the sprinklers. But all this, making it difficult to build, and it's for our own good, right? It's protecting me from myself because I might endanger myself if I run city water into my irrigation system before, the beginning of May when the irrigation district decides to get around to getting it to me. That means I can't invest in a commercial orchard if I were so inclined. I can't invest in, putting in more apricot trees or something like that. I love apricots. It's my favorite thing. It's one of the easiest things to grow, except for the fact that we're in a very marginal climate here. We will get late freezes. Apricot comes out very early. The fruit sets very early. And so we get a late freeze. I got to do frost protection. And if I'm doing frost protection, I need freaking water. I need water. And I don't have it. So how can I build an orchard here when I don't have a way to guarantee water? It's just been hitting me a little bit harder. Then the other thing that happened, the way the world is changing, the way this has hit me lately, things don't get fixed really anymore. We've been in this long kind of path of being more of a throwaway culture. Something breaks, just throw it away and get a new one, because we have so much abundance and things are so cheap. People don't fix things really anymore. And so where this hit home is the reason why my yard is like super behind. I had to fix my lawnmower. Of course, every year, every spring, you go through this whole song and dance of getting the lawnmower started. Yeah, it's fine. It is what it is. You got, I get it. You got to service it and stuff. It's set all winter. That's fine. But there were things I had to fix. Specifically, there was a pulley, a driver pulley. It's not the first time it's happened. Sometimes you like hit a stump or hit a rock or whatever. You hit things a little bit wrong, and it knocks that off. And just the way this particular mower is built, that's kind of a weak point. So I've had to replace this pulley before. I bought this lawnmower from a shop in town. They did service and everything on it. It was working great. Last time I had to fix it, just ran down to the shop. They had the part, get the part, bring it home. It's up and running the same afternoon. Unfortunately, that shop is now closed. I can't afford to have a service shop, that type of equipment dealer anymore. So it's closed. So I go looking up Where's the next closest one? Like part of me is thinking, you know, what if something else goes out on this mower that's like more than I can deal with? Certain things I don't deal with electrical. Like I'm not going to fix an electrical problem. If somebody else can fix it, that's fine. I'm not going to do it. It's just, it's a nightmare from my standpoint. I don't have like a lift to be able to, you know, I'd have to like jack this mower up, get it in weird positions and stuff. There are certain things I needed to do to it. What if like the steering goes out? Like it's just things that I'm not necessarily going to deal with. Where would I take it? Where even is a service department? So I go looking up and I find one. Okay, there's one in Hermiston. Hermiston's about an hour drive from here, maybe a little bit less, 45 minutes. It's across the Columbia River over in Oregon. So I'm like, all right, I'll go over to this. Google says it's a dealer, it's an equipment dealer, and they have a service shop and they deal in this particular, you know, brand of equipment. So I drive to Hermiston and find, no, this dealer has also gone out of business. There is still, however, a small shop there. A man who is 75 years old, he tells me, has basically like, he's just kind of camped up where the service office for this dealer used to be, and he's doing repairs himself, like mostly small, you know, small engine repairs and stuff. He had my part. Thankfully, I was able to get my part. It was not as easy as just driving down the store to the service shop and getting it, but I was able to get it. But I just, you know, had a recognition that's not going to last either. That guy's going to be gone. He's 75 years old, and no, he was going to come take it over from him. Is some young person going to come take that over? I really doubt it. So that shop is going to be on the way out. It's not making him any money anyway. He's doing it to keep busy because he enjoys doing it. He's one of these guys that likes fixing things. So it's going to be gone. And now where are we at? If my steering goes out, I probably have to buy a new mower. You know, because I'm not going to have, it's going to be beyond my ability, and the fixing culture is gone. There's I don't know where I would find somebody to fix it. I don't know where I would find somebody who would get the parts to be able to fix it. Little things, okay, maybe I can get the part from Amazon or eBay or something. Maybe it's going to take a few days. It's just a different culture now, you know, more of a throwaway culture. So anyway, I got behind because I had to fix my mower, and it took me a lot longer than I expected it to because we don't have a fixing culture anymore. So that's what I got going on for the afternoon. Is now it is fixed. It's working great, which is, you know, it's a great feeling. That's the thing. I love fixing stuff. You get such a good feeling from it. You just feel like so useful. It's such a meaningful thing to have accomplished. You've taken something from a broken state and now it works. Now it has a function. Now it's helpful. It's wonderful. It's wonderful to fix things. And so it's kind of a shame, you know, for that to be on the way out as a thing to value. But I have the feeling that it is. So I'm going to go enjoy the fruits of my my efforts at fixing my lawnmower. I'm going to go there and feel like a small demigod. I accomplished the fix of this mower. Now my blades all turn in unison. They're all at the same length. They work. They're not rattling around. They're going to come loose. Jana Bell had a last minute super chat here. Could John have, oh no, we already saw this one. Sorry. We already saw that one. Sorry, Jana. I think that was unlikely. So yeah, hope it's a beautiful day where you guys are. Got that little bit of an early finish. And oh wait, no, it did come up new. Yeah, Jana, I don't know if maybe you missed this before. No, it's still from 1106. I think it just got restarted for some reason. Could John have been involved in undercover work? I don't think so. Talked about it. That's not what sex offender registry officers tend to do. And it doesn't sound like that's consistent with the type of work he was doing because he chose to have more regular hours. More of an office-based kind of job, less of a field-based kind of job once he got the kids. So with that, We have a beautiful afternoon here. I hope you have a beautiful afternoon where you are and a chance to go out and enjoy some of it. And get up, get moving around, enjoy this beautiful biological container that you have, what it can do, let it do what it's made to do, move around, enjoy stuff, have sensual experiences. It's what we're made for. It's what we're built for. And, feed that spirit while you're at it. If fixing things feeds your spirit, makes you feel good, you've accomplished something, do that. If reading a book, if getting online and catching up on everybody else's thoughts, everybody else's takeaway from what happened in the trial, if that feeds your spirit, do that. Find what works for you, but do get out and do what you need to do to make the best out of this afternoon. My Mini 67, Andrea, use Aspen Fuel and watch Chickenick. I will check out Chickenick. I don't know Aspen Fuel. I'll have to check that out. We'll assume it's a specific kind. We just, it's a regular gas mower. Well, I'll see what that is. I'll look it up. Even make a little note here. I'll put it right at the top of my day 3 notes. Aspen Fuel Chickenick. Thank you for that. Susan E. Generous, thank you so much for your commentary. Well, thank you so much for your chat and for your encouragement, Sue. Sometimes I wonder if there's value in what I'm saying, and maybe there is, maybe there isn't. But as long as some people are getting something out of it, then I feel like it's worth doing. So I appreciate knowing that. Guys, take care of yourselves. Look out for yourselves. This is very much a put your own oxygen mask on first type of message. Because I think a lot of people that gravitate here, we're helper type of people, we're empathetic type of people. We're here because we want to see justice done. That's why we're interested in these trials in the first place. But it can be a little bit consuming. So it's very, very important to take care of yourselves and make sure that you're getting what you need. E. Cola T, you're so inspiring, Andrea. I want to be like Andrea when I grow up. It's very kind of you. I really appreciate that. Again, I'm just a person sharing what's worked for me, and if that helps anybody out there, then it's worth it. It's worth it, and I appreciate that. So take care of you guys first. A lot of what's out there, what's happening, it's not in our control, but there are things that are in our control that we can look after. And a lot of that is our own well-being. So with that, guys, go enjoy your afternoon. I'm going to be off enjoying my yard, enjoying some sunshine. Maybe one day soon, enjoying some irrigation water getting turned on. Walk my dog, enjoying the new chickens, all that stuff, guys. So thank you for joining me again today. It's going to be a short day tomorrow, but still an early one. But we'll see what we have from Dr. Fowler, and maybe our first cross-examination from Mr. Alessi. I will be looking forward to that. See you guys tomorrow.